ಬರೋದಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಚೇಂಜ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಅದನ್ನ ಕೇಳಕ್ಕೆ ಹೋಗಲ್ಲ. ಏನು ತೊಂದರೆ ಆಗಲ್ಲ, ನೀವು 10 ಗಂಟೆಗೆ ತೊಂದರೆ ಇಲ್ಲ. ಬೆಳಗ್ಗೆ 10:30 ಈಸ್ಟ್ ಆಗುತ್ತಲ್ಲ, ಇಲ್ಲಿ 10:30 ಶುರು ಅಲ್ಲ, ನೀವು ಮುಗಿಸ್ಕೊಂಡು ಅಂತ ಹೋಗಿ ಈಗ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಆರ್ಡರ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಮಾಡಕ್ಕೆ ಬರೋದಿಲ್ಲ. ನೀವು ಇವನಿಂಗ್ ಹೇಳ್ಬೇಕು, ನಿನ್ನೆ ಸಿದ್ಧಾರ್ಥ ಇನ್ನೊಬ್ರು ಏನೋ ಚೇಂಜ್ ಆಗ್ತಾರೆ, ಅಪ್ಲೋಡ್ ಮಾಡ್ಬಿಡ್ತಾರಲ್ಲ, ಕರೆಕ್ಷನ್ಸ್ ಬಿಫೋರ್ ಸೈನಿಂಗ್ ನೀವು ಏನ್ ಬೇಕಾ ಚೇಂಜ್ ಮಾಡಿ ಹೇಳಿ ಮಾಡಿಸ್ಕೋಬಹುದು. ಆಮೇಲೆ ಬರಲ್ಲ ಯಾರು.
ಅದನ್ನ ಹೇಳಿ ಇವತ್ತು ಕೊಡಿ ಸರ್, ಡೇಟ್ ಆ ಕಡೆ ಈ ಕಡೆ ಮಾಡ್ತಾರೆ. ತೊಂದರೆ ನಿನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ದೆ ಅಂತ ಹೇಳಿ. ಹಳೇದೆಲ್ಲ ಮೆನ್ಷನ್, ಫ್ರೆಶ್ ಫಸ್ಟ್ ಟೈಮ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಬರುವಂತದ್ದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಆಗಿರೋದು ಮಾತ್ರ. ಯಾವ್ದ್ರ ಬೇಡ. ದೇಶ್ ಯಾರು ಮಗು ಎತ್ಕೊಂಡು ಇಲ್ಲೇ ಕುತ್ಕೊಂಡಿದ್ದಾರೆ, ಆ ಕಡೆ ಕುಂಡಿಸ್ಬಿಡಿ. ಅವ್ರು ಪಕ್ಕದಲ್ಲೇ ಈ ಸೀಟ್ ಹಾಕಿದಾರಲ್ಲ, ಅಲ್ಲಿ ಕುತ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸ್ವಲ್ಪ ಆ ಕಡೆ ಕುತ್ಕೊಳ್ಳಿ. ಆಫೀಸ್ ಕಂಪ್ಲೇಂಟ್ಸ್ಗೆ ನಾವು ಇಲ್ಲೇ ರೆಕಾರ್ಡ್ ಕೊಡ್ತೀವಿ, ಎಂಟೈರ್ ರೆಕಾರ್ಡ್ ಕೊಡ್ತೀವಿ ಅವ್ರಿಗೆ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ರೆಕಾರ್ಡ್ ಅಂತ ಆ ಕಡೆಯಿಂದ ಬಂದು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂತಾರೆ. ಅವ್ರಿಗೆ ಹೇಳಿ ಆನಂದ್ ಅಂತ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಸ್ಕೂಟ್ನಿ ಅವ್ರು ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ ರಿಟರ್ನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿ ರೀಸ್ಕೂಟ್ನಿ ಮಾಡಿ ತಂದ್ಕೊಡ್ತೀವಿ. ಅದೊಂದು ನೀವು ಹೇಳ್ಬೇಕು ಅವ್ರಿಗೆ. ನಾವು ಫುಲ್ ಎಂಟೈರ್ ಫೈಲ್ ಪಾಸ್ ಓವರ್ ಆದವು ಮಾತ್ರ.
One memo for
recruitment notification is under challenge. The respondent university is issuing appointment letters to the point. Interim order is yet to be considered.
Fresh matter or
is a B group.
B group.
Next week ಅಲ್ಲಿ ಯಾವುದು ಸರ್?
Yes, 18 2000 September yes 9th. Yes my lord, memo for posting for B group my lord. This is compensatory ground appointment.
ಕೊಡಿ ಅಲ್ಲೇ ಕೊಡಿ.
Compensatory ground appointment my lord. 25th second ಅಲ್ಲ 25th tomorrow 20.
ಯಾಕೆ ಹಾಕಿಲ್ಲ? We verify that if there is any office objection.
Fresh my lord. 25th fresh matter ಆದ್ರೆ tomorrow my lord. One submit 25th my lord. Compensatory ground
Compassionate appointment 25th ಅಲ್ಲ ರಜರಿ 25th 26th 27th ಅಲ್ಲ ಅದಕ್ಕೆ 1ನೇ ತಾರೀಕು
ಆಯ್ತು.
First hearing
1ನೇ ತಾರೀಕು.
petitioner is 72 years old.
Yes
Readings are complete.
28th 28.
28, 28.
For early in 5.
Hmm.
Group preliminary and group B.
Yes, second. Yes.
Petitioner age is 70 years, my lord. Pension of benefit not.
Pensionary benefit 30th.
Lord,
30th, submit. 30th.
service from 1/1/2008 to 1/1/2018
Hmm.
for a last period of 10 years has not been considered.
Hmm.
Now, my lord, service benefit has to be paid to the service.
Yes, second. Yes.
My lord, the petitioner dismissed from service. 1 year, sir. Only 1 year. Only 1 year due to service, my lord.
Yes. Third. Yes.
3rd September.
Hmm. Representation. Yes, 28.
28.
Lord, appointment to the post of dean, Lord, is pending consideration. Notice is already ordered. And B group, Lord, may I request, but next week, any day.
28. Disposed. What is that restoration? Hmm. Yes, 12th. September 12th.
September. September.
Interim order is not complied, you file in a contempt. Which is that procedure? Huh?
12th
Yes.
September.
4th.
One point of regularization, Maharaj, from 88, they are working in the
Regularization?
D group employees.
Second, yes.
Second.
Some,
Trust matter. Old matter. Yes, 4th, yes.
4th September.
Vacating a year. 28, yes.
ಹಾಗಾಗಿ ಅರ್ಜೆಂಟ್ ಇದೆ tomorrow.
Second, yes.
2nd September.
RFA. RFA 29, yes.
29.
Pending.
Enter list.
Yes, please.
Any adjournments, sir? List number 1, any adjournments?
My lord, serial number 41, my lord. And for the petitioner, my lord, I pray for short accommodation, my lord. Senior is out of station.
41.
Mic use ಮಾಡಿ madam, mic use.
Yes, you are appearing for
Petitioner, my lord.
the request of counsel for the petitioner. Leave this matter next.
ಲಾರ್ಡ್ ಅವ್ರ ಕೇಸ್ ಎತ್ತಿಗೆ ಹೋಗ್ಬೇಕು ಸ್ವಾಮಿ.
8, my lord, I am respondent. I informed to the other side.
8. Yes, sir. The request of counsel for the respondent. Leave this matter next week.
My lord, serial number 68, my lord. In this case, I am appearing for the petitioner. We have informed the respondent counsel short accommodation.
Which one?
68.
68.
68. We have informed the respondent counsel, my lord. You shall make kindly give the date, any date, my lord, next
The
week.
request of counsel for the petitioner. Leave this matter next week.
Next week, stay may be extended till then, my lord. Date may be given.
Interim order granted earlier is extended till next date of it.
Date may be given.
Date, yes, 3rd September. Yes.
18,
Bharat.
18,
3rd September.
3rd September.
3rd September, please, please.
But serial number 60, my lords.
16.
60, my lords. We are appearing for respondent number 2, my lords. We have to take instructions in that matter, my lords.
Have you informed the other side?
We will inform, my lords.
First inform, then mention. Yes.
Serial number 51, my lords, for the petitioner.
Serial number?
51. 51.1 also, my lords.
Private respondents in this matter, my lord, there is some urgency.
My lord, senior is not keeping.
Since they are not well, the date may be fixed. I don't oppose to the adjournment.
Yes, at the request of counsel for the petitioner.
Yes, my lords.
Leave this matter on 22nd. 21st. Yes, 21st.
Serial number 72, my lordship. For the
72.
petitioner, my lordship. Kindly refer the matter to mediation, my lordship, on September 10th.
72.
Yes, my lord.
Mediation.
Yes, yes, my lord.
You are appearing for?
Petitioner, my lord.
Other side is also agreed.
Yes, my lordship. Last time only they have agreed.
Learned counsel for the petitioner submits that matter may be referred to which mediation? Bangalore Mediation Center.
Bangalore Mediation Center.
Refer this, requested to refer this matter Bangalore Mediation Center.
September 10th, my lord.
Yes. And the request to refer this matter to Karnataka Mediation Center at Bangalore. Which date?
September 10th.
What is our directed to be appeared before the Karnataka Mediation Center on 10th September? Yes.
Obliged.
Sir, VCLA adjournments if any, list number 1. List number 1.
Yes, Mr. Mahesh.
Sir, Mahesh, ಹೇಳಿ sir.
I am for the fourth respondent. I have informed the petitioner's counsel. 61, my lord. 2 weeks time may be granted. The chief officer has died and somebody else has come. I have no instructions from him. I don't know his number.
Regularization matter.
Yes, at the request of counsel for the respondent. Is this matter on 21st.
Much
Yes.
obliged. Much obliged.
Number 1. For preliminary hearing, serial number 1, Narasimha Prasad SD for petitioner.
I will to for the petitioner, please.
Yes.
Serial number 1, my lord. Shanbogar appointment KT. KSAT.
ಇಲ್ಲ,
KT. Yes.
ಇಲ್ಲ, sir, there are several petitions that were allowed
ಮಾಡಿದಾರೆ,
by the-
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಹೇಳಿ? ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದಾರೆ ಅಲ್ಲಿಗೆ ಹೋಗಿ ಅಂತ. ಇಲ್ಲ ನೀವು ಹೇಳಿಲ್ಲ, ಇಲ್ಲ ಅವ್ರು ಹೇಳಿಲ್ಲ, ಇಲ್ಲ ನಮಗ್ ಗೊತ್ತಿರ್ಬೇಕು. 2, 3 ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಿರ್ತಾರೆ ಅಷ್ಟೇ. Yes, at that outset, learned government advocate has submitted that.
The matter has been already covered by the judgment of the KAT. Series of the matters were disposed.
ಆಯ್ತು, ಅವರೇ ಮಾಡ್ತಾರೆ. ಅವ್ರದಿಗೆ ಒಂದು ಲೆಕ್ಕ ಇರಲಿ ಡಿಸ್ಪೋಸಲ್ ಅಂತ. Yes. Yes, submitted that matter related to the civil post. Petitioner has to approach Karnataka Service Administrative Tribunal in view of judgment of apex court so and so. The petition is disposed of, reserving liberty to the petitioner to approach Karnataka Administrative Tribunal. Yes.
Serial number 2, Sagar V. Shastri for petitioner.
I am for the petitioner, my lord. This is regarding promotion for clerk-cum data entry operator post. I am working for the past 12 years and I have applied and I have represented for the post of clerk-cum computer operator. And another computer operator was also there. She also applied. Whereas the Jilla Panchayat has forwarded her representation, but not mine. So hence we are requesting for a mandamus. Still notices have not been issued.
Or issue notice. Government advocate is directed to take notice for respondent number 1 and 2. Issue emergent notice to respondent number 3,
4 and
5. Counsel for the petitioner is directed to serve 2 sets of copies on government.
Obliged.
Serial number 3, Deepak M.
Lordship, I appear for the petitioners in this lot. Kindly adjourn it for 2 weeks, my lordship. There was a
The request
connected
of
matter.
counsel for the petitioner leaves this matter after 3 weeks.
Serial number 4, Balraj AC.
Much obliged.
Serial number 4, Balraj.
Yes, none appears, leaves this matter after 2 weeks.
Kindly, impugned endorse may be ordered to be returned, my lord.
Original ಇದೆಯಾ?
Oh.
ಅದ್ರಲ್ಲಿ first matter ಅಲ್ಲಿ office is directed to return that annexure.
Impugned endorsement ಅಂತ ಹೇಳ್ತೀವಿ.
AM, annexure AM.
Annexure A to the petitioner forthwith after retaining that Xerox copy. Yes.
Serial number 5, Rajeshwarapian for petitioner, Rakshita DJ.
Milord, this matter, last occasion your lordship had heard the matter, directed me to file statement of objection. I need a week's time, Milord. They've questioned the articles of charge. Inquiry is ongoing. No
Yes.
order is passed as on today yet, Milord.
Yes.
My lord, one request, madam. They have taken 2-3 times objection for filing objection.
No, my lord.
The reason is this, my lord. They are pressurizing the petitioner to vacate the premises, my lord. Without, my lord, without giving an opportunity because he has met an accident.
No, she
The
said
petition,
they are
please,
not
my lord.
precipitating that matter.
My lord, please, what happened, my lord? The petitioner has met an accident. He cannot travel for 7 years, my lord. He has now ready to deposit, my lord, 5 lakhs rupees before this court or, my lord, the department. My lord, not to take precipitative action, my lord. At least, my lord. Otherwise, my lord, they will.
Wait.
Milord,
See, we'll permit that, but don't force him to vacate that. Otherwise, it's purpose of filing the report.
Milord,
Please,
that
my
is
lord.
not the case. He's been transferred to MESCOM in 2012. Kindly see the articles of charge, Milord. 2012, he's transferred. He does not vacate the premises up to more than 10 years. And their own representation,
No, he is transferred to where?
MESCOM as chief
My lord,
engineer.
he is in Mysore. He is daily traveling from the house. My lord, he cannot,
10 years
actually
and
what
he's
happened, my
kept
lord, my lord,
vacating.
everybody, my lord, every,
ಮನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಬಾಡಿಗೆ
ಬಾಡಿಗೆ ಕೊಡ್ತಿದ್ದೀವಿ, ಬಾಡಿಗೆ
ಇಲ್ಲ,
ಕೊಡ್ತಾ ಇದೀವಿ.
ಬಾಡಿಗೆ ಕೊಟ್ಟಿಲ್ಲ
5 ಲಕ್ಷ
ಅಂತಾನೆ
ರೂಪಾಯಿ
ಇಲ್ಲ ಕೊಡ್ತಾ ಇದೀವಿ, ಸೊ 5 ಲಕ್ಷ ಕಟ್ತೀನಿ, ಬಾಡಿಗೆ ತಿಂಗಳ ಕಟ್ಕೊಂಡು ಹೋಗ್ತೀನಿ, ಅದ್ರಲ್ಲಿ.
ಈಗ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯು ಡಿಪಾಸಿಟ್ 5 lakhs.
Please, madam, please, madam.
Mulad, and the submission made that we have taken several times. Kindly see the order sheet,
I am
Mulad.
not recording anything.
Last date matters
Please,
come
madam.
up for
I
preliminary
will
hearing.
deposit 5 lakhs.
Lordship directed me to file statement. Mulad, now enquiry is ongoing. Mulad, annexed day, if your lordship sees.
ಆಯ್ತು, ಎಂಕ್ವೈರಿ ಮಾಡಿ ಸದ್ಯಕ್ಕೆ ಅವ್ರನ್ನ ವೆಕೇಟ್ ಮಾಡಬೇಡಿ, 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡ್ತಾರೆ.
Please, madam.
ಅಲ್ಲ ವೆಕೇಟ್ ಮಾಡೋದಿಕ್ಕಲ್ಲ, ಅವ್ರ ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್
ಅಲ್ಲ,
ಕೊಡ್ಬೇಕು
ಅವರು-
ಅಂತ ಆರ್ಟಿಕಲ್ಸ್ ಆಫ್ ಚಾರ್ಜ್ ಇಶ್ಯೂ
ಇದೆ ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್
44 lakhs.
My lord, that's the exorbitant. As per the rules, 10 lakhs I am entitled. 10
Mulad,
lakhs, 45 lakhs ಹಾಕಿದ್ದಾರೆ. I don't know what calculation they have made, I don't know.
Mulad, if I may be permitted to submit, arrears are due from 2010 to up to 2017 August. Then from November 2023 to May 2024.
Must you give that memo? What are that this thing?
It is mentioned, my lord. We have mentioned the period, page 16, if your lordship comes to.
Page
16, annexed A ಅಲ್ಲಿ.
Yes.
My lord, in that ಆರೋಪ 1.
Yes.
ML ನಾಗರಾಜ್ ಮುಖ್ಯ ಇಂಜಿನಿಯರ್ ಆದ ನೀವು ಬೆಂಗಳೂರು ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಅವಧಿಯಲ್ಲಿ ದಿನಾಂಕ 22/4/2002 ಅಧಿಕೃತ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋನ್ಸೋ ರನ್ವಯ ಹೂಡಿ TL ಮತ್ತು SS ವಿಭಾಗದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ FTHAL 2ನೇ ಹಂತ ಇಂದಿರಾನಗರ್ ವಸತಿ ಗೃಹವನ್ನು ಹಂಚಿಕೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. 2009ನೇ ಸಾಲಿನಲ್ಲಿ ನಿಮಗೆ ಸಹಾಯಕ ಕಾರ್ಯನಿರ್ವಾಹಕ ಇಂಜಿನಿಯರ್ ಹುದ್ದೆಯಿಂದ ಕಾರ್ಯನಿರ್ವಾಹಕ ಇಂಜಿನಿಯರ್ ಹುದ್ದೆಗೆ ಪದೋನ್ನತಿ ನೀಡಿ ನಿಮ್ಮನ್ನು ಮಂಗಳೂರು ಮೆಸ್ಕಾಂ ಕಂಪನಿ ಕಚೇರಿಗೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿದರೂ ನೀವು ಬೆಂಗಳೂರಿನ ವಸತಿ ಗೃಹವನ್ನು ಖಾಲಿ ಮಾಡಿರುವುದಿಲ್ಲ ಹಾಗೂ ಸೆಪ್ಟೆಂಬರ್ 2010 ರಿಂದ ಆಗಸ್ಟ್ 2017 ವಸತಿ ಗೃಹದ ಬಾಡಿಗೆ ಮೊತ್ತವಾದ 15,59,924 ಹಾಗೂ 2021-22 ಸಾಲಿನ 1 ತಿಂಗಳ ಬಾಡಿಗೆ ಮೊತ್ತವಾದ 35,198 ಒಟ್ಟು 15,95,114 ವಸತಿ ಗೃಹ ಬಾಡಿಗೆ ಮೊತ್ತವನ್ನು ಪಾವತಿಸಿರುವುದಿಲ್ಲ. ಮುಂದುವರೆದು ನವೆಂಬರ್ 2023 ರಿಂದ ಮೇ 24 ವಸತಿ ಗೃಹದ ಬಾಡಿಗೆ ಬಾಕಿ ಬೇಡಿಕೆ ಮೊತ್ತವನ್ನು ಪಾವತಿಸದಿರುವುದು ಹೂಡಿ TL ಮತ್ತು SS ವಿಭಾಗ ಕಚೇರಿಯ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಲೆಕ್ಕ ಶೀರ್ಷಿಕೆ ಸೋನ್ಸೋ ರಡಿಯಲ್ಲಿ ಬಾಕಿ ಉಳಿದಿರುತ್ತದೆ. ಸದರಿ ಮೊತ್ತವನ್ನು ಪಾವತಿ ಮಾಡುವಂತೆ ಹೂಡಿ TL ಮತ್ತು SS ವಿಭಾಗ ಕಚೇರಿಯಿಂದ ದಿನಾಂಕ 25/8/2010 ಹಾಗೂ 14/8/2020 ಪತ್ರಗಳಲ್ಲಿ ನಿಮಗೆ ತಿಳಿಸಲಾಗಿದ್ದರು ಹಾಗೂ ತಮ್ಮ ಮೇಲಾಧಿಕಾರಿಗಳಾದ ಪ್ರಧಾನ ವ್ಯವಸ್ಥಾಪಕರು ಬೆಸ್ಕಾಂ ಬೆಂಗಳೂರು ರವರು ದಿನಾಂಕ 3/12/2008 ಹಾಗೂ 21/12/2008 ಪತ್ರಗಳಲ್ಲಿ ತಮಗೆ ಬಾಕಿ ಬಾಡಿಗೆ ಮೊತ್ತವನ್ನು ಪಾವತಿಸುವಂತೆ ಸೂಚಿಸಲಾಗಿದ್ದರೂ ಸಹ ನೀವು ಇದುವರೆಗೂ ಬಾಕಿ ಬಾಡಿಗೆ ಮೊತ್ತವನ್ನು ಪಾವತಿಸಿರುವುದಿಲ್ಲ. KB ಅಕೌಂಟ್ಸ್ ಮ್ಯಾನ್ಯುಯಲ್ ವಾಲ್ಯೂಮ್ 1 ಪ್ಯಾರಾ 38.2 ರಲ್ಲಿ ಮ್ಯಾಕ್ಸಿಮಮ್ ಆಫ್ 3 months ಟೈಮ್ ಶಾಲ್ ಬಿ ಗ್ರಾಂಟೆಡ್ ಫಾರ್ ವೆಕೇಶನ್ ಆಫ್ ಬೋರ್ಡ್ ಕ್ವಾರ್ಟರ್ಸ್ ಎಂದು ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. ಆದರೆ ನೀವು ಇದುವರೆಗೂ ವಸತಿ ಗೃಹದ ಬಾಡಿಗೆಯನ್ನು ಪಾವತಿಸದೆ
2010 ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರತ್ತಾ?
9 ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರೋದು ಟು ಮೆಸ್ಕಾಂ. He does not
ಎಷ್ಟು ಮಂತ್ಲಿ ಎಷ್ಟು ಅವ್ರದ್ದು?
Lord, monthly it is sum of rupees.
May be permitted the circular and the calculation sheet, my lord.
Two things.
Please, my lord.
Lord, before that.
No, circular will not applicable after the transfer.
No,
after the transfer you have to pay.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. Your lordship may kindly in second one, my lord. It is a circular, my lord. Second one, my lord.
95, my lord. There.
Second document. My lord, as per the rules, my lord, he is working as in the MESCOM. As per the rules, the marking there, my lord. I am eligible to pay, my lord. So I have given the calculation sheet, my lord. Calculation sheet in the first, my lord. For that, they have calculated 15 lakhs. I am entitled, my lord, 7,87,000 rupees is there. But as of today, my lord, I am entitled to pay, my lord, 13 lakhs. But I am ready to right now because he met an accident. He could not. He has got he cannot get the salary because ಕಾಲೇ ಮುರಿದೋಗಿತ್ತು ಅವ್ರಿಗೆ. 7 ವರ್ಷ ಅವ್ರಿಗೆ ಇದ್ ಮಾಡಕ್ಕಾಗ್ಲಿಲ್ಲ, ವರ್ಕೇ ಮಾಡಕ್ಕಾಗಿರ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ನಾವ್ ಏನ್ ಹೇಳ್ತಾ ಇದೀವಿ ಅಂತಂದ್ರೆ, ನಮಗೆ ಪ್ರಾಪರ್ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿಲ್ಲ. 5 ಲಕ್ಷ ರೂಪಾಯಿ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀನಿ, ತಿಂಗಳ ಅದು ಆಸ್ ಪರ್ ದ ರೂಲ್ಸ್. ಅವ್ರ ಪ್ರಕಾರ ನಾನು ಏನಿದೆಯೋ ರೆಂಟ್ ಪೇಯಬಲ್ ಆಸ್ ಪರ್ ದ ಬೆಂಗಳೂರು ಇವಾಗ ಇದ್ರಲ್ಲಿ ಮೆಸ್ಕಾಮ್ ಅಲ್ಲಿ ಏನ್ ರೇಟ್ ಇದೆಯಲ್ಲ ಅದ್ರ ಪ್ರಕಾರ ರೂಲ್ಸ್.
ಅದು ಸೆಕೆಂಡ್ರಿ.
ಪ್ಲೀಸ್
ಬಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆದ ತಕ್ಷಣ ನೀವು ವೆಕೇಟ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಇಲ್ಲ ಟ್ರಾನ್ಸ್ಫರ್ ಇಲ್ಲ, ಇಲ್ಲಿಂದ ಮೈಸೂರಲ್ಲಿ ಇರೋದು ಅವರು. ಮೈಸೂರು.
ಯು ಡಿಪಾಸಿಟ್ 8 lakhs rupees.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
8 lakhs rupees by next week.
By 2 weeks, my lord. My lord, by 2 weeks, my lord, because my reason is this, my lord. He has to mobilize the.
So and so learned counsel prays 2 weeks time to file objection. In the meantime, petitioner is also directed to deposit 8 lakhs rupees before this court, or deposit before that respondent number 2 na.
Respondent number 2, my lord.
Respondent number 2.
Oh, please.
This matter of 2 weeks.
My lord, in the meantime, ನಾನು
Inquiry ongoing.
Inquiry ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಎನ್ಕ್ವೈರಿ ನನಗೆ ಹಾಗಾದ್ರೆ ನಾನು ಮೈ ಲಾರ್ಡ್ ಮೈ ಆಂಗ್ಸೈಟಿ ನಾಟ್ ಟು ಪ್ರೆಸಿಪಿಟೇಟ್ ಟಿಲ್ ದಟ್ ನಾಟ್ ಟು
ಅಲ್ರಿ. ಎನ್ಕ್ವೈರಿ ಇರೋದು ಏನು ಗೊತ್ತಾ, ಇದು ನೀವು ದುಡ್ಡು ಕಟ್ತಾ ಇರ್ತಕ್ಕಂಥದ್ದು. ಇದು ಇದರಲ್ಲಿ ಸರ್ವಿಸ್ ರೂಲ್ಸ್ ಅಲ್ಲಿ ನೀವು ಡಿಸೊಬೈ ಮಾಡಿದೀರಾ ಅನ್ನೋದಕ್ಕೆ ಪೆನಾಲ್ಟಿ ಮಾಡ್ಬೇಕಾ ಬೇಡ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, ಅಲ್ಲಿ ತನಕ ನಿಮ್ಮನ್ನ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸಸ್ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವು 8 lakhs ಕೊಟ್ರೆ 2 weeks ಅಲ್ಲಿ ಏನು ಮಾಡೋದಿಲ್ಲ. ಡಿಪಾಸಿಟ್ 8 lakhs. ಲೆಟ್ ದ ಎನ್ಕ್ವೈರಿ tomorrow it is held that no, it is not a penalty, they can be exonerated. We have not said that. Till that, let them file an objection.
I have no difficulty in depositing the amount. It's not in dispute that I have not made the payment of the house rent elements. Question is, they have initiated action to impose a major penalty. When I was on loss without loss of pay, without leave without loss of pay.
That we will see whether law is permitted or not. But you deposit 8 lakhs.
I will.
We'll have it after 2 weeks.
I will deposit, my lords. But the only thing is, my lords, they are holding an inquiry.
Let them hold an inquiry, but not to
impose. There is no need to hold an inquiry, my lords, because there is no need to hold an inquiry because I myself have admitted that I have not paid it.
Then,
I did not pay.
Then what is that exemption under the law if it is not paid?
Lords, I met with an accident and I was in bed rest, complete bed rest for 5 long years. They have granted me leave without pay. When they are saying that I am on leave without pay and I cannot move out, where's the question of I staying in the quarters without paying the rent, my lords? It's an admitted fact, but whether that amounts to a misconduct.
That we will see.
That's not an enumerated misconduct, is what is my submission. I have relied on those provisions, my lords.
See, if it is not a misconduct, they can exonerate you in the inquiry. They are not.
There's no necessity, my lords, because I myself have admitted I have not paid it.
If it is misconduct or not, whether I have to decide or inquiry officer has to decide.
My lords have to decide because on the face of it, there's nothing to inquire into.
No, all inquiry initiated. It is not that it is a misconduct. Employee still has a right to prove before that inquiry, saying that it is not a misconduct. They can be exonerated.
No, my submission
we cannot
is this,
hold an
inquiry. They have initiated action to impose a minor penalty, my lords. I can understand.
No.
Because the minor penalty is recovery of money is also one of the punishments.
After imposing the penalty, then only we can see whether it is a minor penalty has to be imposed, major penalty has to be imposed. Don't make me as an inquiry officer.
No, my lords, they have already taken a decision to hold an inquiry so that a major penalty could be imposed.
No,
that's the proceedings initiated.
One thing, if that authority which is imposing that, initiating that inquiry without jurisdiction, then only we can interfere. Otherwise, only after that inquiry we can come before the case whether it can be done it or not.
On the face of it, my lords, there is.
How can they say that whether it is a minor? See, even if it is in a major penalty, initiated that inquiry by imposing, they can impose that minor penalty also, Mr. It is doesn't.
I have given my reply. Without considering my reply, they straight away proceed to hold an inquiry by appointing an inquiry officer.
That is the ground for you to imposing the penalty. Now that they are proceed with that inquiry, not to impose any penalty for 2 weeks. In the meantime, you file it, you will see that on the merit, and you also deposit 8.
Please.
Don't impose. You go on with that inquiry, but
impose penalty in
Preliminary stages.
Yes.
I'll file my.
My lords are making it clear that they will not conclude the inquiry procedure.
Not impose any penalty.
Please, put it.
No, let them deposit. If their submission is that no, we're
Wait,
willing to, but they don't deposit to show the
I am
bona
agreeing to
fide.
deposit
They should
8
have
lakhs.
come up at the first instance before this honorable court with the amount they're ready to.
I'm on leave without pay. Where do I have money to deposit straight away?
Sir, they want to occupy the premises for more than 8 long years after he's
Yes, respondent
transferred.
is directed to proceed with that inquiry, but not to pass an order for imposing the penalty till next date of hearing, subject to condition. Petitioner has to deposit 8 lakhs rupees before second respondent on or before 20th August. Yes.
Obliged.
Number 4.
Serial number 4. 4. Serial number 4.
No, now you serial number 6, Mr.
Serial number 6, Sridhar Murthy HR for petitioner.
Writ of mandamus, my lords. Wide annexure A and A1, my lords. In page number 13, annexure A, my lords. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚೆನ್ನಕೇಶವಾದ ನಾನು ಸುಮಾರು 9 ವರ್ಷಗಳಿಂದ ಕಿರಿಯ ಇಂಜಿನಿಯರ್ ಆಗಿ ವಿವಿಧ ಕಾರ್ಖಾನೆ ಮತ್ತು ಘಟಕಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ್ದು ನಾನು ನಿಗಮದಿಂದ ನಿರಪೇಕ್ಷಣಾ ಪತ್ರ ಪಡೆದು ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಇಂಜಿನಿಯರಿಂಗ್ ನಲ್ಲಿ ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಣ ಮುಗಿಸಿದ್ದು ತಮ್ಮ ಕಚೇರಿ ನೇಮಕಾತಿ ಪ್ರಕಟಣೆ ಸಂಖ್ಯೆ 23/2008 ಪರಿಗಣಿಸುವಂತೆ.
What is that relief you are seeking?
Consider the representation, my lords. Wide annexure and
representation for what?
I will promote the assistant engineer from junior engineer.
ಎಲ್ಲಿ ನೀವೇನು ಸೀನಿಯಾರಿಟಿ ಇದ್ದೀರಾ? ಎಲ್ಲಿ
Yes, my lords. ಇದರಲ್ಲಿ 2000 my lordship in petition is here and joined the service of the respondent number 2 corporation assistant lineman in the year 2006 and acquiring a qualification of diploma in electronic engineering. He has a
notice.
Serial number 7, Prithvi Shemke.
Appear for the petition. Petition is a contractual employee in the respondent pollution control board. Is agreed by the inaction on the part of the board to grant service weightage, my lords, for his service rendered as a contractual employee. This is the third round of litigation. Now there's an order passed to grant me the service weightage, but that order is not implemented. My prayer is only to implement the order.
Where is that order passed by?
Yes, my lords. Annexure V, page number 207. Initially in 2012, my lords, I had filed a writ petition. This court directed to the page number 207, operative portion 208. Please see last paragraph.
Read.
48% ಕೃಪಾಂಕ ಹಾಗೂ ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸು ದಿನಾಂಕ 5/8/2002 ಅನ್ವಯ ವಯಸ್ಸಿನ ಸಡಲಿಕೆ ನೀಡಲು ಅನುಮೋದಿಸಿದೆ. This is in 2023. Now I am on the verge of retirement. Next year I'll be retiring, my lords.
Issue notice.
May I be permitted to present the panel counsel?
Who is that panel?
My lords, Mr. Mahesh Chaudhary. Yes.
The petitioner Mahesh Chaudhary is directed to take notice for respondent number 1. Counsel for the petitioner is directed to serve one set of copies.
Yes, my lords. Could I request for any date, my lords, since I'm retiring?
Serve ಮಾಡಿ ಅವ್ರು ರೆಡಿ ಇದ್ದಾರೆ ಅಂದಾಗ ಮೂವ್ ಮಾಡಿ. We'll take
Because there's already an order in my favor, my lords.
Yes.
Any date next week, 2 weeks later.
You serve it.
Yes.
Let him take an instruction.
Yes.
If he is ready, then you move that matter.
I'll move them.
Yes.
I'm grateful.
Serial number 8 adjourned. Serial number 9, Abhiraj B. Changti.
My lord, I appear for the petitioner, my lord. My lord, respondent 6 called for post of Kannada teacher, assistant Kannada teacher to respondent number 7 school, my lord. Petitioner and respondent 8 appeared in the interview, my lord. They were called for the interview and they appeared in the interview. The respondent 6 out to have considered the degree qualification marks and as well as interview marks. They have wrongly considered only the marks obtained by the candidates in the interview and wrongly selected respondent number 8 for the post, my lord. Whereas petitioner is most eligible candidate to have him selected for the post of assistant Kannada teacher, my lord.
No, that is it a grant-in-aid post?
Yes, my lord.
Where is that? Is it application is called by the private society?
Yes, my lord.
If that private society, you file an appeal or revision under that section 133. It is not that any action of that state authority, Mister. It is a private society.
My lord.
If there is any irregularities in that appointment, you can approach that authority under that 131. Yes, 131 of Education Act. Yes.
My lord, kindly have it on 13th or 14th, my lord.
For what?
My lord, I will get some clarification on this, my lord.
What clarification? From whom you will get, Mister? Client will tell that what is that legal position, or lawyer has to say, Mister.
No,
Yes.
my lord, I'll go through the act, my lord.
Yes. Before that, you have filed a writ petition.
Yes.
Yes. Is this matter on 14th?
Grateful.
Yes.
Bill number 10, Krishna Das right for petitioner.
If you put same matter. Same matter. Our yaar so and so is directed to take notice. Leave this matter along with that so and so.
Serial number 11, K. Ravi Shankar. Serial number 11.
Annexure U, page 120.
Yes.
Annexure U, page 122 is the similar order.
Yes. Learned counsel for the petitioner is directed to serve 2 sets of question. Ella state and
Ella state.
Government advocate is directed to take notice 1 to 3. Counsel for the petitioner is directed to serve 3 sets of copies.
4 is Lokak.
Also, 5 also you will take notice.
How the?
4 is university.
4 is Lokak.
Mandya University, na? Shivram, H.E. Shivram is directed to take notice for R4. Counsel for the petitioner is directed to serve 1 set of copies. Respondents are directed not to discontinue the service of the petitioner as a guest lecturer if he is already working. He is still next date of hearing.
But only one submission. This your lordships are now passing an order. If they are not relieved or they are working, let the dishonorable court in an earlier notification issued by this 24 for the year 24-25. But it is already ceased before R. Nataraj, Justice R. Nataraj, wherein this court has passed an order. Kindly see on 37/2025. 2025 fourth, the additional government advocate general. Your lordships got it?
Which date?
ಇದು 37/2025. The learned additional advocate general submits that is the status quo it exists today shall be maintained till the next date of hearing. This was also continued on 4/8/2025. ಇದಕ್ಕೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಒಂದು ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿ ಮಾಸ್ ಟರ್ಮಿನೇಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಈಗ ತಾವು ಮಾಡ್ತಕ್ಕಂಥ ಆರ್ಡರ್ ಅನ್ನು ಕೊಟ್ರೆ ಅಲ್ಲಿ ನೀವು ಯು ಆರ್ ರಿಲೀವಿಂಗ್ ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ. ದಟ್ ಈಸ್ ಅವರ್ ಪ್ರಾಬ್ಲಮ್ ವಿ ಆರ್ ಫೇಸಿಂಗ್.
Entry order is there.
There.
If they are mass terminated, it amounts to a contempt. Go and file a contempt.
ಅದಕ್ಕೆ ನಾನು ಒಂದೇ ನಿಮಿಷ. But this is dated 23/7 before the undertaking. ಅದರಲ್ಲಿ ಕೈಂಡ್ಲಿ ಲುಕ್ ಎಟ್ ಮಿಲ್ಲಟ್ ಮುಂದುವರೆದು ಈ ಕಚೇರಿಯ ಪ್ರಕಟಣೆ ಸಂಖ್ಯೆ ಸೋನ್ಸು ದಿನಾಂಕ 2/1/2025 ಸೋನ್ಸು 2/8/25 ಕಾಮನ್ ಟರ್ಮಿನೇಟ್ ಮಾಡ್ತೇವೆ ಅಂತ ಹೇಳಿದ್ರೆ ದಿ ಗವರ್ಮೆಂಟ್ ಅಡಿಷನಲ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ವುಡ್ seek a taken undertaking before the court. That has been continued. This honorable court grants a stay of the notification for the year 25-26. So
ನೀವು ಎಲ್ಲಿವರೆಗೂ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಲ್ವೋ ಅಲ್ಲಿವರೆಗೂ ಅವ್ರು ಇದು ಮಾಡ್ತಾ ಇರ್ತಾರೆ. ನಾವ್ ಏನ್ ಮಾಡ್ಬೋದು? ಸಿಂಗಲ್ ಜಡ್ಜ್ ಇನ್ನೊಂದು ಎಂಟ್ರಿ ಮಾಡ್ಬೋದು. Court has a power to punish. Why can't you take that contempt?
ಈಗ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀನಿ. That is a different aspect. However, I have produced the document to show that I am working. ಈಗ ತಾವು ಮಾಡಿರ್ತಕ್ಕಂಥ ಆದೇಶದಲ್ಲಿ ಕೊಟ್ರೆ we have commonly terminated, you are not entitled.
No, when there is an order of status quo, you go and file a contempt. Otherwise, same thing will be happen. Yes.
Lord, let the copies which were served on the court.
ನಿಮ್ಮ ರೆಕಾರ್ಡ್ ಕೊಡ್ತೀನಿ.
Yes.
ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡ್ತಿದ್ದೀರಾ ನಮಗೆ
ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಬಂದಾಗ ಎಲ್ಲ ಇರುತ್ತೆ.
ಅಲ್ಲ ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ.
Yes.
Please.
Yes, dispensed.
Serial number 12, Suvarna Lakshmi ML for petitioner.
Annexure K is under challenge, my lords, which is the order, my lords, whereby a minor penalty is imposed of withholding 1 increment. But this minor penalty is imposed, my lords, contrary to judgment of the Honorable Supreme Court, where it says, my lords, that when the facts are disputed, the regular inquiry should be conducted even in minor penalty cases. That is my first ground. Second ground, my lords, is the competency of the fourth respondent. As per the amendment, my lords,
where is that charges?
My lords, it commences at page number 96. I have extracted it in my writ petition itself, my reply as well as the charge. Page number 12 onwards.
12.
Please, my lords. Each charge I have culled out and my reply to it also I have culled out.
What are the charges?
My lords, first charge being under the UNIP scheme, estimates have to be submitted for 130 IP plants in Beluru's branch, although it has been directed to submit estimate according to seniority list for the last 3 months. Estimates have not been submitted in full till date. My reply to it is, my lords, 22 IP works. The work orders have been given and completed, and the remaining the work orders are pending with
Where
the
is
division.
that penalty imposed
My
order?
lords, that is Annexure K.
Annexure?
K. Page 114, operative portion.
Yes.
My lords, one glaring factor in this case, my lords, is I was not the regular assistant engineer. I was on additional charge. Till date, additional allowance is not given to me. Once I ask my additional allowance, I am
What
issued
is
with
that
this
penalty
notice.
imposed?
Withholding of 1 increment, my lords, for the period of 1 year. Now this, my lords, is issued. My lords, may kindly take 113, my lords, I'm sorry.
Yes.
Ali 30th June 2025. This is issued by Adhyakshaka Engineer Vidyuta Hagu Shistu Pradhikari, Karya Mattu Palana Vrutti, Chescom Hasan. This is the O&M circle.
Take notice.
My lords, it is without jurisdiction for this reason.
We'll see. If you are succeeded, you will get back.
No.
It's not the termination.
No.
You are working.
My lords, one inquiry has not been held. The law on the point is very clear.
No, I am not deciding that matter.
Please.
See, they have withhold that 1 increment.
Please.
That you will get it if you succeed.
My lords, what happens
is that urgency for
I'm due for promotion as well, my lords. This my promotion also will be deferred because of this.
Oh, is it deferred?
I am due for promotion, my lords.
It is deferred, you come back before the court. Yes.
My lords, if stay is not granted in this case, my lords, then by all means it will be deferred, my
No,
lords.
it is, which law says that in all cases stay has to be granted?
My lords, when
You have in a case for allowing that writ petition, if it is no necessity for granting an interim order here, it cannot be.
my lords, it is without jurisdiction itself.
Without jurisdiction also.
CDCA itself says so.
Yes.
Please look at page number 118, please, for 1
Said
second.
that I am not granting interim order.
Please, my lords.
Yes.
But please look at 118.
No, I have seen that. Yes. Or issue notice. Issue emergent notice. Yes.
My lords, the panel advocate may be directed to take.
Who is the panel advocate?
My lords, for the KPTCL, first respondent would be Rakshita madam.
Yes. Rakshita DJ is directed to take notice for respondent number
1, my lords.
What about the other?
2, 3 and 4, my lords,
There
Nagasri
is
madam appears.
No, that after 3, it should be 4.
4, there's
After 3, there
typographical
cannot
error.
be a 3.
Typographical error.
Yes.
I'll correct it.
That has to be corrected.
Please, my lords.
Yes.
Nagasri madam appears for CESC.
For whom?
Chamundeshwari Electrical.
Yes. Nagashri is directed to take notice for respondent number 2. What about 3
2,
and
3
4?
and 4, my lords.
3 and 4.
She'll appear.
Counsel for the petitioner is directed to serve 2 sets of copy, 1 sets on so and so and 2 sets on so and so. Permitted to amend, correct it.
Please, my lords. Great.
Dispensed for a period of 4 weeks.
Office objection, first time matter, serial number 13, Mukkanappa SB for petitioner.
Petition.
2 weeks time may be granted for 2 weeks time may be.
2 weeks to comply of subjection.
Serial number 14, NS.
My lords, I appear for the petitioner. My lords, this is a court mode matter, my lord. There is urgency, may kindly be heard, my lord.
What is that office objection?
My lords, there is correction in the dates mentioned in the
correct?
prayer. We'll correct it, my lords.
Yes, password. If you complied it, then we will take that.
It was filed yesterday. In the course of the day, I'll correct it.
Yes.
My lords, this is matter pertaining to.
No, you complied, then we'll take it.
Serial number 15, Manjunath KV.
Let's objection, I will comply by now itself. Notice may be issued. Let's, there are.
No, Mr. After compliance.
I will
only
comply
notice is-
now.
Yes. You want passover? Passover.
For orders, serial number 16, Ramananda AD for petitioner, R. Padmanabha.
Yes, who has filed memo for retirement?
6 minutes. I have filed.
Your Lordship, what is happening is the advocate has filed retirement. There the court has vacated. The arrest warrant cannot be issued. From I am working pro bono in this case. this lady is not getting any money from 2006 in spite of execution. Arrest warrant was stayed. Now there's a court, execution court says will not issue and is not available at all.
Now that, what is this matter, Mr.?
Your Lordship, the petitioner succeeded in getting reinstated back to her job in EAT 27 of 2003 by judgment dated 11/11/2005. This was challenged by the respondent, third respondent in WP number 6726 of 2012. Till then, there was a stay order. Again, this matter went to writ appeal. Writ appeal also stayed and directed writ petition to be reconsidered. The writ petition was considered and the third respondent did not succeed. Then what happened is again writ appeal was filed. That writ appeal was also dismissed and only I was able to get 1 lakh of arrears. From then, the executing court is trying to protect the third respondent in one or the other way. And that is the reason I initiated this writ petition. During the writ petition, the respondent contended that I cannot take two remedies, one before the High Court and one before the executing court. In the executing court, he has got a stay order. Then this court said, stay is vacated. You can get the arrest. And now the executing court dismissed the arrest warrant. So we cannot issue arrest warrant against a person.
Challenge ಮಾಡಿ ಅದನ್ನ.
ಅಲ್ಲ, ಅದು ಚಾಲೆಂಜ್ ನಾನು ಹೇಳ್ತಾ ಇರೋದು 2002 ಇಂದ ಸಫರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ I have retired. I have reached the age of superannuation, at least my retirement. Now, last time he took time. Now he is retired. I'm in a helpless position to secure the third respondent. Now, fourth and fifth respondent, he was appearing. They had taken my job from the third respondent society.
What is the order passed by the EAT?
EAT said reinstate me to service and pay all back wages from 2002.
Now that, where is that order passed by that executing court? You challenge that executing court order, you will direct the executing court to.
No, this court actually directed that the stay order is vacated. But now subsequently after the stay order is vacated, they said that we cannot issue arrest warrant to the third respondent. And there, as soon as this court directed that stay order is vacated, the
we can examine any order. If you challenge and it is before us, we cannot say that it is not that.
Your Lordship, my only thing is,
if you want, you challenge that executive court order, then we can say that it is wrong or right.
I am only saying before this court, I am in a helpless position. From 2002, the third respondent is trying to evade the process.
Yes, learned counsel for respondent number 3. Have you sent a notice to them, Mr.?
My lord, I have sent a notice to my lord. Notice them. Kindly see my.
Where is that your memo for retirement?
On 31 July 2025, my lord, I have filed.
The notice is served to them.
Yes, my lord. I have filed an acknowledgement, my lord, along with the memo, my lord.
Now, who has taken the time last week?
He had taken.
Why you have taken time last week, Mr.?
My lord, I tried to contact the respondents, my lord, but they have not.
No, why you want to try to contact? You have filed a memo for retirement. When?
My lord, after the last date of hearing, my lord.
Last date of hearing.
Yes, my lord.
Yes. Learned counsel for respondent number 3 to 6 has filed a memo for retirement. Memo is taken on record. Notice to 3 to 6 is taken on record. The counsel for respondent number 3 to 6 is permitted to retire from the case. The respondent number 3 has not. None appear for respondent number 3 and they have not engaged any counsel. Leave this matter on 20th. Before that, respondent number 3 either engage the counsel or secretary of that respondent number 3 has to be present before this court. Yes. Office is directed to communicate this order to respondent number 3. Please this matter available. Yes. 21st. Yes.
Great finish.
Serial number 17, Subramanya R for petitioner, MS Parthasarathy.
But the matter has been settled and we filed my lord's adjourned memo also.
Yes. What
On
is
that
the
basis,
petition?
on the basis of adjourned memo, my lords, the matter can be disposed of.
Yes. What is this matter, Mr.?
Lords, the
Matter,
challenge,
my
my lords, is to the order passed by the Education Appellate Tribunal.
Yes, you have settled that matter.
They agreed, my lords, to pay, my lords, some lump
Yes.
sum compensation, my lords. I
This
agreed to-
petition. Petitioner called in question. Petitioner trust has called in question. Order passed by Education Appellate Tribunal in EET number 8 of 2017 on 18 January 2019. After service of notice, the parties have settled that matter and filed an joint memo. Dated, date hakilala joint memo. Date
Filed on, my lords, 2nd August. Filed on 2nd August.
filed on 2nd August. Idರಲ್ಲಿ date ಇಲ್ಲ ರೀ, date ಖಾಲಿ ಬಿಟ್ಟಿತ್ತು.
ಇಲ್ಲ ಹಾಕು.
Yes. Joint memo dated 2/8/2025. ಇಲ್ಲಿ 7 ಇದೆ, ಕರೆಕ್ಟ್ ಮಾಡಿ ಅದನ್ನ.
ಆಗ್ಬೋದು.
Yes. The above writ petition is, the memo, joint memo is filed by the parties as extracted below. The writ petition is disposed of in terms of joint memo. Please ಕೊಡಿ ಅವರಿಗೆ date ಇದು.
Serial number 18, Nagendra Naik R for petitioner,
Appearing for the petitioner,
Srikanth MP.
my lords, the respondent number 3 is the trust which manages the respondent number 4 school, my lords. The respondent number 4 school has been closed right now, my lords. It is entirely managed by respondent number 3, and the already the notice has been issued to respondent number 3, my lords. The notice to respondent number 4 for the second time may be dispensed with, my lords.
Know that respondent number 3
Is the trust, my lords, Kannada Sangha, which manages the Kramuka Higher Primary School, which is the respondent number 4.
which is closed now.
Respondent number 4, my lords, the school.
School is closed. Now that trust is there.
Trust is
Who is
there.
representing trust?
Trust is represented by.
Serial number, it is deferred ಅಂತ ಐತಲ್ರಿ.
It is represented by its secretary, my lords.
ಅಲ್ರಿ ಇಲ್ಲಿ ಲಾಯರ್ ಯಾರು ರೆಫರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ?
My lords,
Lords, my name is shown. My lords, I'll verify. Lords, may have it, my lords, on some.
You are 3, you are appearing, yes. You see that your name is there. We'll take notice. Srikanth MP, this ಎಂತದ Kannada Sangha representative secretary BH Road, Kodur
Verify, my
Taluk.
lords, I'm not very sure. Lords, I'll verify. Lords, may have it, my lords, any day next week. In the
Yes,
meanwhile,
let
I'll
us see
verify.
that. Yes.
my lords,
This matter on 19th, you verify that if you are there, otherwise we'll see what you.
much obliged.
Serial number 19, Giri Kumar SV, Azhar Ali Faruqi for petitioner, Mohan Kumar D.
I am for the petitioner in this case. Petitioner is a person with disability. There are multiple rounds of litigation. I had asked him to give certain documents. However, there is a death in his family yesterday, so he couldn't produce it. May I request for a week's time so that I can.
Notification of that office objection.
I think I have to serve a copy.
Temperature ಜಾಸ್ತಿ ಮಾಡಿ.
I think I'll comply with the office objections. because there is a death in his family. He couldn't produce.
Patient office substance rather than the rejoinder filed by that advocate, so on, third, so on, so.
I have come on NOC wakalat in this.
Erase for early hearing, IA for posting filed by that, so on, so. That rectification of the office objection raised by the rejoinder filed by the advocate for the petitioner.
Yes, I have come on NOC. I will seek instructions and comply by it. If
Yes,
it may be taken
at the
up
request of counsel for the petitioner, is this matter
21st,
2 weeks.
if date may be fixed 21st.
No, you comply it and then.
Yes, yes.
Yes.
Serial number 20, Sachin BS for petitioner, Nilesh Krishna.
Yes. Yes, Mr. Rectification of the office objection raised on IA.
I have not received any IA copy, and also the petition copy that I received was not indexed also. There was no pagination, so I am not aware.
The time of filing wakalat, my lords, I filed an application. At the time of filing application, wakalat was not filed. Thereafter, he has filed a wakalat. Serve the copy.
Stay of further proceedings in the execution, so and so before that executing court. Yes, you serve a copy. Yes. At the request of counsel for the respondent, please this matter after 2 weeks. Interim order granted earlier is extended till next week.
Can I request for an early date, my lords?
Want earlier in? Yes.
Application to modify the condition mentioned in the interim order is only my.
You are seeking modification. Yes. You copy, IA copy ಕೊಟ್ಟಿದ್ದೀರಾ ಅವರಿಗೆ?
ಇಲ್ಲ ಕೊಡ್ಲಿಲ್ಲ.
ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
Yes, give this matter on 21st.
Serial number 21, Chandrakant Argole for petitioner.
My lord, your lordships, my lord, observed that this is only a recommendation.
Interim order to be extended and not idea. Interim order. Yes.
There is only a recommendation to the state government for removal. And therefore, your lordships, you only issued notice. Now the state government, my lord, has passed an order of removing the petitioner from service. And therefore, I am before this court, my lord, along with the IA for stay of that order. And it is covered by the decision of this honorable court, my lord, which I have produced along with my writ
What is
petition.
that you are challenging here?
I am challenging the recommendation, my lord, along with the petition. And the state
Has
government, my lord, has passed an order now, the copy of which I have produced along with the IA at page 98. Wherein, my lord, without a discussion, my lord, there is no inquiry is also held, my lord.
Petition ಹಾಕಿ challenge ಮಾಡಿ.
ಅದನ್ನೇ ಹಾಕಿ.
ಎಲ್ಲಿ ಹಾಕಿದ್ದೀರಿ? Amendment petition ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, ಇದು ಈ petition ನಲ್ಲಿ I have sought for stay, my lord.
No, first you have to be challenged by amendment, then you sought for an stay. We cannot quash that without challenging that.
True, my lord, true.
You, along with that, you sought for an stay. Amendment along with the stay, we will consider that.
Your lordship, kindly, he will be relieved of his duties, my lord. Tomorrow itself, I will do that.
To do it, you do that, then we'll say, yes. You
Because
file
there is a stay, my lord. This is fully covered by the decision of this
No, that
honorable
is
court,
true.
my lord.
That order which you want to stay, first it should be challenged by filing an amended petition.
Tomorrow it may continue.
Any days, yes. At the request, leave this matter after 2 days.
Tomorrow, my lord.
Application ಹಾಕಿ ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು.
ಕೊಡ್ತೀನಿ, ನಾಳೆನೆ ಕೊಡ್ತೀನಿ, ಅದಕ್ಕೇನಿಲ್ಲ. ಯಾಕಂದ್ರೆ ಅವ್ರನ್ನ ರಿಲೀವ್ ಮಾಡ್ಬಿಟ್ರೆ ತೊಂದ್ರೆ ಆಗುತ್ತೆ, ಅದಕ್ಕೋಸ್ಕರ. Day after tomorrow, my lord, it appears there is a holiday. Tomorrow, my lord, I will see that. Today itself, my lord, I will see that it is a copy served on the other side.
Yes, leave this matter on 12th, yes. 12th, you have to file it in that counter. Yes. Instead of filing an IA, you could have filed an amendment, Mr. Yes.
Serial number 22, Ranganatha Choice for petitioner.
Appear for the petitioners. Petitioners are all persons working in the Sanjay Gandhi Institute in various posts for more than 15 years. They are seeking for regularization of their services covered by decision, my lord, and presently seeking for an interim order that they should not be terminated, because similar matter annexure Q, page number 140, my lord, in respect of university employees, the court has granted an interim order of stay of termination. They have to continue the applicant till the pending disposal of the 15-20 ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿದೆ, ಎಲ್ಲ ರೆಗ್ಯುಲರ್ ಪೋಸ್ಟ್ಸ್ ವರ್ಕಿಂಗ್ as regular employees in the Sanjay Gandhi institution.
What is that, you are all working as a daily wages employee?
ವೇಜ್ ಅಲ್ಲ ಟೆಂಪ್ರರಿ ಇವಾಗ ಮಿನಿಮಮ್ ಪೇ ಸ್ಕೇಲ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಮೆಲಾಟ್ ಫಾರ್ ಒನ್ ಅನೆಕ್ಷರ್ ಬಿ ಮೆಲಾಟ್. ದಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕನ್ಸಾಲಿಡೇಟೆಡ್ ಸ್ಯಾಲರಿ ಕೊಡ್ತಾ ಇದೆ 3000 ಅಂತ ಅಲ್ಲಿಂದ ರಿವೈಸ್ ಮಾಡ್ತಾ ಬಂದಿದ್ದಾರೆ. ರೆಗ್ಯುಲರ್ ಪೇ ಸ್ಕೇಲ್ ಕೊಟ್ಟಿಲ್ಲ, ರೆಗ್ಯುಲರೈಸೇಷನ್ ಮಾಡಿಲ್ಲ. 15-20 ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿದೆ ಎಲ್ಲ.
No, as on today you are working.
I am working, but before I come to the court, sir, there is likelihood of termination. Every year renew ಮಾಡಿ terminate ಮಾಡ್ತಾರೆ. Similar case in the university or lordship that granted.
Counsel for the petitioner submits that. The petitioners are working as a daily wages employee. They are seeking for regularization.
Daily wage ಅಲ್ಲ consolidated salary, consolidated.
On, they are working as an
Consolidated
on consolidated salary.
Ha.
They are approached this court for regularization. In this event, respondent may discontinue the service of the petitioner. In view of the above, respondents are directed to not to discontinue the service of the petitioner till next date of hearing. Government advocate is directed to take notice for 1 and 2.
Direct to take. Third, I will serve this counsel on Sanjay Gandhi.
Who is that counsel? Rajiv
Counsel, I
Gandhi
will find out, my lord. Exact.
is emergent notice to respondent number 3. ಏನಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್? awaiting service of notice to ಆಗಿದೆಯಾ ನೋಟಿಸ್ ಸರ್?
ಇದು serial number 22.
22. What is that office objection? Better copy of the annexures. Yes, submission is accepted of subjection.
Serial number 23, Ravi Kumar Abhiyar.
Referring the petitioner in this case.
What is that office objection?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಏನಂದ್ರೆ ನಾನು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ನನಗೆ ಥ್ರೆಟ್ ಇತ್ತು ಗೆಸ್ಟ್ ಲೆಕ್ಚರ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೆ, ಬಟ್ ಇವಾಗ ಅದನ್ನ ಅಪಾಯಿಂಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡೋದು.
Yes.
ಮುಂದೆ ಏನಾರ ಮಾಡಿದ್ರೆ
Government advocate is directed to take notice. Respondent number 1, 2. Murarji Desai Residential School, he will take.
No, I'll take.
So and so is directed to take up here for 3. Counsel for the petitioner has filed a memo seeking leave of this court to withdraw. Memo is taken on record. The above petition is dismissed.
Serial number 24, Satish K for petitioner.
For petitioner, my lord. I
Yes.
file memo for withdrawal.
Learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw this writ petition. The memo is taken on record. The above writ petition is dismissed as withdrawn.
Pending applications.
All pending applications are disposed.
Serial number 25, Ranganatha H. Joyce for petitioner, government advocate.
Appeared for the petitioner, my lord. Matter relating to the transfer from one institution to another institution which was not approved, for which I earlier approached this court. I was directed to file an appeal under section 130. I filed it. That appeal is rejected, my lord. That's all. No intermod. No intermod, my lord.
No, that office objection has to be complied, Mr. Non-compliance of that office objection.
I will do it in the course. By next week, I will do it. 2-3 days.
Yes, awaiting service of notice to R4. In the meantime, petitioner is directed to comply that office objection.
Serial number 26, Madhusudan MN for petitioner, government advocate.
for petitioner.
I have,
Awaiting
I-
service of notice to R3.
I am filing,
Will take notice to R3.
wakalat for 5 and 8. Today I am filing the wakalat in the counter. my lord.
Date may be fixed, my lord. Mandamus.
What is this matter?
Mandamus, my lord. Release of salary, my lord. They have been permanent, my lord.
My lord, one submission. The dispute is between the petitioners and the Raja Vakaligara Sangha. On a previous occasion, in a similar matter of termination, your lordship had said that place it before somebody, some other bench. I don't have any objection, but this, I'm just bringing it to your lordship's notice.
Which is that matter?
5120 of 25.
What is that matter?
That is termination of employment.
That is termination of employment.
Okay.
Here it is only seeking for an this thing.
Salary they have, actually what the problem is, my lord, by mistake, without realizing that most of them are not eligible, they have
passed an order granting regular scale. But now we will have problem with the university because
Yes,
most of them
so-and-so.
are ineligible.
So and so is undertake to appear for respondent number
5 to 8
to
presently.
8.
5 and 8.
Huh?
5 and 8.
5 and 8. What about 3?
We are yet to receive the wakalat. 3 is government or something like that.
No, 3 is
He is General Secretary, Rajya Wakaliga Sangha.
Then 3 also I will also.
3.
I'm
3, 4, 5, 6.
3 to 6 ಆಗ್ಬೇಕಲ್ಲ
3 to 6 ಆಗುತ್ತೆ ಅವನು.
ನೀವೇನಾ? Yes, so and so is undertake to 3 to 6. Office is directed to show his name. Not before, leave this matter before other bench. Yes.
Cell number 27.
Lodging matter.
A. Kiran Babu, petitioner, party in person.
Yes.
So about to afternoon.
What is this office objection you have to comply, Mr.
Precisely one officer. Only one officer. For that, in that context, I moved a memo. Kindly pass it over.
What is that office objection?
That is,
Form A and B to be furnished.
yes, I moved a memo for that.
Where?
It is there in the file.
No, form you have to be obtained there.
That is exactly for that context.
ತಗೊಂಡಿದ್ದಾರಾ permission?
It is there in the memo, in the file itself.
You have to appear before the committee and take in a permission.
I know that for that, there is a rule here, my lord. I invoke this rule. Kindly pass it.
What is that rule?
Rule 10 of in-person matter. I've been here before this honorable court for past almost 18 years. So I know the decorum of this court. So
Decision of the court to permit the litigants or other persons to appear in person, notwithstanding anything contained this rule, concerned before this. It may be directions to permit to appear and conduct the proceedings in, yes, it is discretion of the court.
yes, I
You
moved a
obtain a
memo.
permission, yes,
I moved a memo. Kindly pass an order in context with the memo, my lord.
yes.
Then, and I'm a lawyer myself, my lord. So
This
this the
honorable
question,
court
this
may please
petition
to
in,
determine whether the termination of the employment of the petitioner by the respondent is unconstitutional void. What is the termination?
yeah, that is no cause, no reason, my lord.
Albert Package Golosty Private Limited is in a private company. How
Correct,
can you
exactly.
maintain a writ?
Correct, exactly. Kindly pass it over in the afternoon. I thought I'll argue in context with the maintainability. Precisely, just few minutes. Afternoon.
No, you take permission, I will reject your memo. Yes. Petitioner is in a party in person. Which is that rule which permits for you to take?
Rule 10,
Huh?
rule 10. It is there. I gave some.
No. This is court for permitted the litigants to appear in the person. It is for me to examine. But which is the rule which party in person has to be taken a permission?
That is somewhere
Certificate of
in
party in persons committee, yes. As per that rule. Rules for presentation and conducting that proceedings in person by parties. They have to obtain presentation proceedings certificate from that committee. The petitioner party in person has filed a memo seeking an exemption. The memo is rejected. Yes, you take a permission and come. Yes.
Hearing interlocutory application matter, serial number 28, Murli N for petitioner, connected matter, TP Rajendra Kumar.
Appearing for the petitioner, my lord, in all these three writ petitions, may I just walk through the facts of the case, my lord, to refresh?
My lord, serial number 48 also similar matter, my lord.
Amendment ಇಲ್ಲ ಅದೆಲ್ಲ
Pick up together, my lord.
Serial number?
48, my lord.
Now you are in 28. Yes, what you want?
Lord, I have filed an application for amendment and also a direction. May I just walk through the facts of the case, my lord, to refresh your lordship's memory?
On the last date of hearing, there is an interim order to continue their services, provided if there is a workload. Your lordship has passed an order. Now he seeks, he files an application seeking for, they were relieved from the duties, seeking an application, filing an application for quashing of that order and the stay of that stay of that relieving order. Although it will, my lord, it may not require at all. And another application to pay the salary for this period. This period they are not entitled. Your lordship has heard the matter and artist request is adjourned. These two IAs may be considered along with the.
You file an objection to that IA, you will hear that.
Before that, my lord, I'll satisfy your lordship. What happened in the?
No, now you have filed an IA.
Yes.
They have a right to file an
They
objection.
were required to file objection, and I was directed to file a memo showing that there is sufficient workload, which I'll satisfy your lordship.
Workload, we are
I have a
not,
memo, my lord. I have a
disputing at all.
memo.
You have filed. They have to be answered.
Yes.
Please.
It is correct or not.
Yes.
Please.
Can I accept what you said that? Unless they have to be answered that.
Lord, I bow down, my lord. What I submit, my lord, they were required to file objection by this date. Of course, my lord, if they want to time, my lord, I will not come in that, my lord. There's no difficulty. My only apprehension, my lord, there are two aspects. One, my lord, the relieving order notwithstanding your lordship's order. They have relieved me, my lord. Your lordships have passed an order on 27/6.
Yes.
On 30th, my lord, they have passed an order to relieve me from service, notwithstanding your lordship's order and notwithstanding there's sufficient workload.
File a contempt.
Lord, if I file a contempt, your lordships are aware, my lord, I will be certainly cornered, my lord.
This is the first time in this roster,
Please, my lord.
all are saying that apprehended to go to the contempt court and saying that I have filed an application for
Ground
modification.
reality, my lord.
No, actually,
Lord, if I file a contempt, my lord, I will be cornered. I'll be earmarked
No,
to
that is-
ensure that
no,
my
Mr.
service will not be, my lord, regularized.
advocate has to see that, to maintain decorum of this court, to see that this court order has to
Please,
be
Lord.
compliant. You have
Completely
to go
bow
to
down.
that
Please,
contempt
please.
court and to teach that who has disobeying this order.
Please,
I
Lord.
can't file in a contempt.
Please, my lord.
My
Lord,
order is violated. You have sought, I have granted. My order is violated, but I can't do anything. You are not going to that contempt court. Everybody is
Therefore, my
coming
lord,
to-
I sought for an alternate remedy to challenge that order because it's a continuous cause of action. I need not file even a separate writ petition. That's a continuous.
application, you file an objection, we'll see. He is saying that
Contempt ಆಗೋದೇ ಇಲ್ಲ ಇದು.
There-
ನಮ್ಮ order clear ಆಗಿದೆ.
There is a sufficient workload, my lord. I have a memo in my hand.
I said, if there is a workload,
Please.
he is saying that
May I
there is a
just-
workload.
Workload ಯಾವಾಗ ಅಂದ್ರೆ admissions ಆದ್ಮೇಲೆ ಗೊತ್ತಾಗೋದು ಹುಡುಗರು ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಅಂತ. ಅವ್ರಿಗೆ
Then how can
workload
they
ಇದೆ,
even
ಇದೆ
relieve him
ಅಂತ.
from the
I don't
from
know how you get
service?
information.
Sir, counsel,
If that is the, please kindly record his submission, my lord.
he has to establish to me, convince me showing that,
My lord, I have,
how can you come to know that there is a workload? You have to say there is no workload. Then I will decide that. You file that on the basis he has been relieved because there is no workload.
Lord, in fact, in my application for amendment, I have also annexed another document showing that there is a direction by the respondent university directing me to conduct invigilation, directing me to conduct examination, directing me to go to the counter and collect the fees. These are part of workload, my lord. It's not the case that
You are guest lecturer or collecting the
assistant
fees?
lecturer, my lord, I have,
Lecturer collecting the fee, you are happy.
they have passed in order. They have passed in order, my lord.
They have passed an order, you are in it.
Lord, I have a
Professor
professor ranking.
teaching that students, you are asking to do the.
I'm
clerk
so
work,
grateful
you
that
are
your
happy.
lordships have questioned this.
Yes.
This is the
You say
state
no.
of affairs, my lord.
You say, no, I am in a guest lecturer, I have to give teachings to the students.
Lord, I'm at the mercy of the university, my lord. I fairly submit.
Yes. Yes, you, when will you file it, Mr.?
For 10 days, my lord.
Yes, this matter. You have served the copy to him.
Yes, yes.
Well in advance, my lord.
Yes. This matter on 14th.
14, grateful, my lord. So
Yes,
grateful.
you file it, we'll see.
Serial number 29, Srinandan K for petitioner, Anupama Hegde, Balasubramanya KM, connected
Appear.
matter.
20?
Appear for the
29,
respondent.
sir.
Yes.
I
Please,
really
Manoj.
apologize, my lord, the objections to IA, I could not file in the office, it's ready, I will file in.
Amendment.
I will file it in the office, it's ready, I served a copy.
Just received, my lords.
Yes. Learned counsel for the respondent prays weeks time to file objection to IA 1 of
I
2025.
respondent number 4.
4, yes. Respondent number 4, yes.
No, it's 20th, my lords.
You have now rejoined to file. No, you have you seen that what he has filed?
Just,
Yes.
please, my lords.
Yes.
I oblige, my lords.
Serial number 30, Manjunath Rao.
Any
Constable,
date, my lords?
petitioner.
My lords.
Yes, this matter on 28th, yes,
28.
28, my lords.
yes.
Please, my lords.
Serial number 30, Manjunath Rao. Constable,
For the petitioner, my lord, last date of hearing, my lord, your lordships has directed the second respondent to produce the internal
inquiry conducted by them as stated in the order passed by the first respondent, my lord.
What is this matter, Mr.?
This is a issuance of the article charges, my lord. He was taken charge, my lord. He was worked there from
My lord, 8 serious allegation against the petitioner. my lord.
last occasion, my lord, kindly refresh the, my lord. Last occasion, in the matter is arguing, my lord, your lordship to direct the second respondent. That is, there was a internal inquiry and he has undertook to produce the document, my lord.
Brief facts kodi,
Yes,
facts.
sir.
What is this matter?
Article of charges framed by the respondent number 2 against the petitioner. My lord.
Where is that articles of charges?
My lord, article of charges in
Annexure H, my lord.
annexure H. My lord.
What are the allegations, Mr.?
My lord, 8 serious allegation against the petitioner. My lord. That allegation number 1, my lord, in page number 102, my lord. As on ಮಂಜುನಾಥ್ ಹಿರಿಯ ಸಹಾಯಕರು ತೊಗರ್ಸಿ ಶಾಖೆ ಆದ ನೀವು ಈ ಹಿಂದೆ ದಿನಾಂಕ 8/4/21 12/9/23 ಶಿವಮೊಗ್ಗ ತಾಲೂಕು 2ನೇ ವೃತ್ತದ ಕ್ಷೇತ್ರಾಧಿಕಾರಿಯಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾಗ ಜಾವಳ್ಳಿ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರಿ ಸಂಘ
ಇದೆಲ್ಲ ದುರುಪಯೋಗ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ
yes my lord.
ಇದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹೋದ್ರಾ?
They filed the appeal before the JRCS. my lord.
Dispute.
Yes, JRCS also reject their order.
This is only a charge memo.
Article of charges, my lord.
Against that, has he filed an objection?
Yes, filed.
Has
my
been,
lord.
has been
my lord.
submitted.
Objection ಫೈಲ್ ಆಗಿ ಇವನ್ ಎನ್ಕ್ವೈರಿನೂ ಸಹಿತ ಕಂಡಕ್ಟ್ ಆಗ್ತಾ ಇತ್ತು, ಡೊಮೆಸ್ಟಿಕ್ ಎನ್ಕ್ವೈರಿ
ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಸ್ವಾಮಿ. ಈ ಅಲ್ಲೇ ಒನ್ ಆಫ್ ದಿ ವಿಟ್ನೆಸ್ ಸಹಿತ ಎವಿಡೆನ್ಸ್ ಆಗಿತ್ತು. ಇನ್ ದಿ ಮೀನ್ ವೈಲ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಸ್ಟೇ ಆರ್ಡರ್ ಇಂದ ಅದು ಸ್ಟಾಪ್ ಆಗಿದೆ.
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಸ್ಟೇ ಇದೆ
Lord.
Melod,
Annexure N, he
charges
goes
are my-
before the annexure N, he go before the JRCS, my lord. JRCS refused to grant
It's
an
very-
interim order, my lord.
ಆಯ್ತು, ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ ಬಂದಿದ್ದಾರೆ.
ಅಲ್ಲಿಂದ KT ಗೆ ಹೋಗ್ತಾರೆ.
ಅಲ್ಲೂ ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲೂ ಕೊಟ್ಟಿಲ್ಲ, ಇಲ್ಲಿ ಬಂದು
ಇಲ್ಲಿ they are the
come on, interim order, my lord, not the final order.
Melod, may kindly go through that observation of the JRCS. It's very clear. Page number 142, my lord.
No, on what ground you have rights to grant an interim order? What is that main ground?
My lord, this is charges are pertaining to be before the he took charge, my lord. This is charge, my lord. Kindly see the, my lord, annexure. I have produced the two inquiry.
Kindly, page
based-
number 142.
ಆಯ್ತು ರೀ, ಅವ್ರು ಮಾಡ್ತಾ ಇದಾರೆ.
Yes, my lord. Kindly see the, my lord, annexure. These are the inquiry conducted under section 64 and 65 of the Act, my lord.
Annexure.
Annexure E, my lord. ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪೇಜ್ ನಂಬರ್ 33, my lord. ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘ ನಿಯಮಿತ ಜಾವಳಿ ಶಿವಮೊಗ್ಗ ಇವರ ಕಲಮ 64 ವಿಚಾರಣಾ ವರದಿ. The basis of this issuance of article charges, my lord, only this report, my lord. This report and subsequent report, 65 report, my lord. Kindly see the, my lord. This is report pertaining to year 2018-19 and 2019-20, my lord. That can be seen by now page number 32, 38, my lord. 38. This report, my lord, is only pertaining to year 2018-2019. That is the second paragraph ಹೇಳ್ತಾರೆ, my lord. PTK.
ಬಂದಿದ್ದು
ನಾವು ಬಂದಿದ್ದು they
4/4
2023 ವರೆಗೂ is in duty.
ಎಲ್ಲಿದೆ 64 ಎನ್ಕ್ವೈರಿ ಫಾರ್
ಅಲ್ಲ, he has suppressed the material facts. Now I produce, my lord. ಅದರಲ್ಲ ಅರ್ಥನ ಇವರು ಕೋರ್ಟಿಗೆ ಗಮನಕ್ಕೆ ತರ್ತಿದ್ದಾರೆ.
ಕಾಪಿ ಕೊಡಿ.
ಇದು ಕಮೆಂಟ್ಸ್ ಆಗಿದ್ದೆ ಇದೆ. The inquiry report comments, inquiry 64 inquiry comments ಆಗಿದ್ದೆ 29/2021. He is taken charge on 4/4/2021. So in earlier ಇವ್ರು ಹಿಂದೆ ಇದ್ದಂತವ್ರ ಮೇಲೂ ಸಹಿತ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಿದೆ, ಇವ್ರ ಮೇಲೂ ಸಹಿತ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಿದೆ.
See,
what I produced that 64 inquiry ವಿಚಾರ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ವಿಚಾರಾಧಿಕಾರಿಗಳು 5 ಆರೋಪಗಳಿಗೆ ವಿವಿಧ ದಿನಾಂಕಗಳ ವಿಚಾರಣೆಯನ್ನು ದಿನಾಂಕ 11/11/21 ಪ್ರಾರಂಭಿಸಿ 30/6/23 ವಿಚಾರಣೆಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸುತ್ತಾರೆ. ಅದರಲ್ಲಿ ಅಬ್ಸರ್ವೇಷನ್ ಆಫ್ ದ 64 ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಕ್ಲಿಯರ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ರು. ಹಣಕಾಸು ನಿರ್ದೇಶನ ಅಂತದ್ದು ಹಣಕಾಸು ಪೂರೈಸುವ ಬ್ಯಾಂಕಿನ ಮತ್ತು SS ಮಂಜುನಾಥ್ ಇವರುಗಳ ಕರ್ತವ್ಯ ಲೋಪಗಳು ಮತ್ತು ಹುದ್ದೆಯ ಕರ್ತವ್ಯ ಜವಾಬ್ದಾರಿ ನಿರ್ವಹಿಸಲು ವಿಫಲವಾಗಿರುವ ಬಗ್ಗೆ ಸೂಕ್ತ ಕ್ರಮವಿಡಲು ಸದರಿ ನೌಕರರ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರವನ್ನು ಶಿವಮೊಗ್ಗ ಜಿಲ್ಲಾ ಶಿವಮೊಗ್ಗ ಇದರ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕರಿಗೆ ವರದಿಸಿದೆ. As per their 64 enquiry report in the board meeting,
ಎಲ್ಲವೂ 18, 19, 19, 20 ಇರ್ತಲ್ರಿ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ.
It is not allegation McKendy goes to that article of charges. ಅವರಿದ್ದ ಆದ ನಂತರನೂ ಸಹಿತ 21, 22 ಸಹಿತ ಇವರು ಸಂಘಕ್ಕೆ ವರದಿ ಯಾವುದೇ ರೀತಿ ಬಂದಿಲ್ಲ. ಈಸ್ ಮೇನ್ ಪರ್ಸನ್ ಫಾರ್ ಆಗಿರುವಂತ ಅವ್ಯವಹಾರನ ಮೇನ್ ಬ್ರಾಂಚ್ ಗೆ ರಿಪೋರ್ಟ್ ಮಾಡಬೇಕಾಗಿರುವಂತದ್ದು ಇವರು ಸಹಿತ ಮಾಡಿಲ್ಲ. ಫರ್ದರ್ ಅಲಿಗೇಷನ್ಸ್ McKendy goes to that Melad article.
No, that is not that charges that after he has taken a charge, he has not reported. Your allegation is that he has committed a misconduct of.
No. McKendy goes to that allegations Melad.
Yes.
Allegations McKendy article of charges McKendy goes to that.
Annexure H.
Annexure H.
ನೀವು ಹಿಂದೆ 21, 23 ಶಿವಮೊಗ್ಗ ತಾಲೂಕು ವೃತ್ತದಲ್ಲಿ ಕೃಷಿ ಸಹಾಯಕ ಸಂಘ ಕೈಲಾಗಳು ಅಧಿಕಾರವನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು. ಹೇಳಿ ಓದಿ.
ಮಂಜುನಾಥ್ ಇವರು ನೀವು ಈ ಹಿಂದೆ ದಿನಾಂಕ 8/4/21 12/9/23 ಶಿವಮೊಗ್ಗ ತಾಲೂಕು 2ನೇ ವೃತ್ತದ ಕ್ಷೇತ್ರಾಧಿಕಾರಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ ಜಾವಳಿ ಕೃಷಿ ಸಹಕಾರ ಸಂಘದ ಅಧಿಕಾರವನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಸಂಘದ ಬೈಲಾಮ್ ನಿಯಮ ಮೀರಿ ಸಂಘದಿಂದ ಕೆಸಿಸಿ ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲವನ್ನು ವಿತರಿಸಿರುತ್ತಾರೆ. ಹಲವು ಸಂದರ್ಭಗಳಲ್ಲಿ ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲವನ್ನು ನೀಡದಿದ್ದರೂ ಸಹ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಸಾಲ ಇರುವುದು ಕಂಡು ಬಂದಿದ್ದು ಸದರಿ ಸದಸ್ಯರು ಈ ಬಗ್ಗೆ ಆಕ್ಷೇಪ ವ್ಯಕ್ತಪಡಿಸಿರುತ್ತಾರೆ. ಈ ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲ ನೀಡಿಕೆಯಲ್ಲಿ ಸಂಘವು ಕೃತ್ರಿಮವಾಗಿ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ನಂತರ ಸಾಲ ಮರುಪಾವತಿ ವರ್ಷಾಂತಕ್ಕೆ ಜಮಾ ಪಡೆದು McKendy ಅಬ್ಸರ್ವ್ ಮರುಪಾವತಿ ವರ್ಷಾಂತಕ್ಕೆ ಜಮಾ ಪಡೆದು ಬಾಕಿ ಇಲ್ಲದಂತೆ ಮಾಡಿರುವುದು ಸಂಘವು ತಾತ್ಕಾಲಿಕ ಹಣ ದುರುಪಯೋಗ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದೆ. ಇಟ್ ಈಸ್ ಆನ್ ಡೇಟ್ ಆಫ್ ಇವರ ಅವಧಿಯಲ್ಲಿ ಆಗಿರುವಂತದ್ದು. ಅಂದರೆ ಈ ಕೆಳಗಿನ ಪ್ರಕರಣ ಸದಸ್ಯರು ಸಾಲ ಪಡೆದಿದ್ದರೂ ಅವರ ಹೆಸರನ್ನು ನಮೂದಿಸಿದ್ದು 64ರ ವರೆಗೆ ತಿಳಿಸಲಾಗಿದೆ.
Kindly say, Milord. This is report, Milord. Then what is allegation?
Thing.
Yes.
To initiate that departmental inquiry, 64 inquiries must.
Yes, please.
Which law says?
That is
so that you can't initiate.
No.
No. I want that without that 64 inquiry, can it be initiated? Then
where is allegation, Milord?
No, 64 inquiry is in a reference saying that these are all done even after you come to that. You have not taken, these are all that. See, just because there is a reference of 64 in 20.
Yes, Milord. That's why, Milord. That's kindly see the Milord. That's the allegation.
Allegation against you
yes,
is that 8/4/2021 to 12/9/2023.
Yes.
There was a misappropriation.
No. There was no notice, Milord.
Milord, may I request, Milord?
Kindly, Milord.
The inquiry is conducting, Milord. He can submit that submission. What is submitting before this court? They can submit there only. They can.
So for article
discharge him, Milord.
Kindly see, Milord. So for the what is the read the allegation, Milord? The same kind of allegation is referred in the 64. That is pertaining to years 2007 and 17, Milord.
No, I am not deciding that whether allegation is correct or not. The charges is during your term. There is a
no. Yeah, there is no misconduct.
Our munde heli nan munde
kindly see annexure B kindly see, Milord. Annexure B. After taking a charge, Milord, there are lapses are committed by the previous incumbent. I have reported, Milord, on the basis of my reporting, Milord, they have conducted the inquiry. Kindly see, Milord. The what is the is read, Milord? No, article something else. ಒಂದು ನಿಮಿಷ ನೋಡಿ.
ಓದ್ರಿ.
ಆರೋಪ ಒಂದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅದು. ಶ್ರೀ ಮಂಜುನಾಥ್ SS ಹಿರಿಯ ಸಹಾಯಕರು ತೋರಸ್ ಯಾಕೆ ಅವರು ನೀವು ಈ ಹಿಂದೆ ದಿನಾಂಕ 8/4/21 12/9/80 ವರೆಗಿನ ಶಿವಮೊಗ್ಗ ತಾಲೂಕು 2ನೇ ವೃತ್ತದ ಕೇತಾರಿಗಳ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾಗ ಜಾವಳ್ಳಿ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘವು ಅಧಿಕಾರವನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಸಂಘದ ಬೈಲ ನಿಯಮಗಳನ್ನು ಮೀರಿ ಸಂಘದಿಂದ KCS ಮತ್ತು ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲಗಳನ್ನು ಸದಸ್ಯರುಗಳಿಗೆ ವಿತರಿಸುತ್ತಾರೆ. ಹಲವು ಸದಸ್ಯರಿಗೆ ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲವನ್ನು ನೀಡದಿದ್ದರೂ ಸಹ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಸಾಲ ಇರುವುದನ್ನು ಕಂಡು ಬಂದಿದ್ದು ಸದರಿ ಸದಸ್ಯರು ಈ ಬಗ್ಗೆ ಆಕ್ಷೇಪ ವ್ಯಕ್ತಪಡಿಸಿದ್ದಾರೆ. ಈ ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲ ನೀಡಿಕೆಯಲ್ಲಿ ಸಂಘವು ಕೃತ್ರಿಮವಾಗಿ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ನಂತರ ಸಾಲದ ಮರುಪಾವತಿಯನ್ನು ವರ್ಷಾಂತಕ್ಕೆ ಜಮಾ ಪಡೆದು ಬಾಕಿ ಇಲ್ಲದಂತೆ ಮಾಡಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ.
ಅಲ್ಲದೆ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಸದಸ್ಯರು ಸಾಲ ಪಡೆದಿದ್ರು ಸಹ ಈ ಹೆಸರಿನಲ್ಲಿ ಸಾಲ ಪಡೆದವರು ಕಲಂ 24ರಲ್ಲಿ ತಿಳಿಸಲಾಗಿದೆ. ಕೈಂಡ್ಲಿ ಸೀನ್ ಮೇಲೆ there are 8 persons. What they have stated, my lord, the 8%. The 8% my lord, they have obtained the loan. Kindly see, they have obtained the loan during the year 2017-2018, my lord. That has been reported in the 64 inquiry.
No, see.
Just a minute, man. I'll come there, my lord.
ಅದಲ್ಲದೆ
ಅಂತ ಹೇಳ್ತಾರೆ. ಇದು ಅಲ್ಲದೆ ಅಂತ
ನಿಮ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಆಗಿದ್ದಲ್ದನೆ ಮುಂದುವರೆದನು 64 ರಿಪೋರ್ಟ್
ಇಲ್ಲ ಹೇಳ್ತಾರೆ 8 ಜನ ಸಾಲ ಯಾವ ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ.
ನನಗೆ ಅರ್ಥ
ಕೈಂಡ್ಲಿ ಸೀ ಮೈ ಲಾರ್ಡ್, ಕೈಂಡ್ಲಿ ಸೀ 8 ಮೆಂಬರ್ಸ್
ಅವ್ರ ವಿರುದ್ಧನೂ ಸಹಿತ ಆಲ್ರೆಡಿ
ಲೆಟ್ ಮಿ ಆರ್ಗ್ಯುಮೆಂಟ್
ಅವ್ರ ವಿರುದ್ಧನೂ ಚಾಯಪ್ಪ ಈಸ್ ಅಗೇನ್ಸ್ಟ್
yes ma'am ಚಾಯಪ್ಪ ಅಂಡ್ ಮೈ ಲಾರ್ಡ್
ಆಯ್ತು. ಇದು ಓನ್ಲಿ ಎನ್ಕ್ವೈರಿಲಿ
ಅಲ್ಲ ಜಸ್ಟ್ 1 ಮಿನಿಟ್ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ನಾನು ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ
ತೋರಿಸಿ ಅವ್ರ ಮುಂದೆ
yes sir I have brought to the notice ಮಾಡ inspected the they have started inquiry my lord.
ಅವ್ರ ಮುಂದೆ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಮುಂದೆ you pointed out he may exonerated.
No, if the misconduct conducted during my period, I certainly face the inquiry. But this is my lord putting the previous, that is the 3 years back, my lord.
ನಿಮ್ಮ ಪೀರಿಯಡ್ ಅಲ್ಲೂ ಆಗಿದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ
ಇದ್ದಾರೆ ಅಷ್ಟೇ. I have given the
page number 142 of the JRCS rejection order. May kindly ಅದನ್ನ ಓದ್ಬಿಟ್ರೆ ಕ್ಲಿಯರ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಇದು ನೋಡ್ಬಿಡಿ.
Page number 142 of the rejection of
will vacate that interim order.
No, kindly my lord, just a minute. I will demonstrate how they have conducted issued the inquiry contrary to the rules, my lord. Just annex E, my lord.
My lord, 142 may kindly go through
that. Let me.
Yes.
Kindly say, my lord. Page number 45, which is mentioned in the article charges. Page number 1 or 2 ನಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿರೋದು. ಪೇಜ್ ನಂಬರ್ 45 kindly see ಮೇಲೆ 64 ಎನ್ಕ್ವೈರಿ ಪೇಜ್ ನಂಬರ್ ಈ ಕೆಳಕಂಡ ಪ್ರಸ್ತಾಪಿಸಿರ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಮಿಲಾರ್ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಮಿ
ಯಾವ ಪೇಜ್ ನಂಬರ್?
ಪೇಜ್ ನಂಬರ್ 45, that is 64 ಎನ್ಕ್ವೈರಿ 45.
No, 64
ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ ಸೇಮ್ ಅಲಿಗೇಷನ್ ಮಾಡ ದಿಸ್ ಇಸ್ ಪರ್ಟೈನ್ ಟು ಇಯರ್ 2. ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ನೋಡ್ಬಿಡಿ ಸ್ವಾಮಿ 2 ನಿಮಿಷ ನೋಡ್ಬಿಡಿ.
ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್
ಇಲ್ಲ ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿಲ್ಲ. ನಾನು ಸಾಲ 2017 2018 ಅವಾಗ ಕೊಟ್ಟಿರೋದು ಸೇಮ್ ಪರ್ಸನ್ ಮಂಜುನಾಥ್ ಎನ್ ಚಂದ್ರಪ್ಪ. ಜಸ್ಟ್ ಎ ಮಿನಿಟ್ ಕೈಂಡ್ಲಿ ಮೇಲೆ
ಕೌನ್ಸಿಲ್ 64 ಎನ್ಕ್ವೈರಿಲಿ ಹಿಂದೂ ಆಗಿದೆ.
ಇಲ್ಲ ನಮ್ಮ ಪೀರಿಯಡ್ ಅದಲ್ಲ, ಬಿಫೋರ್ ಮೇಡ ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್ ಮೈ ರಿಪೋರ್ಟ್
64 ಎನ್ಕ್ವೈರಿ ಪ್ರಕಾರ ಹಿಂದೂ ಆಗಿದೆ. ನೀವು ಬಂದ ಮೇಲೆ
ಇಲ್ಲ ಆ ರಿಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ. ದಟ್ ನೌ ಮೈ ಲಾರ್ಡ್ he has produced the 64 inquiry. The kindly see what is attached here.
No, I am not.
That is
ಅದು ನಿಮ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಆಗಿದೆಯೋ ಇಲ್ಲೋ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಚಾರ್ಜ್ ಮಾಡಿದ್ದಾರೆ. ನೀವು ಅಲ್ಲಿ ಎನ್ಕ್ವೈರಿ
ಇಲ್ಲ ನನ್ನ ಮೇಲೆ ಚಾರ್ಜ್ ಮಾಡೇ ಇಲ್ಲ ಅವರು. ನನ್ನ ಮೇಲೆ ಚಾರ್ಜ್ ಮಾಡೇ ಇಲ್ಲ
ಅಂತ ಕಂಡಕ್ಟ್ ಮಾಡಬೇಕು. ಎಲ್ಲರೂ ನಮ್ಮ ಮುಂದೆ ಬಂದು ಹೇಳಿದ್ರೆ ಆಯ್ತಲ್ಲ.
ಅಲ್ಲ ಕೈಂಡ್ಲಿ ದಟ್ಸ್ ಮೇಲೆ ಅನ್ನೆಕ್ಸರ್ ಬಿ kindly be seen, my lord.
ಅನ್ನೆಕ್ಸರ್ ಹೆಚ್ ಚಾರ್ಜ್ ಇದೆ against him.
Let me tell ಅನ್ನೆಕ್ಸರ್ ಬಿ kindly be seen, my lord. I have given detail reply.
Yes,
ಅನ್ನೆಕ್ಸರ್ ಬಿ ಮೇಲೆ
ರಿಪ್ಲೈ ನಾನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ ಜಸ್ಟ್ ಯಾಕೆ ನಾನು ಹೇಳ್ತಿದ್ದೆ ಅಂದ್ರೆ ಪೇಜ್ ನಂಬರ್ 26 ಅನ್ನೆಕ್ಸರ್ ಬಿ ಮೇಲೆ.
Yes, your reply to that charge memo.
ಅಲ್ಲ my complaint after taking the charge, my lord, I have made the complaint to the second respondent stating that some lapses are coming. Annexer B, my lord. ಪ್ರಾಥಮಿಕ ಸ್ವತ್ತಿನ ಸಹಕಾರ ಸಂಘ ಪೇಜ್ ನಂಬರ್ 26, my lord. Annexer B. ಪ್ರಾಥಮಿಕ ಸ್ವತ್ತಿನ ಸಹಕಾರ ಸಂಘ ಜಾವಳಿ ಶಿವಮೊಗ್ಗ ತಾಲೂಕು ಸಂಘಕ್ಕೆ ಭೇಟಿ ನೀಡಿದ ಸಂದರ್ಭದಲ್ಲಿ ಕಂಡು ಬಂದ ನ್ಯೂನತೆಗಳು ಹಾಗೂ ಅಡಿಕೆ ದಾಸ್ತಾನದ ಅಡಮಾನ ಸಾಲವನ್ನು ಅವ್ಯವಹಾರದ ಕುರಿತು ಆಫ್ಟರ್ ಟೇಕಿಂಗ್ ಚಾರ್ಜ್ he has made the report, madam. ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಶಿವಮೊಗ್ಗ 2ನೇ ವೃತ್ತದ ಕ್ಷೇತ್ರವಾದ ನಾನು ದಿನಾಂಕ 24/8/70 ಜಾವಳಿ ಪ್ರಾಥಮಿಕ ಸಾಲ ಪತ್ತಿನ ಸಂಘಕ್ಕೆ ಭೇಟಿ ನೀಡಿದ್ದು, ಭೇಟಿ ನೀಡಿದ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಸಿಬ್ಬಂದಿ ಹಾಜರಾತಿ ಪುಸ್ತಕವನ್ನು ಪರಿಶೀಲಿಸಿ ತದನಂತರದಲ್ಲಿ ಸಂಘದಿಂದ ಸದಸ್ಯರುಗಳಿಗೆ ನೀಡಿದ ಸಾಲದ ಅರ್ಜಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಸಾಲದ ಅರ್ಜಿಗಳನ್ನು ಅಪೂರ್ಣ ಮಾಹಿತಿಗಳನ್ನು ಭರ್ತಿ ಮಾಡಿರುವುದು ಗಮನಿಸಿರುತ್ತೇನೆ. ಬಂಗಾರದ ಅಡಮಾನ ಸಾಲಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬಂಗಾರದ ಆಭರಣಗಳ ಒಟ್ಟು ತೂಕ, ಆಭರಣಗಳ ವಿವರ, ಸ್ಥೂಲ ತೂಕ, 1 ಗ್ರಾಂ ಬೆಲೆ ಮತ್ತು ಇವುಗಳ ಮಾಹಿತಿ ಅರ್ಜಿಗಳಲ್ಲಿ ಭರ್ತಿ ಮಾಡದೆ ಸಂಘದಿಂದ ನೇಮಿಸಲ್ಪಟ್ಟ ಅಪ್ರೈಸರ್ ಅನ್ನು ಸಹಿ ಪಡೆಯದೆ ಸಾಲಗಾರರಿಗೆ ಸಾಲ ನೀಡಿರುತ್ತಾರೆ. ಸಾಲದ ಅರ್ಜಿಗಳನ್ನು ಸಾಲಗಾರರ ಹೆಸರು, ಸಾಲ ಪಡೆದ ದಿನಾಂಕ ಮತ್ತು ಸಹಿ ಇವುಗಳನ್ನು ಮಾತ್ರ ನಮೂದಿಸಿದ್ದು, ಕ್ರಮಬದ್ಧವಾಗಿ ಮಾಹಿತಿಗಳನ್ನು ಅರ್ಜಿಯಲ್ಲಿ ನಮೂದಿಸದೆ ಸಾಲವನ್ನು ವಿತರಿಸುತ್ತಾರೆ. ಈ ಸಂಬಂಧ ಸಾಲದ ಅರ್ಜಿಗಳನ್ನು ಇತರರಿಗೆ ಲಗತ್ತಿಸಿ ಈ ಸಂಬಂಧ ಸಂಘದ ಅಧ್ಯಕ್ಷರು, ಉಪಾಧ್ಯಕ್ಷರು ಹಾಗೂ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರ ಗಮನಕ್ಕೆ ತಂದಿದ್ದು, ಈ ಬಗ್ಗೆ ಪರಿಶೀಲನೆಗೆ ಒಳಪಡಿಸುವ ಸೂಕ್ತವೆಂದು ಅಭಿಪ್ರಾಯ ನೀಡಿರುತ್ತೇನೆ. ಸಂಘದಿಂದ ನೀಡುವ ಇತರೆ ಸಾಲಗಳಿಗೆ ಸಂಬಂಧಿಸಿ ಬಾಕಿ ಪಟ್ಟಿ, ಕಳುವಾರು ಪಟ್ಟಿಯನ್ನು ಹಾಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುವ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿಗಳಾದ ಪಡೆದು ಪರಿಶೀಲಿಸಲಾಗಿ ಸಂಘದಿಂದ ಶ್ರೀಮತಿ ವೇದಾವತಿ KN ಕೋಮ್, ಚಂದ್ರಶೇಖರ್ C, ಆಹಾರತೋಳು ವಾಸಿ ಅಂಚೆ, ಭದ್ರಾವತಿ ತಾಲೂಕು ಮತ್ತು ನಾಗರಾಜ್ ಬಿನ್ ಸೋನ್ಸೋ ಇವರಿಗೆ ತಲಾ 15 ಲಕ್ಷಗಳಂತೆ ಒಟ್ಟು 30 ಲಕ್ಷಗಳಿಗೆ ಅಡಿಕೆ ದಾಸ್ತಾನು ಅನುಮಾನ ಸಾಲವನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ಸಾಲಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಅಡಿಕೆ ಸಾಲ ದಾಸ್ತಾನು ಭೌತಿಕ ತೋರಿಸುವಂತೆ ಸಂಘದ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣೆಗಳು ಕೇಳಿದಾಗ ಸ್ಪಷ್ಟವಾಗಿ ಭೌತಿಕವಾಗಿ ತೋರಿಸುವಂತೆ ಕೇಳಿದಾಗ ಉತ್ತರವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಅಡಿಕೆ ದಾಸ್ತಾನಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಮೊದಲು ಸುಳ್ಳು ಮಾಹಿತಿಯನ್ನು ನೀಡಿದ್ದು ಗೋಡನ್ ಅನ್ನು ತಯಾರಿಸಿ ಪರಿಶೀಲಿಸಿದಾಗ ಸಾಲಕ್ಕೆ ಪೂರ್ವಕವಾಗಿ ಅಡಿಕೆ ದಾಸ್ತಾನು ಪಡೆಯದೆ ಸಾಲವನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಗೋಡನ್ ನಲ್ಲಿ ಯಾವುದೇ ದಾಸ್ತಾನು ಇಲ್ಲದಿರುವುದು ಗಮನಿಸಲಾಗಿದೆ. ಪರಿಶೀಲನೆ ಸಂದರ್ಭದಲ್ಲಿ ಸಂಘದ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷರು ಹಾಜರಿದ್ದು ಅವರಿಗೂ ತೋರಿಸಿ ಅಡಿಕೆ ದಾಸ್ತಾನು ಇಲ್ಲದಿರುವುದು ಅವರ ಗಮನಕ್ಕೆ ತಂದಿರುತ್ತೇನೆ ಹಾಗೂ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗಳಾದ ಪತ್ರ ಪಡೆಯಲಾಗಿದ್ದು ಸರಿಪತ್ರದಲ್ಲಿ ಇಲ್ಲದಿಸಿದೆ. ಅಡಿಕೆ ದಾಸ್ತಾನು ಅಡಮಾನ ಸಾಲದ ದಾಸ್ತಾನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಂಘದ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗೆ ತೀವ್ರ ವಿಚಾರಣೆ ಮಾಡಿದಾಗ ಈ ಹಿಂದೆ ಸಾಲ ನೀಡಿದ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವುದೇ ಅಡಿಕೆ ದಾಸ್ತಾನು ಪಡೆಯದ ಸಾಲವನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಈ ಸೇವೆಯನ್ನು ಹಿಂದೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಸಂಘದ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಯಾದ ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ C ಹಾಗೂ ಜಿಲ್ಲಾ ಬ್ಯಾಂಕಿನ ಕ್ಷೇತ್ರಾಧಿಕಾರಿ ಶ್ರೀ H ಅಯ್ಯಪ್ಪ ಇವರುಗಳೇ ತಿಳಿಸುವುದಾಗಿ ಮಾಹಿತಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಅವರು ರಾಜೀನಾಮೆ ನೀಡಿದ ನಂತರ ಹಾಲಿ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿಯಾಗಿ ಕರ್ತವ್ಯ ಶ್ರೀ ವಿಜಯ್ ಕುಮಾರ್ JN ಇವರು ಚಾರ್ಜ್ ಪಡೆಯುವ ಸಂದರ್ಭದಲ್ಲಿ ಅಡಿಕೆ ದಾಸ್ತಾನು ಗೋಡನಲ್ಲಿ ಇಡುವಂತೆ ತಿಳಿಸಿದಾಗ ಇದನ್ನು ಸರಿಪಡಿಸಲಾಗುವುದು ಮತ್ತು ವಿಚಾರವಾಗಿ ಬ್ಯಾಂಕಿಗೆ I am producing.
He has given a loan in his period. We have the documents.
La, that will be recorded, my lord. The record will be available, my lord.
ಅಲ್ಲ ಅವೆಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿಲ್ಲ. ಅಲಿಗೇಷನ್ಸ್ ಚಾರ್ಜಸ್ ಇದೆ.
ಆಯ್ತು. ಎಸ್, ಏನ್ ಹೇಳಿದೀರಾ ಅಂತಂದ್ರೆ 2ನೇ ವೃತ್ತ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾಗ ಜಾವಳಿ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಸಹಕಾರ ಸಂಘ ಅಧಿಕಾರವನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಸಂಘದ ಬೈಲಾ ನಿಯಮಾವಳಿಯನ್ನು ಮೀರಿ ಸಂಘದಿಂದ KCC ಮತ್ತು ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲವನ್ನು ಸದಸ್ಯರಿಗೆ ವಿತರಿಸಿರುತ್ತೀರಿ. ಅಂದ್ರೆ ಇವ್ರ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಸಾಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅದ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲಿ ಇದೆ ಕೊಡಿ.
ಅಲ್ಲ ನಾಟ್ ದಟ್ ಮೈ ಲಾರ್ಡ್, ವಾಟ್ ದ ಅಲಿಗೇಷನ್ಸ್ ಹಿಯರ್ ಮೇ ಕೈಂಡ್ಲಿ ಗೋ ಥ್ರೂ ದಟ್ ಚಾರ್ಜಸ್ ಆರ್ಟಿಕಲ್ ಆಫ್ ಚಾರ್ಜಸ್.
ಆರೋಪ 1 ಅಂದ್ರೆ ಏನ್ ಮತ್ತೆ?
Lord, may I request, my lord, whatever his submission, my lord, he can make before the inquiry officer. If he is not found that he is not guilty, my lord, that will be.
No. There should be. See, now they said in his tenure he has given a loan contrary to the bylaw. Has he given a loan? The documents is there. When you are made in a charge, there should be a document. If that is there, then he has to out. He has to go to the authority. Prima facie, there should be simply. You cannot make a charge and that you read that page 102, first charge. You read that first charge. It is very clear. You frame that charge on what basis?
My lord, illi as in the time of in the tenure of the in earlier yes, may kindly my lord, charge number 1. ಮಂಜುನಾಥ್ ಹಿರಿಯ ಸಹಾಯಕರು ತೋಗರ್ಸಿ ಶಾಖೆಯಾದ ನೀವು ಈ ಹಿಂದೆ ದಿನಾಂಕ 8/4/21 12/9/23 ಶಿವಮೊಗ್ಗ ತಾಲೂಕು 2ನೇ ವೃತ್ತ ಕ್ಷೇತ್ರಾಧಿಕಾರಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾಗ ಜಾವಳ್ಳಿ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಸಂಘವು ಅಧಿಕಾರ ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಸಂಘದ ಬೈಲಾ ನಿಯಮ ಮೀರಿ ಸಂಘದಿಂದ KCC ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲಗಳನ್ನು ಸದಸ್ಯರಿಗೆ ವಿತರಿಸುತ್ತಾರೆ. ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಹಲವು ಸದಸ್ಯರಿಗೆ ಸ್ವಂತ ಬಂಡವಾಳ
ನೀವು ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾಗ ಅಂದ್ರೆ ನೀವು ಡ್ಯೂಟಿಲಿದ್ದಾಗ
ಮೇ ಕೈಂಡ್ಲಿ ಮೇಲ್ನಾಡ್ ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲವನ್ನು ನೀಡದಿದ್ದರೂ ಸಹ ಅವರ ಹೆಸರಿಗೆ ಸಾಲ ನೀಡಲು ಕಂಡು ಬಂದಿದ್ದು ಸದರಿ ಸದಸ್ಯರು ಈ ಬಗ್ಗೆ ಆಕ್ಷೇಪ ವ್ಯಕ್ತಪಡಿಸಿರುತ್ತಾರೆ. ಈ ಸ್ವಂತ ಬಂಡವಾಳ ನೀಡಿಕೆಯಲ್ಲಿ ಸಂಘವು ಕೃತ್ರಿಮವಾಗಿ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ನಂತರ ಸಾಲದ ಮರುಪಾವತಿಯನ್ನು ವರ್ಷಾಂತಕ್ಕೆ ಜಮಾ ಪಡೆದು ಬಾಕಿ ಇಲ್ಲದಂತೆ ಮಾಡಿರುವುದು ಸಂಘದ ತಾತ್ಕಾಲಿಕ ಹಣ ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಇದು
ನೀವ್ ಹೇಳ್ತಿರೋದೇನು
ಜಮಾ ಮಾಡಿದೀವಿ ಅನ್ನೋದು ಇಟ್ ಇಸ್ ದೇರ್ ಇನ್ ದೇರ್ ಪೀರಿಯಡ್ ನಲ್ಲಿ ಆಗಿರುವಂತದ್ದು. ಇದು
ಅದಕ್ಕೆ ಅದು ಎಲ್ಲಿದೆ ಅದು ಕುಡಿ ಅದು ಇವ್ರ
ಅಲ್ಲದೆ ಈ ಕೆಳಕಂಡ ಪ್ರಕರಣ
ಮಿಸ್ಟರ್ ಕೌನ್ಸಿಲ್ ಸಾಲ ತೀರಿಸದೆ ಇಲ್ದಿದ್ರು ಸಾಲ ತೀರಿಸಿದ್ದಾರೆ ಅಂತ ರೆಕಾರ್ಡ್ ಕ್ರಿಯೇಟ್ ಆಗಿದೆ.
ಹಂಗಲ್ಲ ಸ್ವಾಮಿ, ಇವರು ಬೇರೆ ಹೆಸರ ಮೇಲೆ ಲೋನ್ ತೆಗೆದು ಮತ್ತೆ ಅದು ಮರುಪಾವತಿ ಮಾಡಿದರೆ ಬಟ್ ಮೀನ್ ಟೈಮ್
ಇವ್ರು ಅದನ್ನ ನೆಕ್ಸ್ಟ್ ಫರ್ದರ್ ಇವ್ರು ಬಂದಿರೋ ಡ್ಯೂಟಿಗೆ ಬಂದಿರೋರು ಸಹಿತ ಇದನ್ನ ರಿಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ. ಈ ಅವ್ಯವಹಾರಗಳನ್ನೆಲ್ಲ ನಮಗ್ ಗೊತ್ತಾಗಿದ್ದು ಆಸ್ ಆನ್ 64 ರಿಪೋರ್ಟ್ ಬಂದಾಗ್ಲೇನೆ ಗೊತ್ತಾಗಿದ್ದು. ದಿಸ್ ಇಸ್ ದಿ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್
ಸದಸ್ಯರಿಗೆ ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲವನ್ನು ನೀಡಿದ್ದರೂ ಸಹ
ಅದು ಕಂಟಿನ್ಯೂ ನೆಕ್ಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಇದೆ ಅಲಿಗೇಷನ್.
ಸಾಲ ಇರುವುದು ಕಂಡು ಬಂದಿದ್ದು
ಅಲ್ಲ ಅಲಿಗೇಷನ್ ಇಟ್ ಇಸ್ ಕಂಟಿನ್ಯೂ ಇನ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಮೇಲೆ
ಸದಸ್ಯರ ಹೆಸರ ಮೇಲೆ ಲೋನ್ ತಕೊಂಡು ಅದು ಯುಟಿಲೈಸ್ ಮಾಡ್ಕೊಂಡು ತಿರ್ಗಾ ಮರುಪಾವತಿ ಮಾಡ್ತಾರೆ. ಇವನ್ ನಾಟ್ ನೋಟಿಸಿಂಗ್ ಟು ದಟ್ ಮೆಂಬರ್.
ಎಸ್
No, what is that allegation? What is that?
Lord, may I read once again, Lord?
8 ಜನಕ್ಕೆ ಸಾಲ ಪಟ್ಟಿರ ಅಂತ
ಈ
ಹೇಳ್ತಾರೆ.
ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲ ನೀಡಿಕೆಯಲ್ಲಿ ಸಂಘವು ಕೃತ್ಯವಾಗಿ ಸಾರಿ ಮಿಲಾರ್ಡ್ ಮೇ ರೀಡ್ ಫ್ರಮ್ ದಿ ಬಿಗಿನಿಂಗ್
Continue.
ಹಲವು ಇಲ್ಲಿ ಹಲವು ಅಂತ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, ಹಲವು ಸದಸ್ಯರಿಗೆ ಸ್ವಂತ ಬಂಡವಾಳದ ಸಾಲವನ್ನು ನೀಡಿದ್ದರೂ ಸಹ
ಯಾರು who has given that loan?
Lord, that the member itself made a complaint, ಆಕ್ಷೇಪಣೆ ವ್ಯಕ್ತಪಡಿಸಿರ್ತಾರೆ ನಮ್ಗೆ ಕೊಟ್ಟೇ ಇಲ್ಲ ಅಂತ ಅವರು. I will read again that paragraph.
ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲವನ್ನು ನೀಡಿದ್ದರೂ ಸಹ ಅಂತ ಇದೆ.
ಇಲ್ಲಿ ನಾನು ಅದು ಪ್ಯಾರಾ ಇನ್ನೊಂದ್ ಸಾರಿ ಓದ್ತೀನಿ ಸ್ವಾಮಿ. ಶ್ರೀ ಮಂಜುನಾಥ ಎಸ್ ಹಿರಿಯ ಸಹಾಯಕರು ಸೋನ್ಸೋ ಶಾಖೆಯಲ್ಲಿ ಆದ ನೀವು ಈ ಹಿಂದೆ ದಿನಾಂಕ ಸೋನ್ಸೋ ವರ್ಕ್ ಮಾಡಿದಿರಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಹೊರಗೆ ಶಿವಮೊಗ್ಗ ತಾಲೂಕು ಎರಡನೇ
ವೃತ್ತದ ಕ್ಷೇತ್ರಾಧಿಕಾರಿ
ಕರ್ತವ್ಯ ಜಾಲಹಳ್ಳಿ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಂಘವು ಅಧಿಕಾರವನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಸಂಘದ ಬಯಲ ನಿಯಮ ಸೋನ್ಸೋ ಪ್ರಕಾರ ಮತ್ತು ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲವನ್ನು ಸದಸ್ಯರಿಗೆ ವಿತರಿಸಿರುತ್ತಾರೆ. ಹಲವು ಸದಸ್ಯರಿಗೆ ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲವನ್ನು ನೀಡದಿದ್ದರೂ ಸಹ
ಅದು
ಅವರಿಗೆ ಕೊಟ್ಟೇ ಇಲ್ಲ, ನೀಡದಿದ್ದರೂ ಸಹ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಸಾಲ ಇರುವುದು ಕಂಡು ಬಂದಿದ್ದು ಸದರಿ ಸದಸ್ಯರು ಈ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆ ವ್ಯಕ್ತಪಡಿಸಿರ್ತಾರೆ. ಅವ್ರಿಗೆ ಯಾವಾಗ ಗೊತ್ತಾಯ್ತು ಅಂದ್ರೆ ನಮ್ಮ ಮೇಲೆ ಸಾಲದಂತ. ಬಟ್ ಅದೇನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಈ ಸ್ವಂತ ಬಂಡವಾಳ ಸಾಲ ನೀಡಿಕೆಯಲ್ಲಿ ಸಂಘವು ಕೃತ್ರಿಮವಾಗಿ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ನಂತರ ಸಾಲದ ಮರುಪಾವತಿಯನ್ನು ವರ್ಷಾಂತರಕ್ಕೆ ಜಮಾ ಪಡೆದು ಬಾಕಿ ಇಲ್ಲದಂತೆ ಮಾಡಿರುವುದು ಸಂಘವು ತಾತ್ಕಾಲಿಕ ಹಣ ದುರುಪಯೋಗಿಸಪಡಿಕೊಂಡಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ.
It is in continue.
He has not committed, but he is an higher officer who was there.
Yes, previous officer. No, he is the field officer. Page 45 kindly seen, madam. Page 45. ಅಲ್ಲ, may kindly continue the charges. ಅದನ್ನ ಆ charges ಪೂರ್ತಿ ಓದ್ಬಿಡಿ. 8 ಜನಕ್ಕೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರಿಗೆ. ಕಂಟಿನ್ಯೂ ಇದೆ. ಕಾಯ್ದೆ ನಿಯಮ ಬೈಲಾಗಳಂತೆ ಸಂಘವು.
ಅದೇನಾಗತ್ತಂದ್ರೆ ಅವರೆಲ್ಲ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಸ್ವಾಮಿ, ಅವ್ರಿಗೆ ಗೊತ್ತಿರಲ್ಲ ಲೋನ್ ತೊಗೊಂಡಿದ್ದು ಬಿಡೋದು. ಇವ್ರು ಬ್ಯಾಂಕ್ ಅವರು.
That I understood. He has not committed by that Javalli Prathamika Krushi Shatina Sakara Sangha, but he is an higher officer
to inform the bank.
That circle, he is an higher officer.
Yes.
He has not intimated ಅಂತ.
Yes. That is the allegation against him.
Yes.
ಅಲ್ಲ ಅದೇ 8 ಜನಕ್ಕೆ ಅಂತ ಸಾಲ ಕೊಡ್ತಾರೆ ಡಿಸಿ ಮೇಲೆ ಮಾಡ kindly see the 45 milord. He is the field officer. But ಅದು continue allegations.
These are all the disputed questions, milord. These are all the
ಅಲ್ಲ may kindly go through that. ಅದಕ್ಕೆ ಮುಂದುವರೆದು ಇನ್ನೂ ಇದೆ. ಕಾಯ್ದೆ ನಿಯಮ ಬೈಲಾಗಳಂತೆ ಸಂಘವು ತನ್ನ ಕರ್ತವ್ಯ ಜವಾಬ್ದಾರಿಯನ್ನು ನಿರ್ವಹಿಸಬೇಕಾಗಿದ್ದು ಆಡಳಿತ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ಸಂಘದ ಕಾರ್ಯನಿರ್ವಹಣೆ ಬಗ್ಗೆ ಚರ್ಚಿಸಿ ಸಕಾಲದಲ್ಲಿ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಂಡಲ್ಲಿ ಮೇಲಿನ ಹಣ ದುರುಪಯೋಗ ತಡೆಯಬಾಯಿತು. ನೀವು ಕೂಡ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರಲ್ಲಿ ಒಬ್ಬರಾಗಿದ್ದು ಸಂಘಕ್ಕೆ ಹಣಕಾಸು ಪೂರೈಸುವ ಬ್ಯಾಂಕಿನ ಅಧಿಕಾರಿಯಾಗಿದ್ದು ಸಂಘ ಎಸಗಿದ ಕರ್ತವ್ಯ ಲೋಪ ತಾತ್ಕಾಲಿಕ ಹಣ ದುರುಪಯೋಗವನ್ನು ನಿಯತಕಾಲಿಕ ಪರಿವೀಕ್ಷಣೆ ಮಾಡುವುದರ ಮೂಲಕ ಮೇ ಕೈಂಡ್ಲಿ ಅಬ್ಸರ್ವ್ ದಿಸ್ ಮೆಲಡ್ ಮತ್ತು ಸಂಘಕ್ಕೆ ಆಗಿಂದಾಗೆ ಭೇಟಿ ನೀಡಿ ಲೆಕ್ಕಪತ್ರಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡುವುದರ ಮೂಲಕ ಪತ್ತೆ ಹಚ್ಚಬಹುದಾಗಿತ್ತು. ಆದರೆ ನೀವು ಈ ರೀತಿ ಕರ್ತವ್ಯ ನಡೆಸಲು ವಿಫಲರಾಗಿದ್ದು ಬ್ಯಾಂಕಿನ ಸಿಬ್ಬಂದಿಯ ಸೇವಾ ನಿಯಮ ಕರ್ತವ್ಯ ಲೋಪವೆಸಗಿ ಸಂಘಕ್ಕೆ ಆರ್ಥಿಕ ನಷ್ಟ ಉಂಟು ಮಾಡಲು ಕಾರಣರಾಗಿರುತ್ತದೆ. This is the
allegation, my lord. On this allegation, I have written the letter annexed B. After taking a charge, so and so year they have given the loan by creating some document. That's why, my lord, in the 64 report, my lord, page number 45 kindly seen, my lord. 45. The 8 members are there, my lord. In the article charges 102, my lord, kindly see the 102. 8 members are Manjunath. May I read, madam? In the below the pair, correct. Manjunath, Gangappa, Rajendra, Krishnappa, Doddappa, Ramesha, Renuka, Sheshadri. ಇವ್ರನ್ನ 8 ಜನಕ್ಕೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದೇ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಕೇಸ್ 45 ನಲ್ಲಿ that is Manjunath, Gangappa, Maidanappa. That has been pertain to loan in page number 45. That is 64 report, my lord.
Yes.
Manjunath, Gangappa, Rajendra. These 8 members, my lord, they have obtained the loan during the year 2017-2018. Where I was not there, my lord.
ಈ ಲೋನ್ ಅವಾಗ ಕೊಟ್ಟಿದ್ರು. ಆಮೇಲೆ
ನಾ ರಿಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಸಾಲ ಮರುಪಾವತಿ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡಿದ್ರು. ನೀವು ಬಂದ್ರು ಕೂಡ ಸುಮ್ಮನೆ
ಇಲ್ಲ ನಾನು ಮಾಡಿದ annexed B condition ಮೇಲೆ on the basis where annexed B, my lord, I have reported
concerned
after taking the charge, my lord, after taking the charge I have reported to the second respondent. Kindly see the annexed B, my lord.
Only we know the knowledge.
Let me argue, my lord. On the basis of my report, annexed B, my lord, they have instituted the department inquiry against the previous employees, my lord. They have conducted the inquiry and imposed the penalty of dismissal, my lord. I have put the annexed.
Yes,
my lord, kindly see, my lord.
ಆಯ್ತು ಅವ್ರು
ಅವ್ರಿಗೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ.
Same allegation, my lord, 1 second incident department inquiry against me.
Yes.
That is my lord.
Yes. ಆಯ್ತು ಅವ್ರು
ಅಲ್ಲ ನಾನು ಹೇಳ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಪನಿಷ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದು ತೋರಿಸ್ಬಿಟ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ತೀನಿ.
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಸಾಕ್ಬಿಡಿ. I don't want to see that punishment. Yes. There is no dispute.
Yes.
Yes.
The previous, who has committed the misconduct before taking my charge by me, my lord.
Yes.
They are stated on the basis of 64 inquiry only. That is Annexure E.
Yes. Yes.
Yes, my lord, there is no allegation against me.
Yes.
And moreover, my lord, I have given the detailed reply to the article charges as per Annexure F, my lord. H.
Page number.
Page number. Page number 119, my lord. K, Annexure K. 111, 19. Page number K, Annexure K.
Yes.
That is so and so, my lord. The petitioner has given the reply to the ಲಿಖಿತ ಸಮಾವೇಶ ಸಲ್ಲಿಸಿರುವ ಬಗ್ಗೆ ಆರೋಪ ಪಟ್ಟಿ ಸಂಖ್ಯೆ so and so ದಿನಾಂಕ 6/1 that is Annexure H, my lord. Annexure H ಗೆ ನಾವು ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದೆ. Annexure article H ಗೆ my submission, my explanation as per Annexure K. Yes, my lord. ಅದಲ್ಲಿ ಆರೋಪ ಪಟ್ಟಿಯ ಉಲ್ಲೇಖ ನಾನು ದಿನಾಂಕ 8/1
ಆಯ್ತು ಅದನ್ನ ಓದೋದೇನ್ ಬೇಡ ನೀವು ರಿಪ್ಲೈ ಕೊಡಿ.
Yes, my lord. Given all the denying all the allegations and particularly, my lord, the inquiry started on the basis of 64-65 inquiry that has been pertained to year 2017-2018.
Yes.
That is clearly stated in their preamble, my lord. Yes, my preamble itself is stated that the report is pertained to year 2016-17 and 2019 and 20.
Don't repeat, mister.
Yes, my lord.
Then what has happened? Your appeal before first we have filed.
Yes, my lord. I have filed the dispute before the first respondent, second respondent.
Why? Where is
my
the order
application is rejected
Where
on
is
the basis of rejection Annexure N, my lord, page number 141.
Yes.
141.
Yes.
Annexure 141. So dispute, my lord. ವಾದಿಯು ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಸಂಖ್ಯೆ ಕಾಯ್ದೆ ಕಲಮು 70ರ ದಾವೆಯನ್ನು ಪ್ರತಿವಾದಿ ಬ್ಯಾಂಕ್ ವಾದಿಯ ವಿರುದ್ಧ ಹೊರಡಿಸಿರುವ ಆರೋಪ ಪಟ್ಟಿ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋಣಿಸುವ ದಿನಾಂಕ 6/1 ರದ್ದುಪಡಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಸದರಿ ದಾವಾ ಅರ್ಜಿಯೊಂದಿಗೆ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ ಕಲಮು 71(3) ಮಧ್ಯಂತರ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ರೀಸನ್ ಕೈಗೊಂಡಿಸಿದ್ವ ರೀಸನ್ ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್
I read, mister. Against that you have
ಅಲ್ಲ ಅದರಲ್ಲಿ ಇನ್ನೊಂದು ಹೇಳ್ತಾರೆ ಆಂತರಿಕ ಒಟ್ಟು 8 ಆರೋಪಗಳ ಪಟ್ಟಿಯನ್ನು ಬ್ಯಾಂಕ್ ಆಡಳಿತ ವಿಚಾರಣೆಗೊಳಪಟ್ಟು ಕಂಡು ಬರುತ್ತದೆ. Your lordship was directed on that day, my lord, last day time. You produced this ಆಂತರಿಕ ವಿವರ ಇದು.
Now what has happened after that?
After that, I have after rejection, my lord, I approached the KT, my lord. KT is also by reading misreading the provisions, my lord. They have rejected my applications.
What is that?
Page number 161, my lord. Seeking stay of the article charges.
160?
163, page number 163.
What is the order of the case?
That is start from page number 158, my Annexure Q.
ಆಯ್ತು ಪೂರ್ತಿ ಬೇಡ ಏನಾಗಿದೆ ಹೇಳಿ. Why it is rejected?
Reasoning 163 second paragraph. I have produced the documents on record. Well, let's you get it. The charge list dated 6/1/2025 issued by the second respondent band to the petitioner herein are some alleged lapses and deficiency in the work of the petitioner during the some period is only a notice issued to the petitioner herein. The KT, my lord, has taken into that it is only notice. It is not article charges, and the petitioner is entitled to to give his reply and urge his case against the charges made against him. Hence, I have no reason to interfere with the order of stay against the issuance of the article charges.
Yes.
This is only granted, my lord. I have already replied to my article charges as per Annexure.
ಹೇಳಿದ್ರಲ್ಲ ಅದು.
Yes, my lord. Yes, my lord, both the court. Already dispute is pending before the second respondent, my lord. Till the disposal of the interim order may be continued.
Yes. In this petition, petitioner called in question, order dated 17/2/2025, passed by
second respondent.
Which respondent?
Second respondent.
Passed by second respondent. They have rejected only IA.
Case it admits.
Passed on IA filed under section 71 subclass 3 of Karnataka Cooperative Societies Act has been rejected. and also order passed by Karnataka Appellate Tribunal on 29/3/2025, whereby rejected that application filed by the petitioner. The case of the petitioner that he was appointed as a junior assistant on 24/1/2008 in Second Respondent Bank. Later, he was promoted as a senior assistant on 15/7/2019. When did you come to this place?
4/4/2021.
On 4/4/2021, petitioner was transferred to which place, Mr.?
Javalli,
From head, annex A, my lord.
Shimoga Circle.
Shivamoga Circle in the annex, serial number 1. While he was working as a senior assistant, my lord, he was promoted as a posted as
Visita charge. He has been transferred to Shimoga Circle
Shivamoga as a field officer.
as a field officer.
Equivalent post, my lord. Senior assistant as well as a field officer
As
is
a
equivalent
field
post.
officer. On 7/4/2021.
Reported next day, my lord.
Yes. When he was in the service, departmental inquiry has been initiated.
No. After transfer from the, once again, my lord, in the, during the year 25, my lord. He was worked there, my lord, 21,
On 21 ಇಂದ work ಮಾಡ್ತಾ ಇದ್ರಿ.
20 ಇಂದ work ಮಾಡಿದ. Till
12/9/2023.
ಆಮೇಲೆ
He is transferred from another
now
place.
he is not working there.
no, it is not working.
2023 ಗೆ ಬೇರೆ ಕಡೆ
I
transfer
was
ಮಾಡಿದ್ರು.
transferred to Bangalore Circle on 7/4/2021. Thereafter he was 2023 ಅಲ್ಲಿ ಎಲ್ಲಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆದ?
ಮತ್ತೆ ಸೆಂಟರ್ ಬಂದ್ರು, ರೆಸ್ಪಾಂಡೆಂಟ್ ಬ್ಯಾಂಕಿಗೆ ಬಂದ್ರು. ಸೀನಿಯರ್ ಅಸಿಸ್ಟೆಂಟ್.
When?
That is Miller.
12/9/2023.
12/9/2023.
12/9/2023.
He has again transferred to
Head office.
as a
Senior assistant.
senior assistant. The respondent has initiated a departmental inquiry against the petitioner on the ground that during the period he was working as which post?
Field officer.
Field
Field officer on 4/1/2021 to 12/9/2023. There was a misappropriation of the fund. Accordingly, articles of charges has been issued by the annexure H dated 6/1/2025. Petitioner has filed a reply by denying that allegation
Annexure came.
by the annexure K. Thereafter, he has approached which authority?
Second respondent, JRCS.
Ella is second respondent.
Second respondent. Before the second respondent.
ಒಬ್ಬರೇ ಇರೋದಲ್ಲನ್ರಿ?
ಒಬ್ಬರೇ second respondent.
ಅವರೇ
ಅಲ್ಲ first respondent. First respondent, sorry.
Yes. He has
Before the
filed
first
a
respondent.
dispute before first respondent under section 70 of
Yes, please.
Karnataka Cooperative Societies Act and sought for stay of
Article charges annexure H.
articles of charges annexure H. The application filed by the petitioner has been dismissed by
ಅಲ್ಲ dismissal rejected not by this time ಅಂತ rejected Miller. ವಾದಿಪರವಕಲು ವಾದ
ಎರಡು ಒಂದೇ.
ಅಧ್ಯಯನ ಮೇಲಿನ ಪ್ರಕರಣ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ತಿರಸ್ಕರಿಸಿ ಆದೇಶಿಸಿದೆ. ಆದೇಶ ಸ್ವತಃ
dismissed by impugn order 17/2025. 17 to 2025, being aggrieved by the same, he has approached Karnataka Appellate Tribunal. The Karnataka Appellate Tribunal also rejected his application for stay of that articles of charges by impugn order dated 29/3/2025. Therefore, the petitioner is before this court. This court after hearing the parties the petitioner has granted an interim order on 22/4/2025. Yan kottidare interim order?
Stay of the article charges as well as suspension order, my lord.
Stay of articles of charges.
And also suspension order.
Oh, ಎರಡನ್ನೂ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಾ?
ಹೌದೌದು.
ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಾ?
ಇಲ್ಲಿ ಅನೆಕ್ಸರ್ ಎಸ್ ಮೇಲೆ
ಅದರಲ್ಲಿ
ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಇದೆ.
ಅನೆಕ್ಸರ್ ಎನ್ ಓ ಕ್ಯೂ ಹೇಳಿದ್ನಲ್ಲ, ಅಂಡ್ ಆಲ್ಸೋ ಚಾಲೆಂಜ್ ದಟ್ ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಅನೆಕ್ಸರ್ ಎಸ್. ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಎಸ್. The respondent after service of notice has appeared and filed an IFR vacating heard the learned counsel for the parties. Learned counsel appearing for the petitioner has contended that in articles of charges, the allegation is related to for the year 2017 and 18. The departmental inquiry has been initiated on the basis of the inquiry conducted under Section 64 of Cooperative Societies Act. As per that Section 64 report, the misappropriation is related to
2018
and 1920.
Right.
Petitioner has taken a charge as a field officer.
A field officer.
Field officer in the year 2021. Therefore, the charge memo is contrary to that material available on record. He further contended that the immediately after petitioner has taken a charge as a field officer, he has reported to the irregularities committed by previous Javalli Prathamika, Javalli Primary Agriculture Cooperative Society, na?
A credit cooperative society. Agricultural credit cooperative society.
Agriculture Credit Cooperative Society to higher officer wide annexure B. He has not committed any irregularities. And there is no any lapse or deficiency in the work of the petitioner. Hence, he sought for quashing of that charge memo, quashing of articles of charges issued against him. Learned counsel appearing for the respondent society contended that charge against the petitioner that after he has taken a charge as a field officer.
Yes, as a field officer.
Field officer.
And he is not properly report to the higher authority.
He has not reported that irregularities committed by the society to that higher officer. Javalli Primary Credit Cooperative Societies has misappropriated the fund, created a records in the name of the members.
Yes. Bank know the only the, after the
In the
64
members
report.
and issued a loan. As a field officer, he has not reported the same to the higher authority. That was the charge against the petitioner. The department has initiated an inquiry. He can make out his case before that inquiry officer. Heard the learned counsel for the parties. They rose. Read papers. It is not in dispute. Petitioner has been appointed, petitioner has been posted as a field officer. In which place?
Javalli.
Javalli, Prathamika, Primary
Credit Cooperative Society.
Credit Cooperative Society on 4/1/2021, and he was worked till 12/9/2023. As per the charge memo, as per that articles of charges, it is very clear that the Javalli Primary Credit Cooperative Society has, contrary to that bylaws, has granted a loan to member, and also allegation that without distributing that loan amount to that member, the amount has been withdrawn in the name of the member.
That is
Later,
not allegation, madam.
Huh?
They have not properly, the loan is given and they have credited in the end of the year, my lord. That is the allegation.
no,
The creating the document at the end of the year ಅಂತ ಹೇಳಿ.
ಹಿಡಿದರು ಸಹ ಸಾಲ ನೀಡಿದ್ದು
Yes, yes.
ಸದರಿ ಸದಸ್ಯರು ಈ ಬಗ್ಗೆ ಆಕ್ಷೇಪ ವ್ಯಕ್ತಪಡಿಸಿರ್ತಾರೆ. ನಮಗೆ ಸಾಲ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವರೇ ಬಂದು ಹೇಳಿದ್ದಾರೆ.
Yes. ಹೇಳಿದ್ದಾರೆ. That is, it is not pertaining to
ಈಗಲ್ಲ
Yes.
ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಕೇಳಿ. Yes. Later, it has been shown in that records to that amount has been credited. Petitioner as a field officer during his tenure from 8/4/2021 to 12/9/2023, he has not reported these irregularities to that higher officer.
Yes.
Even though inquiry report under 64 related to 17, 18 and 19, 20, the allegation against the petitioner that during this period, he has not reported the irregularities to that higher officer. The
Annexure B is reported, my lord. As per
Yes.
Annexure B, I have reported after taking a charge.
Yes. The relevant charges, charge memo is extracted below. ಅವರಿಗೆ ಆರೋಪ ಇದೆ, ಅದನ್ನ extract ಮಾಡ್ಬಿಡಿ.
Total 8 allegations against him, my lord.
All that will be extracted. Yes. Pursuant to that charge memo, petitioner has submitted a reply. Now inquiry is under progress. Whether petitioner has whether is there any lapse or deficiency in the work of the petitioner can be consider only after conducting a detailed inquiry by the inquiry officer. At this stage, court cannot quash that. Articles of charges. Prima facie, it appears that now I am closing all this appeal also. Now it has to be faced. The
Dispute, my lord, dispute is pending. Like in dispute can maybe.
Not that
continue.
I am giving a finding that prima facie it is there. If you want to take any inviting that order, you suffer it. Yes, why do you want to again go before that?
No, I have only come before this, only rejection of my IM, my lord. It's already admitted, notice has been issued.
No,
They
you
have
are,
also
you
filed
are
the
inviting
objection.
my order. I will give the finding that why you are not granting that. Charges prima facie it is there. Why do you again go there and
Charges, my lord, it is pertaining to year 2016, 17, 18, 19, my lord.
charges?
Where I have.
The above frame the charges. It is, he has to appear before the committee and to prove that tribunal as well as the first respondent has rightly come to the conclusion that prima facie petitioner has not made out any case for granting an interim order. There is no error in order passed by the respondent. Let them decide. I will not give a finding that order passed by that first respondent and KAT. Accordingly, writ petition is dismissed.
A time frame maybe given, my lord. JR says. Dispute ಮಾಡೋದಕ್ಕೆ time frame maybe given.
Yes, it is made clear that the first respondent to decide the dispute in accordance with law without influencing any observation made by this court in this order. Yes.
Till then, my lord, article charges, one way, department inquiry is also going on. The dispute is also pending before the first respondent, my lord. Till the disposal of the dispute, my lord, the inquiry may be stayed, my lord.
No, I said that.
Unnecessary, my lord, they unnecessary, they have conducted the inquiry.
Yes.
Even charges is not pertaining to the where he is.
The inquiry is gone, Mr. Yes. Yes. All pending applications are disposed of.
Cell number 31, Vijay Kumar for petitioner.
One question to me, my lord. Whether somebody is working there, my lord.
Yes.
There is only one person working that office, the cadre of that warder, my lord.
What?
The permanent arrow ಒಬ್ರು warder ಆಗಿ work ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Idare.
So because of that reason, the petitioner is not placed in that post.
No.
That's wrong, Lord. I have the
No,
information.
now that,
Lord.
who is that officer who has, which is the post that is?
Head warder, Lord.
Warder, my lord.
And
No. Now he has been posted to which place?
Superintendent.
Post of superintendent.
Superintendent in which place? Shimoga.
ಶಿವಮೊಗ್ಗ ನಿರಾಶ್ರಿತರ ಕೇಂದ್ರ.
Shimoga Nirasitra Kendra. Ali, who is that immediate junior officer?
Not immediate junior ಯಾರು ಇಲ್ಲ ಅದರಲ್ಲಿ, ಅಲ್ಲಿರೋದೇ ಒಬ್ರು ಹೆಡ್ ವಾರ್ಡರ್ ಅಷ್ಟೇ.
ಒಬ್ರು ಇದ್ದಾರೆ ಹೆಡ್ ವಾರ್ಡ್.
ಒಬ್ರು ಇದ್ದಾರೆ ಹೆಡ್ ವಾರ್ಡರ್.
ಅವ್ರಿಗೆ ಯಾಕೆ ಇನ್ಚಾರ್ಜ್ ಕೊಡಬಾರ್ದು?
ಇಲ್ಲ ಹೆಡ್
ಹೆಡ್ ವಾರ್ಡ್ ಅಲ್ಲಿ ಕಳ್ಸೋ ಬದಲು ಅವರಿಗೆ ಇನ್ಚಾರ್ಜ್ ಕೊಟ್ರೆ ಆಯ್ತು, ಇವ್ರಿಬ್ರು ಔಟ್. That is what that rule says.
ಅಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ. I may
charge
be permitted
should
to
be
place
given
the
to that.
material to show. I may be permitted to place the material to show that there is no person is available.
No, that whether you are the better person or the state government is the better person to say.
ಇನ್ನೇನೆ
Collected the
ನಾನಂದ್ರೆ ಡಾಕ್ಯುಮೆಂಟ್
information.
ಹಾಕ್ಬೇಕಾಗತ್ತೆ, ಫೋನ್ ಅಲ್ಲಿ ಕೇಳ್ಕೊಂಡೆ ನಾನು.
The information.
No, now that you say that there is no this thing. No, there is no immediate junior officer there.
Kindly, my lord, this is the order, my lord.
ಇದು ಆರ್ಡರ್ 2023 ಇದು.
16/1/2025, the last document which is placed. B.S. Mahesh, head warder, ನಿರಾಶ್ರಿತರ ಪರಿಹಾರ ಕೇಂದ್ರ ಶಿವಮೊಗ್ಗ ಇವರು ನಿರಾಶ್ರಿತರ ಪರಿಹಾರ ಕೇಂದ್ರ ಬೆಂಗಳೂರು ಇಲ್ಲಿ ಹೆಡ್ ವಾರ್ಡರ್ ಹುದ್ದೆಗೆ ನಿಯೋಜಿಸುವ ಬಗ್ಗೆ. This is passed on 16/1/2025. Lord, one Mr. Mahesh was working as head warder. In view of his request, Lord, he has been transferred to Bengaluru. There is no head warders available. That is the reason, Lord, I was posted as a superintendent as well as I am discharging the
Lord, it
duties
may
of
be
head
taken
warder
at
also.
4 o'clock, my lord. 4 o'clock I will produce the document.
2:30.
ಇಲ್ಲ 2:30 ನನ್ನೊಂದು ಪಾರ್ಟ್ ಹೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್.
We'll take at 4 o'clock.
ಒಬ್ಲೈಸ್.
Not today, my lord.
You get that, huh?
ಇವತ್ತು ಬೇಡ, ಸ್ವಲ್ಪ ಏನೋ ನನಗೂ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್. ಮಧ್ಯಾಹ್ನ ನನಗೂ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್.
Tomorrow.
Is there any officer?
I will produce the document, my lord.
ಅಲ್ಲ ಹೆಡ್ ವಾರ್ಡರ್ ಅಲ್ಲಿ ಯಾರು ಇಲ್ಲ, ಅವ್ರನ್ನ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಬೆಂಗಳೂರು ಕಳಿಸಿರೋದಕ್ಕೆ ನನ್ಗೆ ಅಲ್ಲಿ ಅವಶ್ಯಕತೆ ಇದೆ ಅಂದ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಪೋಸ್ಟಿಂಗ್ ಕೊಟ್ಟಿರೋದು ನನಗೆ.
Head warden ಅಂತಾನೆ ಅಲ್ಲ. Rule 68 says.
I understand.
Immediate junior. ಯಾರು ಇಲ್ಲ ಅಂದ್ರೆ
ಯಾರು ಇಲ್ಲ, ಹೆಡ್ ವಾರ್ಡರ್ ಅಲ್ಲಿ ಇದ್ದವ್ರನ್ನ ಬೇರೆ ಕಡೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಕ್ಕೆ ಖಾಲಿ ಇದ್ದ
ಹಾಕೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ ವೆದರ್ ಈಸ್ ಫ್ರಮ್ ಆಲ್
ತೀರ್ಮಾನ ಮಾಡದ್ರಿ.
ದಿಸ್ ಇಸ್ ದಿ ಸರ್ಕ್ಯುಲರ್ ವೇರ್ ದಿ ಗವರ್ನಮೆಂಟ್ ಇಸ್ ಫಾಲೋಯಿಂಗ್ ಮೈ ಲಾರ್ಡ್.
Rajappa, if nobody is there, then I will decide other point. Whether you do sure there or both are not entitled.
Yeah, the circular says, my lord, under what circumstances a deputation can be made anta.
ಅದು ಬರೋಣ. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ. ಈಗ ಯಾರಾದ್ರೂ ಇಮಿಡಿಯೇಟ್ ಆಫೀಸರ್ who is eligible to be hold the post of supervisor in charge, then I will direct it to it. I will.
ಅಲ್ಲ SDN ಮಾಡಕ್
ಯಾರು ಇಲ್ಲದೆ ಇರೋದಕ್ಕೆ ನಾನು
SDN ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. SDA in the same office ಮಾಡಕ್ ಬರಲ್ಲ.
Who is eligible to be hold that post, let that.
Material, I have placed material to show those who are in the same cadre and who is warder, head warder ಆಗಿ ನಾನು ಕೆಲಸ ಮಾಡ್ತಿರೋರ್ನ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಆಗಿ ಅಡಿಷನಲ್ ಚಾರ್ಜ್ ಕೊಡ್ತಾರೆ. The person who is working below me, warder cadre ಅಲ್ಲಿ ಇರೋರು ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಪೋಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
No, I will decide all these things. I will start from the basic. First thing is, as per the rules, person eligible immediate officers ಅಲ್ಲಿ ಇದ್ರೆ ನೀವಿಬ್ರು ಬರಲ್ಲ. ಆಮೇಲೆ ನೀವಿಬ್ರಲ್ಲಿ ಯಾರು ಬರ್ತೀರಾ ಡಿಸೈಡ್.
ಯಾರು ಇಲ್ವೇ ಇಲ್ಲ, ಅದಕ್ಕೆ ನನಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇಸ್ ನಾಟ್ ಕ್ಲಿಯರ್.
Yes.
ಅಲ್ಲಿ ಅಡ್ವಾರ್ಡರ್ ಇದ್ರು ಕೊಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ದಟ್ ಇಸ್ ಮೈ ಥರ್ಸ್ಟ್ ಆಫ್
ವಾರ್ಡರ್ ಇರೋರ್ಗು ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. ಗವರ್ನಮೆಂಟ್ ಹಸ್ ಕಮಿಟೆಡ್ ದಟ್ tomorrow.
Yes.
Interim order may kindly be extended.
Interim order granted earlier is extended till
one way or the other, my lord, your lordship may decide.
He himself is not sure. He is saying that I don't know whether.
I called him telephonally. He said that one person is working, my lord. I will take the document.
You could have asked that officers to come, Mr. Yes.
Grateful.
Cell number 32.
Whether he is eligible to be posted as in charge arrangement, that also you inquire. But again, our agala dinonsari time kala. Yes.
32 Satish K for petitioner, Nataraj T.
Yes.
Please.
Yes, I for vacating. Yes.
But I am filing a memo for disposal. Again disposal really. Memo na?
Now, what is the disposal to dismiss that petition?
Yes. Angar sir.
After that, Ravi will argue 5 minutes, then you can say that it is.
ಇಲ್ಲ ಅವರು ಬರ್ತಾರೆ ಅಂತ ಗೊತ್ತಾಗ್ತಿದ್ದಂಗೆ ನಾನು ಮೆಮೊ ಹಾಕಿದ್ದೆ.
Yes. To help that instructing councils are. Yes.
But in view of subsequent development that I have been transferred to Chamarajnagar.
Yes.
That I have taken charge. Writ petition may not survive.
That counsel for the petitioner has filed a memo stating that in view of subsequent event, the prior sought in this writ petition will not survive for consideration. Memo is taken on record. The above writ petition is dismissed having become infructuous. Please,
Pending application.
all pending applications are disposed of.
Preliminary hearing B group matter, serial number 33, Raghavendra G Gayatri for petitioner, government advocate.
Yes, Mr.
Lords, I appear for the petitioner. Lords, I fix the date in view of the fact that this is squarely covered by the judgment.
Yes,
Lords,
what is?
Lords, I'll to some of the facts, my lords. Lords, petitioner before this honorable court were the employees of my lords Mysore Acetate Chemicals Company Limited, my lords, which was a government sector undertaking, and
Yes, Mysore.
Acetate and Chemicals Company Limited,
Yes.
MACC.
Yes.
My lords, will find it annexure C, page 40.
Yes.
Lords, MACC came to be closed by the government, and my lords, subsequently wide annexure E, page 58. The employees who are working,
Yes,
the
absorbed.
MACC came to be annexure E, page 58, my lords.
53.
58, my lords, annexure E.
It's 53 annexure E.
My apologies, my apologies.
Yes. Yes.
Lords, wherein, my lords, the employees who are working in the MACC were, my lords, deputed to different Pattan Panchayats of, my lords, Mysore and other districts, Nelmangla and other districts.
Where is your name?
Lords, my name, petitioner number 1 will be at serial number 21. Petitioner number 2 at serial number 17. M. Ramesh, Nagarasabhe, Mandya.
Yes.
And my lords 21 Anusuya, Group D Naukararu, Nagarsabhe, Mandya.
No, that annexure E ಒಳಗಡೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Annexure E, my lords.
Annexure E ಅಲ್ಲಿ page serial number 21 is Shankar.
Annexure E, my lord.
Annexure E, my lords, dated 29/9/2001.
No, it is dated 19th June 1957.
Lords, my apologies, Annexure F, my lords, F, my apologies, 58.
Yes.
My apologies, my lords, humble apologies.
Yes. Your
Lords,
name
may
is-
kindly come to page 60.
Yes,
17, M. Ramesh, Nagarasabha, Mandya.
17.
17, 17. And my lords, very next page, serial number 21, Anusuya Bai.
21.
Yes, my lords.
So, yes.
My lords, before these, after these employees were appointed in my lords Pattan Panchayats,
Yes.
my lords, similarly situated employees who are working in other factories who are also, my lords, wide Annexure B and C, my lords, have produced Annexure D, page 42. Who are, my lords, in a manner, who are working in the factories, government sector undertaking factories, and were subsequently deputed, came to be absorbed,
Yes.
my lords, by framing special rules at Annexure D and
Yes.
also at Annexure E.
Yes.
On the same ground, my lords, that seeking parity of absorption from the date they were deputed to the Pattan Panchayats,
Yes.
my lords, petitioners and others approached this honorable court
Yes.
by way of filing writ petition 2800 of 2003, which my lords will find at Annexure M, page 126.
M.
M, my lords.
Yes.
Mini.
Yes.
And my lords, operative portion, my lords will find at page 149.
149.
149.
Yes.
Lords, considering, my lords,
Yes.
the parity and also the fact that the government has extended absorption benefits to the other similarly situated employees,
Yes.
writ petition came to be allowed by this honorable court,
Yes.
against which, my lords, a writ of intra-court appeal was also preferred,
Yes.
which is at page 151, operative portion, my lords, will find.
Yes.
Lords, at page 171.
Yes. That has been confirmed.
Yes, my lords, it is confirmed. Para 10, my lords, very same parity aspect has been discussed, and
Yes.
my lords, accordingly, it is confirmed.
Yes.
Thereafter, my lords, Annexure A is passed at page 32, regularizing our services, absorbing our services.
Yes.
Lords, but what they do in Rule 3, Clause 4 is that the effect of absorption is
Yes.
given prospectively.
Yes.
It is at page 34, my lords.
In that other department, they have been given from the date of,
Yes, my lords. From the date they were deputed, on that note it was given, and against which, my lords, 2 batch of writ petitions were filed. My lords, first batch of writ petitions were, my lords, writ petition 10021 of 2020. I shall. This was also therein, my lords, rule of prospective implication was challenged. This also came to be allowed, stating that, my lords, they will be, the employees will be,
petitioner employee.
have the benefit of retros from the date they were deputed. May I read, my lords?
Yes, I took directions.
On the same ground, my lords, we had also filed a writ petition at Annexure W, page 192. Lords, the employees therein are the employees at Annexure A, who's along with the petitioner here. Same employees,
No, same,
same batch. My lords, may kindly take page 36 once, so that it will be page 36.
yes.
My lords, name of the petitioner number 1, Anusuya Bai, is at serial number 17. And my lords, name of Ramesh M at serial number 22 at page 36.
Yes.
Lords, 1 Chamaraju at serial number 5, at serial number 8 MC Keshava,
Yes.
and serial number 5 Ningaya, and serial number 15, 16 and 20. These people approached this honorable court at Annexure W, page 192.
Yes.
Lords, of this honorable court, considering the case and also order at writ petition 10021 of 2020, and it is complied by the government. Government has passed an order absorbing and complying writ petition 10021 of 2020, my lords.
Yes, Mr.
Considering all those.
My lord, my respectful submission in this case, my lord, the court, although the challenge is to the rules, as in this case, in the other case at Annexure W, the challenge was to the rules. But without quashing the rules, the honorable court has relaxed the conditions. My lord, that is not permissible in view of the
That is
decision
what
of
that
the
you have
apex
not
court.
challenged, that you can't say that only this employer. I
Because
have
they
seen
have
that.
implemented it in
See,
connected matter.
Even they have not seek for a return that rules also, or they have not challenging that, but court has granted that. You have accepted. You can't say that other two employees, no.
My lord, I understand, my lord, on the ground of parity, that cannot be said.
Yes.
But my respectful submission is, this judgment is not correct, my lord. Based on apex
No, no.
court's decision in Dhanraj's case,
No, that
My lord.
sheet is, that is not available for you
My lord.
unless you challenge that.
May I,
As in a state,
may I submit
you
one more?
can't say that in respect of that similarly situated persons, 2 persons will challenge, other 5 persons you can't take a
my
pick
lord, the
and choose.
view taken may not be correct. Therefore, this court, my lord, being contrary to the decision of the apex court, my lord, that judgment may not be valid, my lord, is my respectful submission.
That will consider.
May I
But
just
while
pass
directing-
on this judgment, my lord, of the apex court. In
Yes.
fact,
That's why directing, my lords,
My lord,
in the connected matter, the order was direction to DPAR. My lords, then subsequently an IA for correction was filed. And learned EAG himself appeared. He sought not correction only to the respect of direction to the urban development
my
department.
lord, all that may be so. I am not dispute. My lord, I completely agree. If there was a, my lord, correct decision, then, my lord, the challenge to the rules must be addressed, my lord. Otherwise, my lord, otherwise the difficulty for the government is this, my lord. On the one hand, we have the rules. On the other hand, we have the judgment.
No, you have implemented.
My lord, we have implemented.
How
But
can you say
contrary to the rules, my lord.
Then,
My
yes.
lord, para 15, the last part of that says, as long as the rules are not in effect, the court cannot direct that the rules will not be implemented. Please, please,
See, I have seen this judgment.
Dhanraj, yes,
No, first judgment.
10021.
There is no challenging of the rule.
please.
Court has directed, even that contention is not raised by that government. Now you have complied it. Here, second round, in the same set of employees they have given. Now you can't, that I will record your statement. Yes, tell.
My lord, my submission is that judgment would be per incuriam and has to be referred to, matter has to be referred to a larger bench.
Yes, yes, yes. Early. In this writ petition, petitioner sought
My lord, just one more aspect, my lord. There is a delay also, that one submission may also be
what is the
recorded.
delay?
My lord, the others have approached the court, but after securing the order, my lord, at Annexure T, which is dated 29/5/2023.
All are retired now.
One minute, petitioner number 1.
No, that as in a model employer, you have to be implemented to all. Mr.
My lord, the
Everybody
difficulty
should
is,
not
my lord,
pay.
we have suffered a series of orders. I understand, my lord. In fact, regularization from the date of deputation was also not permissible. I'm not going to that, because that is also barred by Indu Shekhar's case, where the apex court, very similar prayer, my lord, to observe from the date of deputation has been repelled by the
My lords,
apex
the
court.
contention
But
and
all
all
that
that is
has not been
addressed in
done
writ petition
previously.
10021.
No, I am not saying anything, Mr. In similar situated persons, it has been done. In terms of that, you have to be do it. That's all. Yes, it is represented by that government advocate itself. It is not that ex parte order. Yes. Then you have not challenged also. Remedy is there for you to challenge. Yes. Sought for directing the respondent number 1, 2 to extend that. Prayer C and D hakali sir. The petitioner was initially employed by public sector undertaking, Messrs. Mysore Acetate and Chemical Limited. And with the decision to close these enterprises, they were sent on deputation to different municipalities. The government of Karnataka after earlier round of litigation has notified Karnataka municipalities bracketly absorption of certain employees from Mysore Acetate and Chemical Limited in urban local bodies special rules 2021. Petitioner have called in question the different provisions of the rules 2021. Learned counsel appearing for the petitioner has submitted that in respect of similarly situated persons, this court in WP number 10575 of 2023 disposed of on 18 July 2024 has granted a relief. In terms of that, he sought for allowing that writ petition. Learned government advocate appearing for the state has not disputed that judgment of this court dated.
Lord, regarding the implementation, he has not produced any material.
I have. Government order.
Yes.
That copy is not given. Namak kottilla.
Yes. Not disputed. The order passed by this court in 10575 of 2023 disposed of on 18 July 2024 in respect of similarly situated persons. He has relied on that judgment of last and also produced the document to show that that order has been implemented.
Lords, writ petition 10021 of 2020 is implemented.
10575.
10021.
No, 10575 ಏನಾಗಿದೆ?
My lords, that is under process. I can direction is fresh representation.
We are saying that only covered. We are not saying.
Direction is to submit fresh representation, that is submitted and they are regularizing.
Yes. Not disputed. The learned counsel, government advocate further submitted that there is a delay in approaching this court by the petitioner. Only after disposal of that writ petition they have approached this court. Secondly, he has contended that the rule is very clear that they have to be absorbed from the date of the rule came into the force.
Lord, as per rule, may I just specify the rule, my lord? It is 3-4. In the prayer, it is wrongly mentioned as 3-3. It is 3-4, my lord.
Yes.
3-4.
As per the rules, they have to be absorbed from the date of rule came into the force.
From the date of appointment,
From
as
the
per
date
the
of,
rules.
yes, from the date of appointment.
As per the rules.
He contended that without set-asiding that the particular provisions of the rules, the petitioner is not entitled for the relief. In support of his contention, he has relied on judgment of Apex Court in 2023 SEC online SC 724. Be that as it may, it is not in dispute the petitioner in this writ petition and the petitioner in the WP 10575 of 2023 disposed of on 18 July 2024 are similarly situated persons. Where is that list you have shown?
Lords, Annexure A, page 36. Schedule.
And their service has been absorbed as per Annexure A.
Schedule. Schedule annexed to Annexure A.
Scheduled annexed to Annexure A. This court in WP 10575 of 2023 as held that relevant paragraph 5 prior also extracted. That order of this court is attained finality. State has not filed any appeal. Since the petitioner are similarly situated persons, in parity, they are also entitled for the similar relief. Accordingly, writ petition is allowed. Declare that petitioner's absorption must be from the date they were sent on deputation to the concerned local body, and that they must be admitted to all consequential financial benefit effect from such a date, but the interest payable at 6% per annum shall only be from the date of notification of the Rule 2021. Petitioners are reserved with liberty to file a representation along with that certified copies of this order with the Secretary Department of.
Respond number 1. Subsequently, it is changed by way of urban development direction.
Respondent number 1. Respondent number 1. Order that the court has liberty to file an.
My lords, last paragraph. Principal Secretary, Urban Development Department, page 2.
Principal Secretary.
Urban Development Department, respond number 1.
You appear before the court and saying that we will going to implement that to Additional Advocate General, Mr.
That is what
Additional Advocate General has appeared and said that yes,
it is under process and we are implementing it is what?
Yes. Who has to direct?
Respond number 1 to be directed.
Respondent number 1 is liberty is to file a representation, certified copies of this order with that respondent number 1 within 4 weeks from the date of receipt of the copy of this order. The respondent number 1 is directed
Three months thereafter time is given to consider the representation.
Directed to consider that representation within the period of 3 months from the date of receipt of such representation.
This one correction, it is from the date of, the effective date of absorption will be from the date of reporting, not the date of appointment. Date of reporting as per Rule 3(4).
Lord, that itself is interfered with. That itself is interfered with now. Lords may kindly say.
Earlier in the order it was recorded, absorption will be effective on the date of appointment. As per Rule
Shall only be from the date of notification of the
date of
Lords, clause 4, page 34.
the absorption shall be effective.
absorption from the date they were sent on deputation.
Lords, if I may clear it.
Wait.
Earlier in the order it was recorded. As per the rules, the absorption will be effective from the date of appointment.
You said appointment, not appointment. From the rules.
Date of reporting.
Date of reporting.
That's all I wanted.
As per that rules, al madidal helidnala. Yes. Yes. Yes.
Date of presentation ಕೊಡಂಗಿಲ್ಲ ಅಂತ ಇದೆ.
Yes.
Para 25 of the
Yes. ಅದನ್ನು judgment ಜೊತೆಗೆ. Yes.
Lords, all his contentions are answered in writ petition 10021 para 24 onwards.
No, I
All
don't
his
know that.
contentions
No,
are answered.
Without quashing the rules.
Lords,
Which
it may not be, he may not be completely right for this reason. There need not be a specific word saying that so and so is quashed. That is been diluted at any first relief which is been given. There they say that I will be entitled for the benefit, entitled for the benefit from 2021 amendment, but I will be absorbed from the previous date. So dilution is made. There need not be a specific word. That is also, there is also decision.
There is no discussion of Hindu Shekhar in this case.
No, that's
Judgment was given to me today.
provision has to be read down like this ಅಂತ ಹೇಳ್ಬಿಟ್ಟು there should be a reasoning that order.
Lords may kindly
Either
there is no specific
striking
order
down
to that effect.
or
I concede.
read down that provision should be there.
To that effect, specific order illa.
But anyhow, that state itself is interested, why
Implementing.
should I come in that way?
Deeply.
34,
Highly
Sri Prasad Pai, petitioner, P. Harish Bhandari.
Yes, Mr.
Petitioner. The last occasion, my lord, respondent submits whether any appeal was filed against the covered by a judgment, my lord. They wanted to find out
Yes.
whether any appeal has been filed.
Against which order?
The reported in WP number 15499 of 2013, my lord. Covered by judgment. This matter is covered by.
Yeah, yes. Who has taken the time?
So the
Government advocate.
government
Appeal
advocate,
ಹಾಕಿದ್ದೀರಾ ಅದ್ರ ಮೇಲೆ?
he found out, my lord, no appeal has been filed.
Yes, Mr. That which is the committee?
Balajiga community, Balajiga community.
Balajiga,
Balajiga
community.
Balajiga, Banjiga.
Now there cannot be a two this thing. One
Yes,
for
ma'am.
education purpose
And one for academic purpose.
Yes, Mr. Government.
And for one for job.
Pass over.
Pass over.
I'll get the. Letter has been sent, I'll get the instruction.
Yes, pass over.
Serial number 35, CS Madhu for petitioner, Satish K. A. Chandrachud.
For petitioners, my lord. Lord, it is a premature case of Group C employee who is working as SO in Bescom, Chelur, Ubi Taluk, my lords.
Yes.
On the very first date of hearing, the respondents have contended that there is a departmental proceeding against me. As a result, they have passed the impugned order, my lords.
Just give the brief facts.
Please, my lords. Lords, the petitioner was given promotion and transferred to SO post Chelur on 8/6/2022 as per Annexure E, my lords.
Annexure E.
Annexure E, my lords. Typed copy is at page number 25, my lords. Typed copy, page number 25, my lords. Her name is at serial number 5, my lords, page 26.
8th June.
8th June 2022, my lords.
Your name is?
Vijay Lakshmi, yes. Serial number 5, my lords.
Serial number 5, Vijay Lakshmi. ಎಲ್ಲಿಂದ ಎಲ್ಲಿ ಗುಬ್ಬಿಯಿಂದ?
From Gubbi to Cheluru, my lords.
Cheluru Shake.
Cheluru Shake, Upavibhaga Gubbi.
Then which
thereafter one Naveen Kumar was deputed to my post without transferring me. As a result, I approached this honorable court.
Which is that annexure?
Annexure H, my lords.
transfer from one place, one chair to other chair is transferring. Now you can imagine that how that their employees are working.
Lots, there are.
But in
What
this,
their motive of working, how they are working.
to
how
stick
they are
on to the
serving.
same chair.
We are saying that government servants, how they are serving to that nation or that citizen, you can imagine that.
But in the instant case
But
that they,
we can't do anything because we have to follow the rules, law, whatever the law is there, we are doing that.
but
So
in this,
even full bench said, from one place to one chair to other. One branch, ಈ ಕೀ one branch ಅಂತೆ ಅಲ್ಲಲ್ಲೇ ಪಕ್ಕದಲ್ಲೇ ಅದಕ್ಕೆ yes
one section to another section or one chair to another chair as well. But in this instant case, what I've been instructed is, my lord,
yes
there were repeated negligence of this particular officer, wherein
ಡಿ-ಇನ್ಶಿಯೇಟ್ ಮಾಡ್ರಿ please
ಮಾಡಿದ್ದಾರೆ ಅದು ಆಗಿದೆ. ಆ ಡಿ-ಇನಿಶಿಯೇಟ್ ಆಗಿದೆ.
ಆದ್ರೆ ಐ ಥಿಂಕ್ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಡಿಸ್ಟಿಂಗ್ವಿಶ್ ಮಾಡಬಹುದು ಅಂತ ಕಾಣ್ತದೆ.
ಅಲ್ಲ, ಡಿ-ಇನಿಶಿಯೇಟ್ ಆಗಿದೆ. ಅವ್ರಿಗೆ ಕರ್ತವ್ಯ ಯಾವ ತರ ಅಂತಂದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರು ಸಹ ಅಲ್ಲಿ ಲೈನ್ಗಳದ್ದು
we'll see if that serious allegation, if that rule is not followed, we'll permit you to do it and
Please, my
transfer it.
lords.
That's all.
My lords,
It
I
is
have
not-
made,
First you establish that it is all is complied. If it is not complied, we'll quash it and permit you to do it and this, if there is any serious allegation.
yes ma'am.
Yes.
my lords, 6 months ago, I made a representation stating that the wires are getting dilapidated. Kindly permit me to change the wires, and I have given the estimation. They have taken the estimation,
All
forwarded
that
to
can
office.
be established in the D. If D is there,
Please, my lords.
then rule says you should be transferred to that non-executive post.
Non-executive post.
That too with the prior permission of the.
ಅದೇ
chief
ಅದು
minister.
ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಪರ್ಮಿಷನ್ ಹೂ ಇಸ್ ದಟ್ ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ
Please, my lords.
ಮಾಡಿ.
I'm obliged.
ನನಗೆ ಗೊತ್ತಾದಂಗೆ ಡಿ ಫ್ಯಾಕ್ಟೋ ಆಗಿದೆಯಂತೆ.
Let us see. Yes, yes.
ಬಟ್ ಪ್ರಯಾರ್ಗೆ ಡಿ ಫ್ಯಾಕ್ಟೋ ಆಗಿದೆಯಂತೆ. But in certain cases where defects are also placed on record, your honor,
Yes.
that for your lordship's appraisals.
Let us see on Tuesday.
Wednesday,
Wednesday.
13th.
Yes.
Grateful, my lords.
Serial number 36, Siddhanuru Vishwanatha for petitioner, Jagadishwar NR, H. Devendrappa.
Yes. This is a suspension matter, my lord. More than 6 months, there is no inquiry initiated. As per Ajay Kumar Chaudhary case, may kindly reinstate the respondent in
Who is your
original
opponent?
place, my lord.
Serial number
36,
36.
Jagadishwar NR,
ಜಗದೀಶ್ವರ ಎನ್ನಾರ ಅಥವಾ
H. Devendrappa.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್?
Assam.
Suspended from,
5 ಯಾರು?
By Devendrappa.
ದೇವೇಂದ್ರಪ್ಪ. Now why that private persons has made a party?
my lord, now the respondent number 5 is appointed in my place, my lord. Even after lapse of more than 6 months, still I am not in reinstate, or there is no substantial alliance. Suspended,
When is that order of suspension?
my lord, suspension of order passed in 21/2025, my lord. That is annexure L, my lord.
Annexure L.
Yes, my lord. 22/1/2025, my lord. Harshavardhan M, clerk cum data entry operator, Kadime Belchi, Gram
ಗ್ರಾಮ
Panchayat.
ಪಂಚಾಯತ್ ಇದಾಯ್ತು.
Yes, my lord.
Who is appearing for ಗ್ರಾಮ ಪಂಚಾಯತ್?
Respondent 1 to 4 appearing, one is
ಜಗದೀಶ್ವರ್ ಎನ್ನಾರ್.
Jagadishwar. Now after inquiring that, my lord,
Where is that rule?
my lord,
Niyama
annexure Q, my lord, now appointed in respondent, private respondent is appointed as per obtaining RTI, my lord.
ಪಂಚಾಯತ್ ರಾಜ್ ರೂಲ್ಸ್ ಇತ್ತಲ್ಲ 2024.
In earlier, my lord, unanimously, the respondent number 2 taken decision for dismiss this petitioner. I approached for Jilla Panchayat for appeal, my lord. The appeal is allowed and reinstate in my in original position, even though again they have suspension order is passed by the respondent number 3, my lord.
ಮತ್ತೆ appeal ಹಾಕ್ಲಿಲ್ಲ.
Yes, the same allegation, my lord.
No, you could have filed an appeal.
Alla, appeal, now already it is appeal is concluded.
No,
Again,
ಇದು
suspension order is unilaterally decided by the respondent number 3, my lord. As per Ajay Kumar Chaudhary case, the Honorable Supreme Court is very clear that, my lord, I submit my reply also, my lord, relating to the
No, ಇದು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ ನಿಯಮಾವಳಿ 2020
113, in section 113. For conducting the inquiry, the suspension is, they have
No, now you are arguing that
suspension, my lord, more than 6 months, it is a unreasonable days is here, my lord. More than 6 months and reinstation is must necessary as per Ajay Kumar Chaudhary case, my lord.
ಪೇಜ್ ಎಲ್ಲ ಉಲ್ಟಾಗಿದಾವ್ ನೋಡ್ರಿ ಅದು. Disciplinary authority ಗ್ರಾಮ ಪಂಚಾಯತ್ so on so. That empowered to place that employee in gram panchayat suspension where the disciplinary proceeding is contemplated and pending that the case against. No, but is it government advocate?
Lord.
In these rules, there is no such provision.
Yes,
But I
but
think
Can it be
generally, my
applied
lord,
that Supreme Court judgment that?
Lord, generally, my lord, what will happen in suspension matter, my lord? It has to be suspended for the period. After that, if the charge memo is not issued by the authority who has suspended, my lord,
Shall we import
then
it to
automatically it
disciplinary?
will,
Import place the employee gram panchayat under suspension. No, under what context Supreme Court said? Because
that is under service rules, my lord.
no, that whether it's applicable, because here there is no such this thing. In your KCSR ಅಲ್ಲಿ ಇದೆ 6 months ಆಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಬೇಕು ಅಂತ
90 days, my lord.
90 days.
In 90 days.
ಈ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ. Whether
Yes,
it can
there
be
is no-
applied, that judgment
That I will clarify, my lord. Maybe taken tomorrow, I will clarify.
tomorrow.
Oblige.
You see that Panchayat Raj Act rules.
Alla,
Rules
I have the
Karnataka-
rules, my lord, I have the rules, but it's very clear that, my lord, there is no specific rules. Under 113, conducting the inquiry and dismissed by the power by the
Rule 8 ಅಲ್ಲಿ ಇದೆ ರೀ.
jurisdictional Gram Panchayat has the empowered right for dismissal. But now there is no inquiry, still it is commenced.
No, I am asking that whether they have any power to suspend you or not. It is there.
Suspending.
Rule is there. ಈ ರೂಲ್ ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಗೆ ಅಪ್ಲೈ ಮಾಡಬಹುದಾ ಅಂತ ಲೆಟ್ ಹಿಮ್
I will clarify. that
ರೂಲ್
tomorrow.
8 B ಒಳಗಡೆ ಇದೆ. That ಅಧ್ಯಕ್ಷ of the gram panchayat is empowered to place an employee of the gram panchayat under suspension where the disciplinary proceeding against him is contemplated or pending or where the case against him in this respect of the criminal offence or under investigation or trial.
Oblige.
Can it be applied the Supreme Court judgment here say that? I encode that, my lord, which is in Kannada in our library. So, ಇದ್ರ ಪ್ರಕಾರ ಗ್ರಾಮ ಪಂಚಾಯತಿ ತಪ್ಪು ಮಾಡಿದ ನೌಕರನ ವಿರುದ್ಧ ಶಿಸ್ತು ಕ್ರಮ ಪ್ರಾರಂಭಿಸುವುದು, ದಂಡ ಅಥವಾ ವೇತನ ಬಡ್ತಿಯನ್ನು ತಡೆ ಹಿಡಿದು ವಿಧಿಸಲು ಸಂಬಂಧಪಟ್ಟ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಅಧಿಕಾರ ಅಷ್ಟೇ ಇರುವಂತದ್ದು. ಅದರ್ ದೆನ್ ದೇರ್ ಇಸ್ ನೋ ಎಂಪವರ್ ರೈಟ್.
ನೀವು ರಿಟ್ ಹಾಕಿದ್ರಲ್ಲ,
ಎಸ್,
annexure L ಒಳಗಡೆ they have quoted the rule. Under this rule you have been suspended. Have you seen that rule?
8(6).
Have you seen that rule?
ಎಸ್, ನೋಡಿದ್ದೀನಿ ಸರ್.
ಮತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಲ್ಲ.
ಅಲ್ಲ ಅದರ್ ದೆನ್ ಇನ್ನು ಯಾವುದೇ ಪ್ರಾವಿಷನ್ಸ್ ಇಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ ಸರ್.
No, that rule they have quoted. Whether under that rule there is a provision power for suspension or not. Have you seen that rule? If you have not seen, you say that I have not seen. But you are supposed to be seen before filing that. I have the rules.
I encode that, my lord, and now I getting this one.
No, ನನ್ನ ಹತ್ರ ರೂಲ್ಸ್ ಐತ್ರಿ. ಆ ರೂಲ್ಸ್ ಅಲ್ಲಿ ನಾನು ನಿಮ್ಮ ಎದುರಿಗೆ ಓದ್ ಹೇಳಿದ್ನಲ್ಲ, ಪಂಚಾಯತ್ ಹ್ಯಾಸ್ ಎನ್ ಪವರ್ ಟು ಸಸ್ಪೆಂಡ್. CCA ರೂಲ್ಸ್ ಅಲ್ಲಿ 6 months ಆದ್ಮೇಲೆ ಅವರು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಟ್ಟು ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕಾದ್ರೆ ಮತ್ತೊಂದು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ಅಂತ ಎಲ್ಲ ಇದೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಆನ್ಸರ್ಡ್ ಆನ್ ದಟ್ ಕಂಟೆಕ್ಸ್ಟ್ ಆರ್ ದಿಸ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಐ ವಾಂಟ್ ಆಸ್ಕಿಂಗ್
ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಅಪ್ಲಿಕೇಬಲ್ ಟು ಆಲ್
ರೂಲ್ಸ್ ಅಲ್ಲಿ ಇದೆಯೋ ಇಲ್ಲ ಅನ್ನೋದೇ ನೋಡಿಲ್ಲಪ್ಪ ನೀವು, ಹಂಗೆ ರಿಟ್ ಹಾಕಿದಿರ. ಅಗೇನ್ ದಟ್ ಯು ಆರ್ ಟೆಲಿಂಗ್ ಸಮಥಿಂಗ್. See that this is the rules, it is there. They have a power. Now only question is that.
It is applicable to Ajay Kumar Chaudhary case, my lord. So that
you see that Mr.
tomorrow.
You have that rules.
ನಾನು ತೋತೀವಿ ಸರ್.
ತೆಗೆದಿಟ್ಕೊಳ್ಳಿ rules. Tomorrow you see that whether it can be applied that. If it is that is the case, then this has to be quashed.
Serial number 30, my lord, he is fit for respondent. Now, the suspension order was challenged before this all court. The first instance you have to challenge before the JRC, my lord. There is no order, my lord, for challenging that liberty to challenge the suspension order before the first respondent. That is JRC.
Suspension, liberty to challenge that suspension order, ಅದು dispose ಮಾಡಿದ್ವಲ್ಲ before the
Yes, my lord,
competent.
the withdraw, permit to withdraw the petition. Then only I will go through the JRC.
That's what that I expected when I have given in a fine.
Order is passed.
ಆಯ್ತು.
ಅದಕ್ಕೆ
Learned counsel for the petitioner is filed in a memo. Taking leave. ನೀವಿನ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಎಲ್ಲಿ ಹೋದ್ರು ಕೂಡ ನಿಮಗೆ ರಿಲೀಸ್ ಸಿಗಲ್ಲ ನನ್ನ ಫೈಂಡಿಂಗ್ ಅಲ್ಲ.
Yes, that's why, my lord, that's why.
Yes. Permitted to withdraw. Yes.
Please.
Yes.
Serial number
36, tomorrow you will see Mr.
I will.
Tomorrow, yes.
37, Satish K for petitioner, GP Sharat Kauda, TP Vivekananda.
But here for the petitioner,
Yes, Mr.
matter pertaining to my lord suspension. Suspension is dated 23/12/2024. But the allegation is I have traveled abroad without taking permission of my lord my employer. But on that allegation, my lord, I have been placed under suspension. Wide order dated 23/12/2024. Lord, I made a representation for revocation of suspension. Lord, the charge memo is issued on 26/2025, which is served to me, my lord, on 27/6/2025. After 6 months, if the date is taken into consideration, my lord, it is prior to 6 months. ಎರಡು ದಿನ ಮೊದಲೇ ಮಾಡಿದ್ದಾರೆ. But my lord, it is served upon the petitioner on 27/6/2025.
What is that judgment says? What is that rule says?
My lord, thereafter, my lord, there is no extension.
No, what is the rule says? It should be an extension or which
Yes,
is the rule?
rule 10(5)(b).
Yes, sir, CC rules.
Right, it's a deeming provision. It says that it is deemed to have been continued unless and until there is a specific revocation, is what it says.
Yes, let's-
Karnataka Civil Service CCA rules, Rule 10.
If charge memo is issued,
Let us see that. We'll
Yes.
read the rule.
if departmental inquiry is not commenced,
No, with 10,
5B.
5B, yes.
If departmental inquiry is not commenced against the delinquent government servant or charge sheet is not filed in the court within a period of 6 months from suspension, the competent authority shall decide whether to revoke or continue suspension of such government servant, and unless decided and ordered for continuation within this period, suspension shall be deemed to have been revoked from the date of completion of period of 6 months from the date of suspension. Upon such revocation of the order of his suspension, it shall be the duty of the government servant to immediately seek order of posting from the appointing authority, failing which he shall be deemed to be on unauthorized absence with effect from the date of revocation of the order of his suspension, provided that authority competent to place a government servant under suspension may extend the period of suspension beyond the period specified in this clause only after consulting within the said period with the authority referred in subclause A, only if such authority recommends extension within the said period. Otherwise, the order placed.
First thing is that,
Yes, ma'am.
when is the date of suspension? 23/12/24.
23/12/2024, my lord. Yes.
When is that order has been, charge memo has been issued?
Not 26/2025.
It is within 6 months.
Within 6 months. Not it is served.
Not served, they have said. You read that.
Issuance.
See, within that period.
ಹಂಗಾದ್ರೆ
Department,
not only to
to say.
deprive me, not the benefit of this. not-
Therefore,
it
they,
is-
they have a time limits of 6 months. They can issue in last day also.
ಇಲ್ಲ ಇದು 27th 26th ಆಗಿರೋದು, but they have
Unless you establish that or made an allegation seeing that they have put in an antedated, then we cannot be say that. It is not that it is served on you.
The date of issuance is what is contemplated.
Yes. Shall decide whether revoked or continuous suspension of servant and unless
ಅಲ್ಲ
decided.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗ್ಬೇಕು ಇಲ್ದೇ ಹೋದ್ರುನು.
No, extension ಅದಕ್ಕಲ್ಲ. ನೀವು ಚಾರ್ಜ್ ಮೆಮೊ ಇಶ್ಯೂ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ದೇ ಹ್ಯಾವ್ ಟು ಪಾಸ್ ಅನ್ ಎಕ್ಸ್ಟೆನ್ಷನ್. ಚಾರ್ಜ್ ಮೆಮೊ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ.
ನೋಡಿ at any rate ನೋಡಿ allegation is of
Beyond the period of specified in the class, only after consulting within the said period with that authority. If any such, but it is issued on within 6 months.
ಅಲ್ಲ
Other than that, you have any ground? Yes.
2 ದಿನ ಮೊದ್ಲೇ ಮಾಡಿದ್ದಾರೆ ನೋಡ ಆನ್ ಫ್ಯಾಕ್ಟ್ಸ್.
No, you
But-
can't, yes, you are entitled for all this benefit when you are retired from the case. So, after
exoneration.
exoneration.
ನೋಡ your
Second
lordship
thing is, after 6 months, you have to pay full salary.
75%.
75%.
ಆದ್ರೆ
Without work,
ನೋಡ the allegation is trivial in nature. Not kindly see the allegation whether I should be continued in suspension. The only allegation is not page 38.
no, that is true. Therefore, all
Therefore-
this class has been made to apply employer to see that instead of giving him a see, it is not that you are going to commit such a mistake when you are in the service, if you are continued. You have not taken a permission. If you are in a suspension is on the basis of that corruption. If you are allowed to continue, again you will do that work. But you are suspended on the basis that you are not taken a permission.
Permission.
Therefore, the employer has to apply their mind. Instead of simply paying 75,000, 75%, they could have revoked. That also you have to think.
That should have been
See,
considered. My lord, the allegation is not only that he has traveled abroad without prior permission, my lord. There are allegations that he has also forged certain documents. If I may
ಇಲ್ಲ,
permit my lord to kindly,
ಇಲ್ಲ.
Annexure C, page number 29.
ಇಲ್ಲ ಚಾರ್ಜ್ ಮೆಮೋದಲ್ಲಿ ಬೇಕಲ್ಲ annexure C milord is
In
the
the charge memo,
Charge memo ದಲ್ಲಿ ನೋಡೋಣ ಈಗ ನೀವು charge
please, my
memo.
lord.
page
Annexure G,
38.
Page 37, page 38.
38. This is the only charge.
ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದೆ ಪ್ರವಾಸಗೊಂಡಿದ್ದ ವಿಚಾರಣೆ ಮಾಡಿ ಕ್ರಮ ಮತ್ತೆ ಅವ್ನು ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡಿದ್ದಾನೆ ಸುಮ್ನೆ ಏನ್ ಮಾಡ್ತೀರ ಹೊರಗಿಟ್ಕೊಂಡು ಸುಮ್ನೆ ಯಾಕೆ ಸಂಬಳ ಕೊಡ್ತೀರಿ? Yes, that
should have
liberty
been
will
considered,
given
my
you,
lord,
given
but
a
our-
representation. Let them consider in accordance with law.
That can be given.
Yes.
If a
Otherwise,
representation is given,
no
it will
purpose.
be considered.
Yes.
ಇಲ್ಲ ಈ charge ಗೆ I cannot be kept out is my lord.
But there is no such law saying that.
But
If
there is
charges-
one judgment which says that lord once articles of charge is issued, lord there is no scope for continuation of the suspension for the reason that all the records are with them and there is no need to.
Law is not like that. But if you have any judgment, place me, then I can see that. I don't
Yes,
think
my
such, yes,
Your lordship may pass over, my lord, I will produce.
yes, pass over.
Lord, I will also seek records pertaining to this matter, my lord. If my lord would have it on 18,
Yes, 18.
I'll secure all the records, entire records pertaining to
Yes,
the case. I'll
and
place it
also
before
get
the
an
court.
instruction,
I'll
whether it
seek
can be
instruction.
considered for, otherwise you are getting in a loss, that's all. You are just
That is
paying
true,
in a.
that is true, ma'am.
Yes. If any allegations are serious, then it should be, you
Yes,
cannot be.
allegation is
Allegations are quite serious because that's the only
I-
reason, and there is continuous holidays, therefore
I
18.
But serial number 40.
Serial number?
Yep.
Tomorrow. Yes.
Serial number
First
40, my
matter
lord.
ಆದ್ರೆ ನೋಡಿ tomorrow, yes.
Serial number 40.
similar petition ಇದೆ.
Similar petition is pending. It is coming up on 19th of August.
Serial
Lords, I
number
have-
40.
I appear for the respondents, my lords. I have objections, my lords. This matter may be heard. I filed my objection.
Yes, we'll see when the matter is reached.
Serial number 55, my lord.
Serial number?
Serial number 55, my lord.
55.
From the other side also, my lord. Even for 20th, my lord, for the 230, this, my lord.
You are appearing for respondent number?
20th, for 20th, my lord.
No, you are appearing for whom, madam?
Petition, my lord.
At the request of counsel for the petitioner. Is this matter? When do you want?
20th, my lord.
Not 20th, 22nd, yes.
Lord, in serial number
Madam
38.
is not available in the respondent side.
No, no, 22nd, yes, yes.
Serial number 38.
Hmm.
Article directed notice period. My friend will appear, loving friend will appear. H.M. Muralidhar, connected matters are there. He will appear.
Who?
H.M. Muralidhar.
H.M. Muralidhar.
Given the numbers are.
Yes, that when the matter is called, will delete your
Next matter, 38.
38. Who is that petitioner? Counsel for the petitioner.
Chandan Gowda.
Our Burley.
230.
Yes.
My lord, serial number 54, my lords.
Yes.
Appear for the respondents, my lords. My lords, arguing counsel is unwell. Kindly have it immediately.
Have you informed that other side? Informed and move that 230. First inform.
ಚೇಂಬರ್ ಕಡೆ ಬರ್ತಾ ಇದೀವಿ. ಇಲ್ಲ ನಿಮ್ಗೆ ಕೊಡ್ತೀನಿ ಈಗ. ಅಲ್ಲೇ ರೀ ಬನ್ನಿ.
ಗ್ರಾಮ ಪಂಚಾಯತ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇದೇ ಇಲ್ಲ.
ಇದೆ ನೋಡೋಣ ಏನಾರ ಮಾಡೋಣ. ನಿಮ್ಮಲ್ಲಿ ಇದೇನೆ ಇದೆ ರೂಲು.
ನನ್ನ ಲೈಬ್ರರಿಯಲ್ಲಿ ಕನ್ನಡ ಇತ್ತು, ಕನ್ನಡನೇ ತಕೊಂಡ್ಬಂದಿದ್ದೇನೆ.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಸಸ್ಪೆನ್ಷನ್
ಸಸ್ಪೆನ್ಷನ್ ಅಂತ ಇಲ್ಲ, ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ ಅಷ್ಟೇ ಇರೋದು.
ಯಾಕೆ ಅಲ್ಲಿ ಇಲ್ಲಿ ಸರ್ಕಸ್ ಮಾಡಿ ಮತ್ತೆ ಹೇಳಿ ಸರ್.
ಅಪೀಲ್ ಇದೆಯಲ್ಲ,
ಅವರು ಇನ್ನೊಬ್ರು ಕೌಂಟರ್ ಬರ್ಲಿ ಅಂತ ಕಾಯ್ತಾರೆ. ಅವ್ರ ಕೈಗೆ
ಇದೆಯಲ್ಲ ಕಂಪ್ಯಾಷನೇಟ್ ಗ್ರೌಂಡ್.
ಫ್ರೆಶ್ ಇದೆಯಾ?
ನೆಕ್ಸ್ಟ್ ಜಿ ಇದೆ, ಯಾವುದೋ ಇದೆ. ಸರಿ ತೊಳಿ
ಸರ್, ಇದು ಒಂದು ಜಿರಾಕ್ಸ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬರ್ತೀನಿ.
ಔಟ್ ಸೈಡ್ ಇಲ್ಲ.
ಥ್ಯಾಂಕ್ ಯು.
ಅಲ್ಲ ಅಲ್ಲಿ ಲೈಬ್ರರಿಯಲ್ಲಿ
ಫೋಟೋ ತಗೊಳ್ಳಿ, ಸಿಗುತ್ತೆ ನಿಮ್ಗೆ, ಬೇರೆ ಕಡೆ ಎಲ್ಲ ಸಿಗುತ್ತೆ.
ಇಲ್ಲ ಸ್ಕ್ಯಾನ್ ಮಾಡ್ಕೋಬೇಕು
ಮಾಡಿ. ನನಗಿದ್ರೆ
ಸರ್ ಹೇಳಿ ಸರ್. ಪಾಸ್ವರ್ಡ್ ಇಷ್ಟಿದೆ. ಎಷ್ಟು ಸರ್ ನಿಮ್ದು? 47. 40 ಹತ್ರ ಐತಿ. ಪಾಸ್ವರ್ಡ್ ಇವಾಗ ನೋಡಲ್ಲ.
ಸಾಹೇಬ್ರೆ, ಒಂದೇ ಒಂದು ನಿಮಿಷ ಆಯ್ತು.
Continue ಮಾಡ್ತಾರೆ You have to keep an eye on our matter. Can you go? I will let you.
ಒಂದು ಸ್ಟೆಪ್ ಮೇಲೆ ತಗೋಬೇಕು ಅಂತ 9 ಸ್ಟೆಪ್ ಮೇಲೆ ತಗೋಬೇಕು 4 is three is four should be expected not as a factor regular who should be by EPC appointing authority backlog saying that there is enough representation. Representation enough elected ಮತ್ತೆ ಬರೀ 15 post ಇರ್ತಾರೆ. CH-10 17 plus 2 ಇದೆ. Generality ಬರಲ್ಲ. Generality is not maintained. SC and others. On this grounds, tell it to read it. With the findings, wrong calculation, then read it. Raising your poster will not like your backward 1 to 100 articles. How many you going to
ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ಹೋಗುತ್ತೆ ಸರ್. ಸಾಹೇಬ್ರು ಸೈನ್ ಎಲ್ಲ ಆಗ್ಬೇಕಲ್ಲ, ಫೈಲ್ ಹೋದ್ರೆ ಪ್ರಯೋಜನ ಇಲ್ವಲ್ಲ. ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಸಿಗುತ್ತೆ. ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಸಿಗುತ್ತೆ. ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ಹೋಗುತ್ತೆ, ನೀವು ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಕಲೆಕ್ಟ್ ಮಾಡಿ. ಸಾಹೇಬ್ರು ಸೈನ್ ಆಗ್ಬೇಕಲ್ಲ ಸರ್. ಹೋಗಿಲ್ಲ ಹೋಗಿಲ್ಲ.
ಇದು ಮೆಮೋ ಕೊಡೋದು ಮರ್ತೋದೆ, ಬೆಳಿಗ್ಗೆ ಕೊಡ್ಲಾ ನಾಳೆ ಕೊಡಿ. RFA ಹಳೇದು 2010 ಯಾವ್ದಾದ್ರು ಒಂದು ಫ್ರೈಡೆ ಹಾಕೋದು. ಆಯ್ತು, ಈಗಲೇ ನಾಳೆ ಕೊಡ್ಲಾ? ಹೌದು ಅಭಿನಯ್
ಸಮಾಚಾರ
ಆರ್ಡ್ರಲ್ಲಿ 54 ಇರೋದು 31 ಆಸ್ ಪರ್ 31(7) ನಾನು ಇಲ್ಲಿ ಅಮೆಂಡ್ ಮಾಡ್ತೀನಿ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ಅವರು ಪೋರ್ಟಲ್ನಲ್ಲೇ ಮಾಡ್ತೆ ಅಂತ ಹೇಳಿದ್ರು. ಅಮೆಂಡೆಡ್ ಬೈ ದ ಆರ್ಡರ್ ಡೇಟೆಡ್ 31(7) ಇನ್ ಓಪನ್ ಕೋರ್ಟ್.
ಅದು ಗೌರ್ಮೆಂಟ್
ಮುಂದೆ ಬಂದಿದ್ರು, ಬೇಕಾದ್ರೆ ಇಲ್ಲಿ ನಾವು ಚೇಂಜ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಂದ್ರು. ಹಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಕೇಳ್ತೀನಿ ನಾವು ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಅಂತ ಹೇಳಿದ್ರೆ.
ಇಲ್ಲ ಸಾಹೇಬ್ರು ಗಮನಿಸ್ತಾರ.
ಮತ್ತೆ ಇದು ಏನಿದೆ,
ಈಗ ಹೋಗ್ತೀರಾ ಬೇಗ? ಇನ್ನ ಬಂದಿಲ್ಲ ಸಾಹೇಬ್ರು. ಬೇಗ ಹೊರಡಿ.
ಇದಿದೆ ನೋಡಿ 5/4/24.
ಒಂದ್ ಮಾತು ಸಾಹೇಬ್ರು ಕೇಳಿ. ಹೇಳಿಲ್ಲ ಆ ಕಡೆ. ಇರಿ ಮೇಡಮ್, ಒಂದ್ ನಿಮಿಷ ಕೇಳ್ತೀನಿ ಬಿಟ್ರೆ ಹೆಂಗೆ? ಹೋಗಿ ಮೇಡಮ್, ಬೇಗ ಬೇಗ.
One submission, my lord. Serial number 54. I pray for a week's time, my lords. Any date next week. I've informed the other side.
54. Yes, 18th. 18th or 19th? 19th. Yes, use this matter on 19th. Great.
Appearing on behalf of Siddharth Baburao, my lord. Kindly pass over.
Pass over. Yes, pass over.
Serial number 40, Vijay Kumar for petitioner.
That's a request for a passover. The ASG is leading us in this matter, my lords. We're
Why
ready.
that he is saying that connected? What is this matter?
Lords, this is concerning the Secretary Ayush.
Is there any stay?
There is a stay, my lords. So the entire selection process, my lords, is stalled.
Permitted to take.
Lords, my request is there is some inconvenience. It's not the same cause of action at all. I believe I'm not on record in that matter, my lords. I believe in that what is challenged is his appointment as secretary. Here, they want to restrain him from carrying out his functions in terms of appointments for another.
There I can, in your case, quo warranto that has been issued. Challenge that. Here, what is that you are challenging?
Composition of a committee, my lords. For appointment, of chairman and members to the National Commission of Homeopathy.
Because there is an observation of the Honorable Supreme Court in respect of the third respondent. That is the reason we are here. Because this honorable court is the writ of mandamus and that.
No, you are saying that in the committee, third respondent should not. No, you said that only in your case, he should not be there in that committee.
Search committee.
Such committee, he should not be there in that committee.
Search committee.
Such
The
committee.
member of the search committee should not be.
Your allegation is that some
Observe.
no, in your case, he said that he should not be there.
Same petitioner. Same petitioner.
Yes.
But they're different petitioners, different cause of action.
No.
Here, my lords, what they say.
Both of them wants that this, he should not be there.
Lords, but there's no prayer to that effect here. Here, there is no prayer not to continue him.
No, suppose if that writ petition is allowed, he is out, then his petition will become infruct.
Lords, I am saying that the decision in this writ petition would absolutely have no bearing on that writ petition. ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಿದ್ದಾರೆ ಅವ್ರ ಸೆಕ್ರೆಟರಿ ಪೋಸ್ಟ್ ಇಂದಾನೆ ತೆಗೆದಾಕಿ ಅಂತ. ಇಲ್ಲಿ ಏನ್ ಹೇಳ್ತಿದ್ದಾರೆ ಅವ್ರು ಸೆಕ್ರೆಟರಿ ಆಗಿದ್ದಾಗ ಅವ್ರು ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡ್ತಿರೋ ಫಂಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಅವ್ರೊಂದು ಕಮಿಟಿದು ಭಾಗವಾಗಿರ್ತಾರೆ. ಆ ಕಮಿಟಿದ್ ಭಾಗವಾಗಿರಬಾರ್ದು ಅಂತ. ಇದು ಡಿಸೈಡ್ ಆದ್ರೆ ಅವ್ರಿಗೆ ಏನ್ ಪ್ರೆಜುಡಿಸ್ ಸ್ವಾಮಿ? ಈ ಕೇಸ್ ಡಿಸೈಡ್ ಆದ್ರೆ ಇವತ್ತು ಅವ್ರು ಸೆಕ್ರೆಟರಿ ಆಗಿ ಇರ್ತಾರೋ ಬಿಡ್ತಾರೋ ಅದಕ್ಕೆ ಏನ್ ಬಿ ಡಿಸೈಡ್ ಸೆಪರೇಟ್ಲಿ my lords. ಇಲ್ಲಿ ಎಂಟೈರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ process is stayed. My lords have said that that there is a stay on publication of the list.
That matter is when? No, that when do you want this matter now?
Lords, today, my lords, we filed objections. Advance copy is served to them. We are ready, my lords. AG is leading us in the matter.
No, that matter is different. We will hear this matter also. No. We can suppose if he is convinced. No. We can suppose if he is convinced, he can be kept out of this search.
The recommendation of a search committee
Yes.
consisting of, so what are the components? A, cabinet secretary; B, 2 experts; C, 1 expert; D, 1 person possessing so and so. Please direct attention to clause E. The secretary to the government of India in charge of Ayush to be the convener member. So by virtue of law, section 5(1)(e) is an essential, is the convener member, is like the member secretary. Now the petitioner says, don't have him in the committee. How is that possible, my lord? The law is very clear. It says he shall be the, to be the convener means he shall be the convener member.
Yes.
Okay, I will read that also. I will read 5 also. No appointment of the chairperson or member shall be invalid merely by reason of any vacancy or any absence of a member in the search committee. Fine. That situation has not arisen. That has not arisen. But let us look at the relief. Now have a look at the relief sought.
Yes.
Page 21. Issue a writ of mandamus
Yes.
or any other appropriate writ or direction directing respondent number 1, 2 and 4 to exclude third respondent from the search committee proposed to be constituted for the selection and appointment to the post of chairperson, National Commission for Homeopathy, President of Homeopathy Education Board, Medical Assessment and Rating Board for Homeopathy, and Board of Ethics and Registration for Homeopathy. But how can this Honorable Court direct the authorities
Law
not
said-
contrary to law?
Law said he should be in a one of
He
the.
should be. And he has not challenged the
Can't say
validity
that
of that law.
contrary to that.
When there is an observation of the Supreme Court, that will not be third respondent. Cannot be.
No, let us look at that observation.
Finalize that list. Finalize that list.
What is the section on that?
Search committees.
No, my lord, why should be? My lord, when the writ petition itself is not maintainable, my respect to the commission, there cannot be an interim order. When the writ petition is prima facie not maintainable.
You file a fresh writ petition will.
Yes, my lord, lordship may give him liberty. Lordship may give him liberty.
No, Mr. Counsel, you should be very distinct. Filing in a writ petition can be done it one day. Wait. If you are filing an amendment, you have to give filing an objection to that other side. You think that which is better?
And my lord, by tomorrow,
cannot be
by
allowed.
tomorrow, this law will not change. If my learned friend is thinking so nothing is going to happen.
You can
Whether he
file
takes
an
a day's time or a year's time, the law will be the same.
No, challenging. If you file an amendment tomorrow, then I have to give an opportunity for him to file an objection. You can file a writ tomorrow itself, challenging that appointment
Meantime,
order.
my lord, would your lordship also have a quick look at the Supreme Court judgment which the petitioner's counsel is
No, no, no,
attempting
first
to
we'll
place
see that
reliance upon?
In this case, prayer itself is cannot be
But
granted.
true,
in
prayer
law.
itself is not maintainable. There
No.
cannot be a prayer directing the
Better thing
authorities
is
to
that you
take a
can
decision contrary to law.
You withdraw that, file in a fresh writ petition challenging his appointment order.
Let the matter be maybe taken up tomorrow. They are not taking for a longer adjournment. By tomorrow, we will rectify whatever is there in the intercom, you know, so you're not.
No, no, there is nothing to rectify, my lord. I'm sure my learned friend has not been briefed. What is there to rectify?
Pleadings are in place. Even if your lordship finds that.
Tomorrow.
Tomorrow.
It may be listed along with other petition because.
That we'll see
that.
No, 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 that's
we'll
my lord,
see
they're
later.
totally different, my lord. It is filed by somebody else. It is filed by somebody else. There is no connection to that. My lord, let this writ petitioner show how this writ petition is maintainable.
Why the central government should shy away from meeting the
No,
challenge
no, no,
to
there
their
is,
actions. Because this is something which is to be.
we are not shying away, my lord, we are not shying away. The writ petitioner has to show how the writ petition is maintainable. Today, my lord,
There is a challenge in relation to a particular cause. Note, there may be a 3-pronged, 4-pronged, 5-pronged attack in respect of cause for which we are hesitating before our lordship. Two, he might have raised, I might have raised. Central government should not shy away from defending their actions.
No.
Ultimately, in a rule of law, what is.
my lord, let my learned friend confine his argument to this case. My lord, it can't be a omnibus submission.
Wait. See, that case I have heard, I have rejected interim prayer. Remedy is to challenge.
Yes.
That case has to be heard finally. Tomorrow cannot be heard finally. There cannot be a preference to your case to hear.
In this case, my lord, it's a maintainability issue. It's a question of maintainability.
I can still remember that that is the case which I have argued.
Can I mention this? I think, I may have to, if I were to refresh your lordship's memory, your lordship's only said, your lordship did not reject the interim prayer. There is no rejection of the interim prayer. Since it was said that this is a very issue which is pending before the Supreme Court.
Yes.
Your lordship's only said this matter will be listed after so and so time. Nothing has happened there, then your lordship will consider the interim prayer. Lords, by the rising of the court, I will pass on a copy of the interim. Lords, if your lordship feels that this was a matter which your lordship had refused, I am not before your lordship tomorrow. Both the matters may be taken
No,
up.
he will, but not to cure that defect in this case. But not to cure that defect in this case by
That's right,
adding
sure,
your
sure.
case. That's what that.
That's the reason why I said, Lords, now your lordship has specifically directed the matter to be listed after 2 weeks. If that matter.
No, they have primarily objected that this prayer itself is not maintainable.
Writ petition itself is not maintainable.
Then we'll see tomorrow.
Rectification they will carry out.
No, if it is rectified, then the writ petition will not survive.
See, let us,
If
if
the pleadings are there, it will still be there.
rectification which is permissible under the law.
Argue
they
ಮಾಡಿ
can
ಅಂತಿದ್ದಾರೆ.
Convince
If
me.
that is
then
your
we'll
sense,
see.
please argue.
Tomorrow. Yes. This matter tomorrow. Yes, interim order granted, will extend it till tomorrow. Yes.
The lordship may, my lord, note that tomorrow on the maintainability it will be heard.
Yes, sir, maintainability. Yes. If maintainability is be heard, if it is not convinced, then we'll vacate that interim order.
Very well, I am grateful, George.
Cell number 41 and 42, K. Sridhar for petitioner. Swati Al Kamat. Serial number 42.
I am appearing for the petitioner.
Yes,
My lord, as far as R9 is concerned, I am filing a memo.
yes.
R9, service to R9 may held sufficient, my lord. Organ
Who is R9?
R9 Jilla Panchayat formal party or kuda
R7, my lord.
R7.
R7.
Yes.
R9.
I represent the R7, my lord.
You are appearing for-
R7 ನಾ ಹೇಳ್ತಾ ಇಲ್ಲ ಈಗಿನಿಗೆ ಆಫೀಸ್ ನೋಟ್ ಪ್ರಕಾರ R9 ನಾ
ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್.
ಅಲ್ಲ R9 is page number 45. In the amended writ petition I filed, that may be seen, not original writ petition.
Where is that?
Amended writ petition copy filed on 8/7 after serving.
Yes. What is that?
Annexure Q, ರಾಷ್ಟ್ರೀಯ ಆರೋಗ್ಯ ಅಭಿಯಾನದ ರಾಷ್ಟ್ರೀಯ ಬಾಲ ಸ್ವಾಸ್ಥ್ಯ ಕಾರ್ಯಕ್ರಮದ ಅಡಿಯಲ್ಲಿ ಮಕ್ಕಳ ಆರೋಗ್ಯ ತಪಾಸಣೆ ಚಟುವಟಿಕೆಗೆ ರಚಿಸಲಾಗಿರುವ ಮೊಬೈಲ್ ಹೆಲ್ತ್ ತಂಡಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಎಲ್ಲ ಫಾರ್ಮಸಿಸ್ಟರ ಸೇವೆಯನ್ನು ದಿನಾಂಕ 31/3/25 ಅಂತ್ಯಗೊಳಿಸುವುದು ಹಾಗೂ ಸದರಿಯವರ ಜಾಗಕ್ಕೆ 25-26 ಆರ್ಥಿಕ ವರ್ಷದಿಂದ ನೇತ್ರ ಸಹಾಯಕರ ನೇಮಕವನ್ನು ಮಾಡ್ಕೊಂತ ಈ ಮೂಲಕ ನಡೆಸ್ಕೊಳ್ಳೆ ನಾವು 8-10 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದೇವೆ. ನಮ್ಮನ್ನು ತೆಗೆದು ಇನ್ನೊಬ್ಬರನ್ನ ಟೆಂಪ್ರರಿ ಇದ್ದವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕಂತೆ. Kindly see page number 47 in the same, page number 47. Supreme Court order. Service law, ad hoc employees cannot be replaced by another ad hoc employee.
Pass this order, Rashtriya Arogya Abhiyana.
ಅದೇನಂದ್ರೆ ದಿ ಸಿಸ್ಟಮ್
Who is that respondent, Mr.?
ಯಾರು?
Which respondent has passed an order?
ಇದು ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗವರ್ಮೆಂಟ್.
You have passed this.
Second respondent.
Yes, Mr. What is it?
My lord,
ಅಲ್ಲ ಇನ್ನೊಂದು ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೇನೆ ಅವ್ರು ಹೇಳೋದಕ್ಕಿಂತ. ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ, ಪೇಜ್ ನಂಬರ್ 46. ಸಿಮಿಲರ್ ಸೇಮ್ ಮ್ಯಾಟರ್, ಸೇಮ್ ಆರ್ಡರ್.
Same order is to stay.
Same order is challenged. In before Dharwada bench, same order has been stayed.
Where is that?
ಆಮೇಲೆ page number 46 in the amended petition. Page number 46.
Optometrist. ನಾವು ನೇತ್ರ ಸಹಾಯಕ ಇಲ್ಲದೆ ಇದ್ದ ಪಕ್ಷದಲ್ಲಿ ಫಾರ್ಮಸಿಸ್ಟ್ಗೆ ಆದ್ಯತೆ ನೀಡುವುದು. This is the circular. Under the project, this is a centrally sponsored project, my lord. State and center are in partnership, they are implementing this project.
ಈ ಕಾರ್ಯದಡಿಯಲ್ಲಿ ಮಕ್ಕಳ ಆರೋಗ್ಯ ತಪಾಸಣೆ ಚಟುವಟಿಕೆ ರಚಿಸಲಾಗಿರುವ ಮೊಬೈಲ್ ಹೆಲ್ತ್ ತಂಡಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುವ ಎಲ್ಲಾ ಫಾರ್ಮಸಿಸ್ಟ್.
Stay has been granted without noticing this in the earlier case.
But your office is not filing and vacating. Whatever granted, you will take it then.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಹೇಳ್ತೇನೆ ಸ್ವಾಮಿ, ಅನೆಕ್ಷರ್ ಎ ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಸೀನ್
ಅಂತ್ಯಗೊಳಿಸುವುದು ಹಾಗೂ ಸದರಿ ಜಾಗಕ್ಕೆ 25 ರೂಪಾಯಿ ಅಂತ ನೇತ್ರ ಸಹಾಯಕರು ನೇಮಕ ಮಾಡಿ. ನೇತ್ರ ಸಹಾಯಕರು ಇಲ್ಲಿ ಯಾರು? ಇವರು
ಫಾರ್ಮಸಿಸ್ಟ್.
ವೇರ್ ಇಸ್ ದಟ್ ಸರ್ಕ್ಯುಲರ್?
ಮೈಲಾಟ್ ಅನೆಕ್ಷರ್ ಎ
ಮೊದಲು ಆದ್ಯತೆ ನೀಡುವುದು, ನೇತ್ರ ಸಹಾಯಕರು ಇಲ್ಲದೇ ಇದ್ದ ಪಕ್ಷದಲ್ಲಿ ಫಾರ್ಮಸಿಸ್ಟ್ ಅವರಿಗೆ ಆದ್ಯತೆ ನೀಡುವುದು.
ಮೈಲಾಟ್ ನಾವು 9 ವರ್ಷ ಆಗಿದೆ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದ.
Now we want to replace them with a.
You go ahead with that. If they are till that, let them continue. Will you making and will see not to relieve the petitioner, but I am not saying that. You go ahead with. If you get in what is that?
ನೇತ್ರ ಸಹಾಯಕರು,
ನೇತ್ರ ಸಹಾಯಕ
ಫಾರ್ಮಸಿಸ್ಟ್ ಇದ್ದಾರೆ
ಅಂದ್ರೆ ಏನು?
ಆಪ್ಟೋಮೆಟ್ರಿಸ್ಟ್, ರಿಫ್ರಾಕ್ಷನಿಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರು.
ಅವ್ರು ಸಿಕ್ಕಿದ್ರೆ ಇವ್ರನ್ನ ರಿಪ್ಲೇಸ್ ಮಾಡಿ, ಅಲ್ಲಿ ತನಕ ಮಾಡಬೇಡಿ.
It may be clarified that the order will not come in the way of
granting the stay of that circular, not to relieve the petitioner.
Yes. And that will not come in the way of appointing.
ಅದಲ್ಲ, ಒಂದೇ ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೇನೆ, ಇದು ಒಂದೇ ಪ್ಯಾರ ಹೇಳ್ಬಿಡ್ತೇನೆ. ಸಜೆಸ್ಟೆಡ್ ಕಾಂಪೋಸಿಷನ್ ಆಫ್ ಮೊಬೈಲ್ ಟೀಮ್ ಹೆಲ್ತ್, ಇದು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಡೈರೆಕ್ಷನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದು. ಇದರಂತೆ ಇವರು ಅಪಾಯಿಂಟ್ 9 ವರ್ಷದಿಂದ ಮಾಡಿದ್ದಾರೆ. ನಾನು 9 ವರ್ಷ ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ದೇನೆ, ಇನ್ನೊಂದು ವರ್ಷ ಆದ್ರೆ 10 ವರ್ಷ ಆಗುತ್ತೆ, ಆಗ್ಲಿಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ. ಆ ಕಾರಣಕ್ಕೆ ಇದು ಮಾಡಿದ್ದಾರೆ. ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ, ಮೆಡಿಕಲ್ ಆಫೀಸರ್ ಆಯುಷ್ 1 ಮೇಲು 1 ಫಿಮೇಲು ಅಟ್ಲೀಸ್ಟ್ ವಿತ್ ಬ್ಯಾಚುಲರ್ ಡಿಗ್ರಿ ಫ್ರಮ್ ಅಪ್ರೂವ್ಡ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್, ANM ಸ್ಟಾಫ್, ಫಾರ್ಮಸಿಸ್ಟ್ ವಿತ್ ಪ್ರೊಫಿಷಿಯನ್ಸಿ ಇನ್ ಕಂಪ್ಯೂಟರ್ ಅಂಡ್ ಡಾಟಾ ಮ್ಯಾನೇಜ್ಮೆಂಟ್. ಫಾರ್ಮಸಿಸ್ಟ್ ಅಂತೇಳಿ ವಿತ್ ಕಂಪ್ಯೂಟರ್ ಡಾಟಾ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಇದ್ದವ್ರನ್ನ ಮಾತ್ರ ಆಗ ರೆಗ್ಯುಲರ್ ಸೆಲೆಕ್ಷನ್ ಮಾಡಿ ಇನ್ವೈಟ್ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿ 9 ವರ್ಷದಿಂದ ನಮ್ಮನ್ನು ಸೆಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. 9 ವರ್ಷ ನಾವು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೇವೆ. ಈಗ ಇಂಪ್ಯೂಂಟ್ ಆರ್ಡರ್ ನಲ್ಲಿ ನಾವು ಬೇರೆಯವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತೇವೆ ಅಂತೇಳಿ.
ಅನೆಕ್ಷರ್ ಎ ಏನದು?
ಅನೆಕ್ಷರ್ ಎ ಇದೆ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸ್ಕೀಮ್.
ಎಲ್ಲಿದೆ ಅದು? ನೀವು
ಅದು ಫಸ್ಟ್ ಪೇಜ್ ಕೊಡ್ತೇನೆ. ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸ್ಕೀಮ್ ಅದು.
ಇದೇನಿದು?
ಯಾವ್ದು?
ರಾಷ್ಟ್ರೀಯ ಆರೋಗ್ಯ
ಅಭಿಯಾನ ಅಂದ್ರೆ ನಾ ಪೇಜ್ ನಂಬರ್ ಕೈಂಡ್ಲಿ ಸಿ ಪ್ಯಾರಾ ಮೆಲಾಡ್.
ಆಯ್ತು, ನೀವು ಇಫ್ ದಿಸ್ ಸರ್ಕ್ಯುಲರ್ ಇಸ್ ಕಾಂಟ್ರಾರಿ ಟು ದಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸರ್ಕ್ಯುಲರ್, ಯು ಚಾಲೆಂಜ್ ಇಟ್.
ಅದೇ ಅಲ್ಲ, ಸರ್ಕ್ಯುಲರ್ ಅಲ್ಲ. ಸರ್ಕ್ಯುಲರ್ ಯಾವ್ದು ನಾನು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವರು. ಯಾವ್ದು
ಕಾಪಿ? ನಿಮಗೆ ರೂಲ್ಸ್ ಸರ್ಕ್ಯುಲರ್ ಎಲ್ಲ ಕಾಪಿ ಕೊಡ್ತಾರ ನೀವು?
ಅಲ್ಲ, ಸರ್ಕ್ಯುಲರ್ ಗವರ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿ
ಕೊಟ್ಬಿಟ್ಟು ಚಾಲೆಂಜ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೂ ವಿಲ್ ಟೆಲ್ ಮಿಸ್ಟರ್?
ಬೇಡ, ನಾ ಸರ್ಕ್ಯುಲರ್ ಅವ್ರನ್ನ ಕೇಳ್ತೀನಿ, ನಾನು ಕಾಪಿ ತೊಳ್ತೇನೆ. ಅಲ್ಲ, ಈ ಪಾಯಿಂಟ್ ನಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 47 ಮೇಲೆ.
No, now I am not deciding, mister. I am granting interim order. I am not saying that what that circular stated by the.
Lord, I am told it's refractionist.
Ophthalmologist.
Ophthalmologist will be a physician. Either optometrist or a refractionist would be a technician.
What is that correct word used?
My lord, the word the officers told me is refractionist. My lord.
Yes, it will not come in the way.
ಇಲ್ಲ ಅಂದ್ರೆ ನೇತ್ರ ಸಹಾಯಕರು ಅಂತಾನೆ.
I will not come in the way of that. Kannada is the best and ultimate. Yes. I will not come in the way of the respondent to select ಸಹಾಯಕರ ನೇಮಕಾತಿ ಮಾಡುವ. Yes, not come in the way of that. Select the ನೇತ್ರ ಸಹಾಯಕರು till next date of hearing. Yes. as per that circular annexure Q dated 29/3/2024. Yes. ಆಯ್ತು, ಅದು ನೀವು ನೋಟಿಸ್ ತಗೊಳ್ಳಿ ಈಗ now it is not necessary. Yes, week's time is granted to pay the process, issue notice to respondent and liar.
ಕೊಡ್ತೀನಿ ಸರ್, ನನಗೆ ಒಂದೇ ಕಾಪಿ ಕೊಡ್ತೀನಿ, ಅದನ್ನೇ ಕೊಡ್ತೀನಿ.
Serial number 43, Ravindra VS for petitioner, government advocate.
For petitioner.
Yes.
But annexure, Malad B, Malad the petitioner has been appointed. But in the ink page number 17, Malad, only one post is there for Malad the appointment of Malad the.
You read that operative portion of that. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ
Malad, ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ತಾಲೂಕು ಹಿಂದುಳಿದ ವರ್ಗ ಕಲ್ಯಾಣಾಧಿಕಾರಿಗಳ ಕಚೇರಿ ಗ್ರೂಪ್ ಡಿ ವೃಂದದ ವಕೀಲರ ಜವಾನರ ಹುದ್ದೆಗಳ ಸೃಜನೆಗೆ ಬದಲಾಗಿ ಅವಶ್ಯಕರು ಒಂದು ಸಿಬ್ಬಂದಿ ಸೇವೆಯನ್ನು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ 7 ಡೇಟೆಡ್ 7/7/2007 ಅನ್ವಯ ಸರ್ವಿಸ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಬೇಸಿಸ್ ಮೇಲೆ ರಾಜ್ಯದ ಎಲ್ಲಾ ತಾಲೂಕು ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಕಲ್ಯಾಣಾಧಿಕಾರಿಗಳ ಕಚೇರಿಗೆ ಈ ಕೆಳಕಂಡ condition has been imposed only, Malad, it should be renewed after 7 months. Malad, I have been renewed continuously from Malad, from the appointment is on 2018 itself. Up to 13/1 Malad, the 2025. Now Malad, based on Malad, some of Malad, the political pressures has been made by Malad. I am going to relieve Malad from the said Malad. Malad, there is no order. ಇವತ್ತು ಬೆಳಗ್ಗೆ ರಿಲೀವ್ ಮಾಡ್ತೀವಿ, you have to make signature ಅಂತ they have Malad threatened.
Nature respondent take necessary measure to through the policy decision to scheme to regularize that petitioner into the
Please
service.
Malad, in view of Malad the decision of Supreme Court itself.
When did you appoint?
Malad, I have been appointed on 2018 itself as per the order of Malad the
2018.
2/1/2018.
Which law says you have to be regularized?
But since Malad, the Supreme Court decision is Malad has been considered by the Supreme Court in view of Malad the Jaggu versus Union of India. Where Malad the court, where Malad the department.
So he is seeking regularization to a civil post.
Then you have to go to that KT.
Malad down.
Then you have to go to that KT.
Malad down. No Malad, I am not only Malad sought for that relief. Malad, my continuation of Malad the service has to be considered by the department itself.
Regularization to that civil post. Then you have to go to that KT.
Malad, now Malad, I have been appointed on the contract basis.
Even contract
Malad,
basis.
though Malad, I have been contract service Malad, now Malad, by virtue of Malad, a letter has been forwarded to Malad the department. But last I can also Malad.
No, first you answer this, whether you have to go to that KT or not. You go and approach the KT and seek regularization there, Mr.
But till such period Malad, my service should not be Malad terminated. ಯಾಕಂದ್ರೆ ಇವತ್ತು ಬೆಳಗ್ಗೆ ಬಂದ್ಬಿಟ್ಟು ಅವರು ಟರ್ಮಿನೇಟ್ ಮಾಡ್ತೀನಿ, ರಿಲೀವ್ ಮಾಡ್ತೀನಿ ಅಂತಾರೆ. But by virtue of Malad the decision considered by the Supreme Court itself, Malad, a termination should not be made only on the ground that Malad he is appointed on the contract basis itself.
No, Mr. Counsel,
The court has
regularization, they have completed 10 years, you have not completed 10 years, even KT go through, you cannot be seek for a regularization. You are appointed in 2018. How many years you have completed, Mr.?
Not 7 years.
Then how can you seek for a regularization?
But by
Of rejecting itself by me, I am sending to there. Even 10 years, 10 years.
My second prayer has to also be
What
considered.
is the second prayer?
Must issue written direction to the respondent from continuing the service of the petitioner in the service
Nim
in
contract
D group
employee nimge
in the fourth.
continue
Malad,
ಮಾಡ್ತಾರೆ.
that is how Malad, the Supreme Court Malad has considered that aspect Malad in details. Malad, the court,
Still, a government advocate has raised a preliminary objection that petitioner seeking a regularization to the post, to that civil post. Hence, he has to first approach that Karnataka Service Administrative Tribunal in view of judgment of apex court in case of so and so. The writ petition is disposed of, reserving liberty to the petitioner to approach Karnataka Service Administrative Tribunal.
but till such period Malad, the
No interim
department
order in
Malad
earlier
from
also.
Malad from last 25.
ಯಾವ್ದಾರ ಕೇಸಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡ್ರು ಕೊಟ್ಟಿದ್ದು.
But the court has granted an interim order in this case, my lord, by consider, please, my lord.
Yes. Then
Court has granted this case, my lord, by consider, please, my lord.
Yes. Then
Court has granted, my lord, by considering, my lord, the decision of.
Interim order granted by this court.
Not to disturb the petitioner till next date anta ಇದೆ.
Yes, interim order granted by this court. ಈ ತರ ಹಾಕ್ಬಿಡಿ. The respondents are directed not to. What is that earlier granted? First ಏನ್ ಕೊಟ್ಟಿದ್ರು? Extended till next date of hearing. Interim order granted earlier is extended. Hearing service of the petitioner back by this welfare department shall not disturb. Respondent directed interim order granted by this court dated 6/3/2025 will be extended for further period of 2 weeks.
My lord, at least 4 weeks, my lord, she has, at least for the court, my lord, I have.
Dispose
My lord, otherwise, my lord, I have to move the matter, it has to be listed, that is, my lord, at least 4 weeks, my lord. Another 2 weeks may be granted.
Yes.
By considering, my lord, the length of service.
Interim order granted earlier is extended for a period of 7 days.
Your lordship, my disability pension, your lordship, my disability pension was taken away in the year 1998, your lordship. I'm 72 years old, your lordship. I have served in the military for 23 years. During my service, during such service, I was being disabled, and at the age of 41, I got retired in the sense I was asked to get voluntary retirement, your lordship. For 5 years, there was a disability pension given to me, your lordship. After 5 years, that is 1997, your lordships, my disability pension has been taken away, stating that I am fit for any kind of the civil service, your lordships. I don't know for what reason. Even then, I went to the concerned authorities. I have given the representation letter. My last representation was in the year 2003, your lordship. That also is not been considered. Again, my condition is such that I'm not even able to look after my medical expenses, your lordships.
Why they are not considered?
No, your lordships.
Reassessment is medically at the nearest designated hospital to restore. What is that reassessment of medical?
Whatever disability I have gone through so many years, your lordships, according to them,
short
let them.
accommodation, we have trying to contact the concerned officer. They have sent a mail that they will share the information regarding the concerned
When do you
officer.
want?
After 1 week, months.
Yes.
Your lordship, it is too much, your lordships.
Consider request of respondent as a last chance. Week's time is granted. Leave this matter on 19th.
Grateful.
What is this, Mr.? Ready? Want to go through that?
Tomorrow, Lord, because otherwise it will.
Tomorrow. Yes, we'll have it on 18th.
No, I'll continue.
18th. Yes.
Then they are serving the documents, my lords.
No, if you are ready or you want time, you say yes.
Only CNR rules and then OMs, latest OM of the government of
Yes,
India.
18th.
Monday, my lords.
Monday, next
Tuesday.
week is full.
Tuesday, my lords.
Otherwise, we'll see on 13th.
Obliged. Obliged.
Leave this matter on 13th. The request of
Lord, my name may kindly be deleted, my lords.
office is directed to delete the name of M.N. Kumar.
No, my lords, Vaibhav Malimat.
Vaibhav Malimat for respondent number 3. Yes.
Great for the lords.
Serial number 46, Ashwini Rajagopal for petitioner.
With my lord's kind leave. What's the challenge, my lords, is to the order of suspension, my lords.
Yes.
At annexure E, my lords, page 27. This order, my lords, is issued on 11/1/2025, my lords. Till date, no charge sheet is issued, my lords. The 6 months completes on 10/7/2025, please, my lords.
Yes, Mr.
By operation of law, my lord, there is a deemed revocation now.
Yes.
Now, only
In
thing
terms
is,
of-
my lord, the point remains is with regard to posting, my lord.
Yes.
That he cannot be posted in the same place, my lord.
That you can any posting
In the same place, my lord.
That you can do it.
any posting.
You will be come to the replay. You see, suspension order will go.
Please.
You can do whatever you want, that will not come in that.
There is a
Only thing
deemed
is that in view of
Why?
that order has to be quashed, that's all.
My lords, I belong to the BBMP, my lords, Assistant Revenue Officer.
Yes. In this writ petition, petitioner challenging
Annexure E,
Annexure E dated 11/1/2025 passed by fourth respondent.
Please.
Whereby petitioner has been kept under suspension. Ten five
10-5.
B.
5B, my lords.
Department is not commenced against the delivered servant, charge sheet is not filed. Judge should decide whether to revoke or continue suspension of charge servant. Just decide order to continue within the period, the suspension should be deemed to have been revoked. Yes.
It provides that if no order is passed, it shall be deemed to be revoked.
Yes. Petitioner is in the cadre of Assistant Revenue Officer in BBMP, Bangalore. By impugn order 11/1/2025.
11/1/2025.
11/1/2025. As on today, the departmental inquiry is not commenced. In view of the provisions of Rule 10(5)B, the impugned suspension order has to be quashed. Accordingly, writ petition is allowed in part. Impugn order dated 11/1/2025 Annexure E is quashed. In respect of other relief is concerned, it's kept open.
Please, I have submitted a representation dated 1/8/2025. my lords. I'm handing it over.
That will take in care. Yes.
It may be observed kindly, my lords, that it may be considered. To consider the representation for posting.
No, that if the suspension order is quashed, he will go back to his work. Then you have to be passed any order that is the, why do you want that all directions and all? Yes.
Very well. Grateful to my lords.
All pending applications are disposed.
Please.
Serial number 47, CS Madhu for petitioner. Krishnamurthy.
Yes.
For petitioners, my lord. Petitioner has sought for writ of mandamus.
Yes.
Directing the respondents to admit the petitioner into grant-in-aid, my lords. This is the
Admit the
third round
petitioner
of
to-
litigation.
Particularly, mandamus direct the respondent to send the proposal, admit the petitioner to grant-in-aid.
Please,
Yes.
my lords.
Who has to send?
Lords, as per the order passed by the
So
principal
where is your
secretary,
appointment?
my appointment order is at annexure A, Pahitava.
Anumodiside.
Please, my lords. Thereafter, due to misunderstanding between the petitioner, the department, as well as the management, decision was not taken to send my proposal to the government, my lords. For admitting grant-in-aid, my lords.
Grant-in-aid.
It is clearly evident from annexure G, my lords, page number 35, E paradal ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. Annexure G, page number 35, para E, my lords.
Yes.
Second, ಸದರಿ ನೇಮಕಾತಿ ಪ್ರಕರಣದಲ್ಲಿ ಇಲಾಖೆಯ ಹಂತದಲ್ಲಿ ಸ್ಪಷ್ಟ ನಿರ್ಧಾರವನ್ನು ತೆಗೆದುಕೊಳ್ಳುವಲ್ಲಿ ಆಡಳಿತಾತ್ಮಕ ಸಮಸ್ಯೆಯಿಂದ ವಿಳಂಬವಾಗಿದೆ. ತೆಗೆದುಕೊಳ್ಳುವಲ್ಲಿ ಆಡಳಿತಾತ್ಮಕ ಸಮಸ್ಯೆಯಿಂದ ವಿಳಂಬವಾಗಿದೆ. Thereafter, I made several representations, approached the appellate authorities. Thereafter, I sought direction from the government. Recently, on 30/4/2024, at annexure M, page number 63, my lords, I approached the government under section 133 of Karnataka Education Act, seeking specific direction to the Director Pre-University Education, my lords.
What is the direction they have issued?
Direction is at page number 67, my lords. ಮೊದಲನೇ ಮತ್ತು ಎರಡನೇ ಪ್ರತಿವಾದಿಗಳು
Page number 67.
page number 67, my lords. Yes, given reasons for the decision at para number 6, my lords. ಅರ್ಜಿದಾರರನ್ನು ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗೆ ನೇಮಿಸಿಕೊಂಡಿರುವುದು ನಿಯಮಾನುಸಾರವಾಗಿರುವ ಕಾರಣ ಅನುದಾನ ರಹಿತವಾಗಿ ಅನುಮೋದಿಸಲಾಗಿದೆ. ಅರ್ಜಿದಾರರು ನಿಗದಿತ ವಿದ್ಯಾರ್ಹತೆ ವಯೋಮಿತಿ ಹೊಂದಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರನ್ನು ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿಕೊಳ್ಳದಿರುವುದು ಮತ್ತು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದ ನಿರ್ದೇಶನದ ತರುವಾಯ ಅದನ್ನು ಪಾಲಿಸದಿರುವುದು ಆಡಳಿತ ಮಂಡಳಿಯ ಲೋಪವಾದಿಗಳು ಈ ಆದೇಶ ತಲುಪಿದ 15 ದಿನಗಳೊಳಗಾಗಿ ಅರ್ಜಿದಾರರನ್ನು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಸಂಬಂಧ ಪ್ರಸ್ತಾವನೆ ಅಥವಾ ಅರ್ಜಿದಾರ ಬೆತನಿ ಸಂಯುಕ್ತ ಪದವಿ ಪೂರ್ವ ಮಹಾವಿದ್ಯಾಲಯ ನೂಜಿ ಬಾಳ್ತಿಲ ಅಂಚೆ ಕಡಬ ದಕ್ಷಿಣ ಕನ್ನಡ ಇಲ್ಲಿನ ಅನುದಾನಿತ ಇತಿಹಾಸ ಉಪನ್ಯಾಸಕರ ಹುದ್ದೆಗೆ ವರ್ಗಾವಣೆ ಹೊಂದಲು ಆಕ್ಷೇಪಣೆ ಇಲ್ಲ ಎಂಬುದಾಗಿ ನಿರಪೇಕ್ಷಣಾ ಪತ್ರವನ್ನು ಉಪನಿರ್ದೇಶಕರಿಗೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು. ಒಂದು ವೇಳೆ ಆಡಳಿತ ಮಂಡಳಿಯು ಪ್ರಸ್ತಾವನೆ / ನಿರಪೇಕ್ಷಣಾ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸದಿದ್ದಲ್ಲಿ ಉಪನಿರ್ದೇಶಕರು ಈ ಬಗ್ಗೆ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಪ್ರಸ್ತಾವನೆ ಸಿದ್ಧಪಡಿಸಿ ನಿರ್ದೇಶಕರಿಗೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು. ಸದರಿ ಹುದ್ದೆಯು ಪರಿಶಿಷ್ಟ ಪಂಗಡಕ್ಕೆ ಮೀಸಲಾದ ಹುದ್ದೆಯಾಗಿರುವುದರಿಂದ ಮತ್ತು ಅತಿ ಮುಖ್ಯವಾಗಿ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಯಾಗಿರುವುದರಿಂದ ವಿಳಂಬಕ್ಕೆ ಆಸ್ಪದ ನೀಡದೆ 2 ತಿಂಗಳ ಒಳಗಾಗಿ ಭವಿಷ್ಯಾನ್ವಯವಾಗಿ ಅನುದಾನಕ್ಕೊಳಪಡಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ನಿರ್ದೇಶಕರಿಗೆ ನಿರ್ದೇಶಿಸಿದೆ. 2005ರ ನಿಯಮಗಳ ಪ್ರಕಾರ ಅರ್ಜಿದಾರರಿಗೆ ಕನಿಷ್ಠ ಮೂಲ ವೇತನ ಪಾವತಿಸಲು ಆಡಳಿತ ಮಂಡಳಿ ಬಾಧ್ಯವಾಗಿದ್ದು, ಪರಿಶೀಲನಾ ಅರ್ಜಿ ಆದೇಶದ ದಿನಾಂಕದಿಂದ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವವರೆಗೆ ಅರ್ಜಿದಾರರಿಗೆ ಕನಿಷ್ಠ ಮೂಲ ವೇತನ 3 ತಿಂಗಳ ಒಳಗಾಗಿ ನೀಡಲು ನಿರ್ದೇಶಿಸಿದೆ. ಈ ನಿರ್ದೇಶಕರು ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಪದವಿ ಪೂರ್ವ ಇವರು ಈ ಆದೇಶ ಹೊರಡಿಸಿದ 1 ತಿಂಗಳೊಳಗಾಗಿ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಇಲಾಖೆ ನಿರ್ದೇಶನವನ್ನು ಪಾಲಿಸದೆ ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಕಾಯ್ದೆ 53 ಉಪಕಲಂ 2 7ರ ಉಲ್ಲಂಘನೆ ಮಾಡಿರುವ ಕಾರಣ ಅನುದಾನವನ್ನು ಹಿಂಪಡೆಯುವ ಬಗ್ಗೆ ಸ್ಪಷ್ಟ ವರದಿಯೊಂದಿಗೆ ಸರ್ಕಾರಕ್ಕೆ ವರದಿ ಮಾಡತಕ್ಕದ್ದು. None of the directions have been complied with.
Who is appearing for that institution? Have you recommended his name? No, that there is no direction you to
him from service, thereafter again took him back into service. This has happened over a period of time.
No, he is not in the service now.
He is not.
I am not allowed to
He's not allowed
work in the institution.
No, then you invoke that 52(3) and take that.
No, I am told that the institution is no longer functioning, although it's in the process of closing down. It's not closed down. It's on the verge of being closed down.
No, that is different. Now there is any directions.
In any case, my lord, throughout there was a direction in 2021 under 131 revision, which my learned friend read out.
Yes.
My lord, he read out at page
67.
30, annexure G, I believe.
Please, 35 minutes.
35. 35 is the order in revision by the commissioner. Again, here also there was a direction given to pay him the minimum wages. There was a direction given again by the principal secretary. Last paragraph. May I read the last paragraph? My learned friend read E.
Yes.
The last paragraph, the final direction may be seen.
Yes.
ಅನುದಾನಿತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜುಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ನಂತರ ವೇತನ ಅನುದಾನಕ್ಕಿದ್ದು ನಂತರ ವೇತನ ಅನುದಾನಕ್ಕೆ ಒಳಪಟ್ಟಂತಹ ಯಾವುದೇ ನೌಕರರು.
Paragraph, which paragraph you are reading?
Page 35, last paragraph.
No, he read page 67.
ಅಲ್ಲ 35 ನು ಓದಿದ್ರು to show para E, ಕನ್ನಡ E, ದೀರ್ಘ E. Page 35 ಅಲ್ಲಿದೆ. This is the revision, my lord, 131.
No, what is this annexure M?
Annexure
ಅಂತಾನು ಹೇಳಿದ್ದಾರೆ. ಸತತವಾಗಿ ಹೇಳಿದ್ರು ಮಾಡಿಲ್ಲ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವರು.
Who is
Now
that?
they are on the verge of my lord closing down.
No, without that, no, 2015 you could have complied there itself. No, who is that assistant? ಯಾರಿಗೋ directions ಇದೆಯಲ್ಲ.
Kindly peruse page number 39.
My lord, ಇಲ್ಲಿ ಎರಡು I'll just point out, my lord, in the direction under 133 annexure M. My lord, there are two difficulties, my lord. Proper parties, there is they have not made the management as a party here.
No, you forget about management. Please see that second condition.
Second
If
condition.
management is not recommended, see.
Because it is a SC/ST post, then
ಹುದ್ದೆಗೆ
the
ಒಂದು
director should
ದಾಖಲೆಯಿಲ್ಲ ಎಂಬುದಾಗಿ
submit
ನಿರೀಕ್ಷಣಾ ಪ್ರಮಾಣ ಪತ್ರ ನಿರ್ದೇಶಕ ಸಲ್ಲಿಸುತ್ತದೆ. ಒಂದು ವೇಳೆ ಆಡಳಿತ ಮಂಡಳಿಯು ಪ್ರಸ್ತಾವನೆ ನಿರೀಕ್ಷಣಾ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸದಿದ್ದಲ್ಲಿ ಉಪನಿರ್ದೇಶಕರು ಈ ಬಗ್ಗೆ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಪ್ರಸ್ತಾವನೆ ಸಿದ್ಧಪಡಿಸಿ ನಿರ್ದೇಶಕರಿಗೆ ಕಳಿಸತಕ್ಕದ್ದು.
now
Will, yes.
I'm pointing. Now the difficulty is the college, the institution is on the verge of closing down. They don't have student strength and they don't want to, and that is the reason in the first direction, he was asked to be transferred to another Bethany pre-university college.
ಬೆತನಿ ಸಂಯುಕ್ತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜ್ ಯಾರ್ದದು? ಇವ್ರದೇ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್
ಇಲ್ಲ, ಇವ್ರದಲ್ಲ. But the problem is now unless he is admitted to grant in aid, We cannot transfer him under the rules.
You first admit it a grantee-net and transfer him. That is the direction to you.
Right, my lord.
Upanirdarshakaru.
Please.
Yes.
I'm only pointing out the difficulties.
Yes.
A solution may be.
ಪರಿಶೀಲನಾ ಅರ್ಜಿ ಆದೇಶ ದಿನಾಂಕದ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವವರೆಗೆ ಅರ್ಜಿದಾರರಿಗೆ ಕನಿಷ್ಠ ಮೂಲ ವೇತನ 3 ತಿಂಗಳ ಒಳಗಾಗಿ ನೀಡಲು ನಿರ್ಧರಿಸಲಾಗಿದೆ. ನೀವು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ ಇಲ್ಲಿ?
Is party, my lords. Respondent number 1 to 1 is convener, second one is principal, third one is.
Yes,
deputy
management
director.
is there. There are two things. One, you admit him to that grantee-net, find out the place and send it. For remaining this period, as per that condition or management has to,
Please.
we'll direct that
Lord,
to complain
may I just file
or
one
that you.
statement of objections ಹಾಕ್ಬಿಡ್ತೀನಿ.
Yen beda, there is a directions to that, you have not challenged. You first admit it to the grantee-net and post it to the place where there is a vacancy. Then second is that you have to pay all arrears, Mr. We want to implement this order, that's all. His direction is to-
ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡಿ ಸುಮ್ಮನೆ. We'll file our
not that,
objections and
No,
we'll clarify all the.
See, you come with that order of admitting to the grantee-net and transfer by next time.
Please.
Then we will direct the
No, I'll
management.
seek instructions on that also. What can be done, my lord?
Yes. When do you want?
My lord, it can be taken up next week itself.
Yes.
Any convenient date, my lord.
Later on 20th.
Please.
Yes, it is better, let them pass an order because their proposal is not necessary as per that order. You admit it into grantee-net and find out the place, send him where there is a vacancy.
My lord, may I just-
Remaining amount which has to be,
that may be clarified by the.
that also clarified that if it is closing down, you close it and that if it is closing down, you close it and seize that
Before closing,
property.
let them clear their liabilities.
Yes, yes. Or that you settle with them for payment of this, in between that. Yes.
Grateful. Yatish, yes, for petitioner. Abhishek Kumar.
ಎಷ್ಟು serial? Yes.
Please, my lord. Well, the petitioner was appointed in the respondent number 2 university as a temporary lecturer, my lord, in the year 2016.
Yes.
It was a sanctioned post.
Hmm.
As per section 50 of the Karnataka University Act 2056, my lord, of
Yes.
2000. And now, my lord, now they have issued, and this court was appreciate the facts and has also granted interim order. The interim order, my lord, which is on 18th July 2024, where the respondent was directed to continue respond for the academic year, that is till June. But on June 30th, my lord, they have given me an order stating that I have been bidugadegolisalaಗಿದೆ ಅಂತ ಒಂದು order pass ಮಾಡಿದ್ದಾರೆ.
Where is that?
That order, my lord, I filed in a separate IA for directions. IAs of dated
What is that
29/7/2025. In IA, my lord, page number 10, annexure A.
What is the interim order passed by this court?
Please, my lord. Further, the learned counsel submits that in similar circumstances in WP number 16116 of 2024, this court has granted interim order directing the respondent not to replace the petition therein with another temporary employee and to consider the petitioner's continuation for the next academic year. As a clarification, the learned counsel submits the WP number so and so. The petition is working as an assistant professor.
Now, why you want to relieve him from that, Mr.? Admission is over.
My lord, may I submit? My lord, may I submit this, my lord? In K. Krishna and others from the University of India, my lord, divisional bench has told if 10 years, 3 to 8 years, if it's continued, then the presumption can be drawn that the workload will continue. Because 10 ವರ್ಷನೇ continue ಆಗ್ತಾರೆ, the sudden workload will not stop because the university has a run.
No,
Needs to run.
see here, depending upon the student, if the admission is less, then workload will be less.
That's what
Who
my
will
lord,
pay that?
in the same university has suffered an order. They have told that if the continuous workload is there, then a presumption can be drawn. Now they cannot come and tell that workload.
Judgment.
Yes, my lord, K. Krishna and others was University of Mysore, the same university judgment, and this has been the Supreme Court has been confirmed.
2003. What is this?
Please.
Mr. Absorption of the regularization time.
If your lordship may come to page number 2603, my lord.
No, all this is the facts. Now,
My lord, if Please, my lord, the operating portion is at
Counsel,
page number 75.
no, your right is only if they are replaced by you by other set of temporary employee. Otherwise, your right is for the term which you have been appointed.
I agree. I bow down for the.
If they don't want to appoint any teachers,
But that is what the observation has been done in the divisional bench. my
no,
lord.
if they don't
Because
want to
we are
appoint,
almost 10 years we have served. My age is around 45. Now they cannot tell me that, no, I cannot take you back. Artificial break should not be implemented. Artificial break should not be implemented, my lord.
no, their artificial break is for only 1 or 2 days. Earlier, what they are doing, there are 2 days artificial break and they will give that. Now they are doing it continuity of service, that's all. Here, see, they are appointing you only for an academic year. Where there is an academic service is there, to that only. Therefore, guest lecturers, how to be appointed, that circuit, ide ide. Rules say that, okay, you show that what is the rules which.
My lord, the rule which applies for this is the
Guest
Karnataka
lecturers ಗೆ
University
ಏನೋ
Act
circular issue
2000.
ಮಾಡಿದಾರಲ್ಲ?
Karnataka University Act 2000, my lord. Section 56.
What it says?
Temporary appointment, notwithstanding anything in section 53, 54 and 55 and 57, the vice chancellor may make temporary appointments for not more than 1 year duration to post of lecturers and such non-teaching staff as may be specified in the statutes. Where such posts are either temporary or appointments to such posts cannot be made in accordance with section 53, 54, 55 and 57. All those sections deal with the permanent employee. My lord, despite this section 56 temporary, all the procedure has been followed. There was a committee formed,
No,
interview
therefore,
has been taken.
he cannot be appointed more than 1 year.
Please, my lord, he cannot be appointed more than this. This provision was implemented with the intention that students should not suffer. But however, they are misusing that provision
No,
by taking me for 1 year, again giving me stop break, again taking me for another 1 year, again give me stop break.
Is what that you cannot be appointed 5 years at a time. You can be appointed every year by that vice chancellor. There is no power to appoint you 2 years.
Please, 6 minutes for 1 year. Only that term has been changed. Verbatim, it's the same provision, my lord.
Yes.
And honorable single bench of this court also, my lord, observed that.
Yes.
That is of the, that judgment, my lord, I'll place before this court as well.
Yes, mister, what is this judgment? Is it applicable? Now that all your, no, guest lecturers ಗೆಲ್ಲ ಒಂದು circular rule, something I have seen, mister. Recent guest lecturer ಹೆಂಗ್ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಗೆಸ್ಟ್ lecturer ಅಂತ ವರ್ಡ್ they have used.
We'll seek.
ಯೂನಿವರ್ಸಿಟಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀರಾ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರು. What is this, mister?
The procedure they have adopted is as per the sanction
No,
method, my lord.
This is not one case, mister. Every day I am seeing that 100 cases. There is a separate rules or something they have been made for a guest lecturer. You see that? Executive order is there for a guest lecturer itself, mister.
Lord, and in the
You have to
similar
bring
matters,
all
my
that
lord,
and we establish that case, mister.
Lord, in similar matters, this court was granted interim order stating that if workload is there, let them be continued. The same benefit may be granted to this petition also, my lord.
No, that workload is there, they will continue that.
That may be
will made
recorded.
clear. Yes.
We'll continue.
Yes.
That may be recorded, my lord.
Yes. Learned counsel for the petitioner has submitted that. There is a apprehension that petitioner service will not be continued for the academic year 25-26. Learned counsel appearing for the university has submitted that. The university will come to know that.
Number 49, Raghavendra Ji Gayatri for petitioner.
Yes.
Government advocate.
Lords, what is under challenge is promotion and endorsement issued denying my promotion. Lords, may I seek one adjournment in this because senior is not well and he has not come to office and the instructions from client are to senior only.
Yes, when do you want? Next week.
Date, my lords, next.
The request of counsel for the petitioner, leave this matter on second. Yes.
Deeply obliged.
Cell number 50, Satish K for petitioner.
Yes.
Government advocate.
My lord, the petitioner has given voluntary retirement due to, my lord, ill health in 23. It is aided, my lord, a technical institute, my lord. There is no provision, my lord, to give a voluntary retirement. But a scheme was introduced in 2007, Annexure J, page 35. It is not finalized.
No, they are not finalized.
Not finalized. Then, my lord, they published the rules before this court, produced it, My lord,
No,
this-
last occasion you have argued this.
Oh,
There
they
somebody
filed
was-
affidavit that in the year, my lord, January 25, they will, efforts will be made regarding finalized draft rules in accordance with the due procedure in law as actually as possible ಅಂತ 28/1 affidavit ಹಾಕಿದ್ರು. ಈವರೆಗೂ ಫೈನಲ್ ಮಾಡಿಲ್ಲ. ರೂಲ್ಸ್ ಸೇಸ್ my lord 15 days ಫೈನಲ್ ಆಗಬೇಕು ಅಂತ ಕೊಡಿ.
Where is that?
Yes, they admit that. This affidavit is filed, you got the rule only. 23 years publish ಮಾಡಿದ್ದಾರೆ.
Additional Advocate General appear ಆಗಿದೆ. Somebody has appeared last
ಹೌದು.
occasion. He said we will do it ಅಂತಾನೆ.
ಹೌದು, ತಾವೊಂದು ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿ ದಯವಿಟ್ಟು ಯಾಕಂದ್ರೆ ಅವನಿಗೆ ಆರಾಮಿಲ್ಲ.
ಇವರು
Unable to
my
get
colleague
up
was
from the
appearing
bed.
in this matter, my lord. He is held up in, my colleague, Mr. Siddharth was appearing in this matter.
By which time he may die also.
ಅಲ್ಲ ಈ
Situation
ಇದ್ರಲ್ಲೇನಾ
is so bad.
ಇವ್ರು ಒಬ್ಬ Additional Advocate General
Has to be obtained in the subordinate decision, thereafter approval of the cabinet in mandatory in this matter. Next, I state that all efforts will be made regarding finalization of the draft rules in accordance with the due procedures in law as expeditiously as possible ಅಂತ 28/1/25 ಹಾಕಿದ್ರು. ಈಗ ನಾವು 8th month ಅಲ್ಲಿ ಇದ್ದೇವೆ.
No, what is the difficulties in finalizing the?
Some time may be fixed, but extended benefit will not.
Yes, Mr.
ಸತ್ತೋಗ್ಬಿಟ್ಟು ಅಷ್ಟೊಳಗಡೆ.
You
Kindly have it tomorrow or pass it over, my lord. My learned friend is supposed to appear in this
pass
matter.
over.
He's held up in another matter.
will grant some sufficient time, we finalize it that within that time.
Yes. ಇಲ್ಲ ನಾಳೆ ಇಟ್ಕೊಂಡ್ಬಿಡಿ ಸರ್.
Pass over, let him come.
Okay,
That is the
please,
only I will
please.
dispose of. Yes.
Cell number 51 adjourned, cell number 52, Sundaresh HC for petitioner, connected matter, government advocate.
Appear for petition in this case. This is a case, my lord, the second petition is a D group employee working in the aided institutions. My lord, the proposal has been submitted before the government for approval. And his name has been shown in the list also. Then my lord, that endorsement came to be issued that as per the notification issued by the government in the year 2017, the all D group employees has to be recruited through outsource agencies. That has been quashed by the Honorable Court. You will also may kindly see. Then this rules was clarified by the government at Annexure N. You will also may kindly see, stating that this rules is not applicable for the employees who are appointed prior to notification. This has been clearly stated. So in spite of that, my lord, you will also may kindly see Annexure N. This is very important. This rules is not applicable. It's only a prospective in nature. This petition was appointed prior to these rules.
ನೀವೇನೋ quashed ಅಂತಾರಲ್ರಿ ಎಲ್ರಿ?
ಇದು annexure ಇಲ್ಲಿ ಇದು this endorsement has been quashed. Annexure R ಅಲ್ಲಿ your last may or page 72 judgment ಇದರಲ್ಲಿ para 5 your last may. It is clear as annexure yes that the D group worker being admitted to grant-in-aid can be considered added to the notification dated 26/9/2007. If such D group workers have been working prior to the amendment made to the rules. Taking note of the clarification at annexure yes and also the letter addressed by third respondent as per annexure V. Annexure, the list wherein petition name is found at serial number 1053, subject to the writer in the clarification on 7/12/2020. If the petitioner fulfill the relevant criteria, including seniority in the said institution, the request of the petitioner as noted in the recommendation at annexure V is to be considered by respondent number 1 and necessary order to be passed. Such consideration to be concluded within a period of 3 months from the date of petition furnishing certified copy of the order to respond. The endorsement dated annexure Q is set aside in the light of the clarification of annexure. The Q is annexure, this endorsement.
No, in same petitioner.
Yes, sir, same petitioner.
Yes.
Then, my lord, again, same endorsement came to be issued. Then, my lord, annexure S is the director has submitted a report before the government for recommending the post for admitting grant-in-aid.
Why this rejected again?
Then, my lord, annexure.
Hmm. 11/1. Yes.
7 teachers and 1 SCA
Yes.
is admitted to grant-in-aid.
Yes.
However, no proposal had been sent at that stage, 2012.
Yes.
To admit the group D post and by the petitioner to grant-in-aid. So that only regarding that aspect, he has to clarify why it was not sent. Otherwise, he has to be.
Yes.
Thereafter in 2016 and 2014.
Yes.
Proposal proposal was sent by the government to, admit it to granted, by the department.
Yes.
Thereafter, the, 4/5/2015, 4/8/2015. Commissioner sends, list has been sent to the government. Among them, serial number 5,
Petitioner name is also there. Yes.
Annexure, yes.
serial number 5.
Fine.
Yes.
He has been recommended. Now, as per the rules, the amended rules from 2017,
Yes.
all group D posts will cease to exist.
Yes.
As per note 1 of the amended rules.
Yes.
And as per note 2, all group D posts are to be filled up by
Grant in excess of the staff pattern, the post held by such excess staff shall ceases to exist consequent to the retirement, promotion, resignation, dismissal, removal. And then auxiliary non-teaching service in an aided high school, including service.
ಅದಲ್ಲ ಆಯ್ತು ಈಗ ನಾವು
Yes, ಈಗ ಇದನ್ನ this was clarified by the government.
2017 ಎಲ್ಲ not teaching
ಇದು
in this case, it is a
Pre-
2015.
prior to,
But the rules are made to be also
in his case only. In his case only,
yes.
this court earlier round said that
that is relying on earlier
decision. If such D group have been worked prior to that amendment to the rules, taking notification of a clarification and all, it has to be, again you have rejected that.
what I found out is, the very first case, that has been wrongly, the order is wrong.
Which
Because
one?
in that case, the appointment is made in the very first case.
Here, in this case, they have not relied upon that earlier cases. He said, in view of that clarification given by the government,
yes. The government has clearly clarified the notification.
What is wrongly stated is, there is nothing to say that the rules will cease to exist. The not notice, not one at all.
Yes.
And the appointment was made after the rules came into existence in the year 2021.
yes.
Therefore, that judgment may not be right. However,
No.
No.
His case,
his
his own case earlier, the, why, yes, in terms of that will,
ಮತ್ತು ದಿನಾಂಕ 2/6/1992ರಿಂದ 31/5/1993 ಹಾಗೂ this is relevant. ದಿನಾಂಕ 1/6/1993ರಿಂದ
Yes.
2/2/2000 this appointment is between this date. In
Yes.
1998. ಅವಧಿಯಲ್ಲಿ ನೇಮಕಗೊಂಡು ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರವೇಶನಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಬೋಧಕೇತರ ಗ್ರೂಪ್ ಸಿ ಮತ್ತು ಡಿ ಸಿಬ್ಬಂದಿಗಳನ್ನು ಅನುದಾನಕ್ಕೆ ಒದಗಿಸುವ ಬಗ್ಗೆ. Notice by kindly see page 38.
yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಹಾಗೂ ಉಲ್ಲೇಖಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ಗಮನ ಸೆಳೆದಿದೆ. ಈ ಬಗ್ಗೆ ತಾವು ಸಲ್ಲಿಸಿರುವ ಮಾಹಿತಿ ಹಾಗೂ ವಿವರಗಳಂತೆ ನಮ್ಮ ಆಡಳಿತ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರೌಢಶಾಲೆಗಳಲ್ಲಿ ಸಂಬಂಧಿಸಿದ ಆಡಳಿತ ಮಂಡಳಿಗಳಿಂದ ದಿನಾಂಕ 16 ಪೂರ್ವದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ 129 ಡಿ ದರ್ಜೆ ನೌಕರರು 2 ದಿನಾಂಕ 1992ರಿಂದ 31/5/1993 ಅವಧಿಯಲ್ಲಿ ನೇಮಕಗೊಂಡು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ 141 ಡಿ ನೌಕರರು ದಿನಾಂಕ 1/6/1993ರಿಂದ 2/2/2000 ಅವಧಿಯಲ್ಲಿ ನೇಮಕಗೊಂಡು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ 438 ಗ್ರೂಪ್ ಡಿ ನೌಕರರು ಮತ್ತು ದಿನಾಂಕ 1/6/1993ರಿಂದ 2/2/2000 ಅವಧಿಯಲ್ಲಿ ನೇಮಕಗೊಂಡು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಗ್ರೂಪ್ ಸಿ ನೌಕರರು. This is not ನಿರ್ವಹಿಸುತ್ತಿರುವ ಗ್ರೂಪ್ ಸಿ ನೌಕರರು. This is not
Yes.
ಗ್ರೂಪ್ ಡಿ ಒಟ್ಟು ನೌಕರರು ಭವಿಷ್ಯವರ್ತಿಯಾಗಿ ಈ ಆದೇಶ although somebody has not been appointed, they have wrongly shown them to be appointed just to get granted. Let him give us
No.
a satisfactory answer as to why it was not sent initially.
No, you are not asking all these things. This court said, consider that when you are doing that, you have to ask, verify. If that is not there, you on that ground, you have to give an endorsement. ಸುಮ್ಮನೆ ಕುತ್ಕೊಂಡ್ಬಿಟ್ಟು ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ರು ಏನೋ ಹಾಕಿದ್ರು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇದೊಂದು ರೀಸನ್ ಹಾಕ್ಬಿಟ್ಟು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಡೋದು.
Even the director has submitted.
ಟೀಚ್ ಮಾಡಿದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ. Yes, yes.
Even the director of secondary education has also submitted a report.
Yes.
Annexure N ನಲ್ಲಿ this notification has been clarified by the government, please.
In this writ petition, petitioner has, what is that connected matter?
Connected matter, idu same, similar, but idರಲ್ಲಿ rejection ಆಗಲಿಲ್ಲ. Only a mandamus we are seeking.
Mandamus, that will come later. Yes. In this writ petition, petitioner called in question, endorsement dated 14/2/2024, issued by respondent number 1 as per annexure W. Petitioner number 2, who is the employee of that institution being managed by petitioner number 1.
That is Sujata Kannada Medium High School.
Petitioner number 2 has been worked by endorsement dated annexure Q, first endorsement yavattu first
Annexure endorsement annexure L, page 60,
dated
26/4/22.
by endorsement annexure L dated
6/4/22.
26/4/22, 26/4/2022, being agreed by the same.
Page 60.
Petitioner has approached this court by filing a writ petition in WP number 11857 of 2022. This court, by order dated 10th August 2022, has set aside that endorsement and directed the respondent to consider the case of the petitioner within 3 months. Thereafter, similar endorsement has been issued by impugned endorsement dated
Annexure T,
page 6/2/2023, being agreed by the same. The petitioner is before this court.
No, that endorsement has also set aside by this court in Annexure V.
ಯಾವ endorsement?
ಇದು ಯಾವುದು Annexure T, 6/2/23.
ಅದನ್ನು set
ಅದು
aside
set aside ಆಗಿದೆ.
issued an endorsement annexure T.
Annexure T,
Being
Annexure
agreed
V.
by that, petitioner has approached this court, filing one more same ground. Agreed by the same, the petitioner is before this court. Learned counsel appearing for the petitioner has submitted that earlier 2 occasions, the case of the petitioner for admitting the grant in aid has been rejected, that in view of the rule
Notification.
Karnataka Education Institution Recruitment and Term and Condition Service of the Employees Private Aided Primary and Secondary Institution Amendment Rules 2017, that Group D employees has to be appointed only through outsources. This court in earlier occasion has clarified that petitioner has been appointed before the said rules 2017 has came into the force. The rule is not applicable to the case of the petitioner. In spite of that, similar endorsement has been issued. Hence, he sought for allowing the petition. Yes.
The officer who has come now, he was able to give proper instructions. Is
Yes,
the-
learned government advocates,
Annexure C, page 37.
when it is sent,
ಇದು ಈ 37 Annexure C ಆದ್ಮೇಲೆ Annexure D, Annexure D, Annexure D, 41, page 41.
on 16/10/2014.
Yes,
16/10
ಹೌದು.
ಅಲ್ರಿ ಆ ಲೀಸ್ಟ್ ಯಾವಾಗ್ಲೂ
1610 ನಲ್ಲಿ ಕಳ್ಸಿದ್ರು.
16/10 ಅಲ್ಲ,
ಹೌದೌದು, 16 ನಲ್ಲಿ ಕಳ್ಸಿದ್ರು.
16/10/2014.
14 D, and then
No reason forthcoming why it is not sent in the year 1998. Since as per the rules, all Group D employees has to be appointed by outsourcers. Therefore, the authorities has issued an impugn endorsement. Heard the learned counsel for the parties. There was writ paper. It is not in dispute. Petitioner was appointed as a Group D. It is not in a Group D post since 1998. It is also not in dispute that petitioner appointment has been approved by that competent authority. The government, the list of that candidates who are covered under that government order has been prepared. Ilri at least
Annexure H,
wide annexure H
dated 4/8/15.
4/8/2015. Petitioner name is also mentioned in that list. In spite of that, ನೀವೇನ್ mandamus ಕೇಳಿದ್ರ first ಒಂದ್ಸರಿ?
First mandamus ಕೇಳಿದ್ರು.
Petitioner case has not been considered for admitting the granting aid. Hence, petitioner has approached this court by filing in a writ petition in WP 338 of 2021. This court directed the respondent to consider that representation of the petitioner in accordance with law. Thereafter,
Annexure L.
the endorsement has been issued on 26/4/2022. In view of the rule 2017, petitioner case cannot be considered for granting aid. That endorsement has been challenged before this court in WP number 1185 to consider the case of the petitioner for admitted to granting aid. The relevant paragraph, para 5 extracted. In spite of that, the similar endorsement has been issued by the annexure T dated 6/2/2023. Being agreed by the same, the petitioner has filed a writ petition before this court in WP 4491 of 2023, disposed of on 11 July 2023. The relevant paragraph is extracted. Para 5. And this court has also remitted the matter with a warning to consider that case of the petitioner in the light of that order passed by this court. In spite of that, the respondent has issued a similar endorsement that is impugned in this writ petition 4/2/2024. In view of that, order passed by the government by the annexure C dated 2/1/2024, and also recommendation made by the director, recommendation made by the director
14. 2014.
2014, yes. 2014, Annexure C. Impugn endorsement required to be quashed. The respondents are directed to consider that case of the petitioner in the light of that order dated 10th August 2022 passed in writ petition number 11857 of 2022. Within outer limit of 3 months from date of receipt of copy of this order. No, I have said. No, I said this impugn annexure has to be quashed because of that annexure. No, that I said it has to be quashed because of that annexure C and clarification earlier judgment.
Yes.
Now you have to be considered in terms of that annexure. Yes.
Connected matter, Your Lordship.
Connected matter ಏನು ಕೇಳಿದೆ?
ಅದರಲ್ಲಿ mandamus to consider reputation for on the basis of the recommendation made by the authorities. ಇದರಲ್ಲೂ D group employee working in the institution.
In this writ petition.
Sixth respondent society.
Following relief. The petitioner was appointed as Group D employee in which institution, Mr.
The Basaveshwara Prodashale
in sixth respondent society
Abbenahalli
in
Malur Taluk.
Institution which is run by sixth respondent society.
Annexure G ನಲ್ಲಿ clarification ಪ್ರಕಾರ least has been
ಮಾಡ್ತಾರೆ first. Yes. Wide annex government 2/1/2014 21 to 14 2/1/14 ಅಲ್ಲ 14 ಅಲ್ಲಿ 93 ಇಂದ 2000 ವರೆಗೂ ಗ್ರೂಪ್ ಕಳಿಸಿ ಅಂತ ಹೇಳಿ. Yes. By government order dated 20th/1/2014 has directed that authorities to
21/2014.
The Group C and Group D employees who are appointed between 1/6/1993 to 2/2/2000. Case has to be considered for admitting the grantinate. Pursuant to that order, the director has prepared a list. Wide annexure.
Annexure H ಅಲ್ಲಿ
ಇದ್ರಲ್ಲಿ ಈ ಕೇಸಲ್ಲಿ
ಇದರಲ್ಲಿ annexure J
prepared a list. Wide annexure J
4/5/2022 ಇದರಲ್ಲಿ
4/5/2022
4/5/2022 page 32.
In that petitioner name is placed in serial number 1. In spite of that petitioner name has been recommended for admitted to the grantinate, the same has not been considered closing all relevant documents. If such a representation is submitted to the competent authority, who has to consider?
The first respondent has to consider.
First already commissioner irbeku.
ಇಲ್ಲ first
Commissioner.
like government
ಹೇಳಿರೋದ್ರಿ commissioner.
ಅಲ್ಲ state of Karnataka principal secretary has to consider first respondent.
Yes, respondent number 1 and 2 submitted a representation to respondent number 1 and 2 within 4 weeks from date of receipt of copy of this order.
Please.
If such a representation is submitted, respondent number 1 and 2 is directed to consider the same in accordance with law as expeditiously as possible, not later than 3 months from date of receipt submission of that representation. All pending applications.
Cell number 53, Rahmatullah Kotwal for petitioner, Rekab Chamke.
Yes.
In this case, for the respondent. Lords, respondent is the monitoring committee, my lords. This is a committee which is appointed by the Honorable Supreme Court. Last time I had pointed out, my lords, this committee.
No, you are appearing for respondent.
Respondent.
Let him give that facts of the case.
Preliminary objection I have, my lords. There's an order of the Honorable Supreme Court. In my statement of objections I had pointed out.
Yes.
Dated 3rd April 2024, where at page 42, it has been stated that if any grievance is there as against the respondent monitoring committee or the CEC, then the person has to go by filing an application. Normally, the High Court should not entertain an application by filing an application. Normally, the High Court should not entertain an application issue dispute as the matter is sub judice and this court is in sine. Albeit, this court can direct the parties to approach the High Court if required and necessary.
Now, what is this matter pending before?
Briefly, my lordship, the background is there was a lot of illegal activities, which binding activities, which were taking in the state of Karnataka. So, my lords, based on R1, my lords, that is which is my exhibit at page 10, which is in writ petition number 568 of 2009, the Honorable Supreme Court, my lord, had directed that all the sale activities of the iron ore should be stopped in the state of Karnataka. And they had appointed the monitoring committee to continue, to carry out sale by way of e-auction, my lords. That, my lordship, may see at para 2.2, my lords, at page 12. So they had set out the modalities, page 10, my lords. The following modalities of sale of existing stock of iron ore, keeping in account of the sale proceeds and related issues.
Iron ore allotment ಹೆಂಗ್ ಮಾಡಬೇಕು ಅನ್ನೋದನ್ನ
So, my lords, so para 2 says this quantity will be sold through e-auction. My lordship may see para 9, my lords, which is at page 14. Para 11, sorry, my lords.
Yes.
Then they had appointed a committee comprising of Mr. So-and-so, Chief Conservator of Forest, so-and-so. Then Mr. Srinivasa, Director of Mines and Geology, may be constituted hereinafter called the Monitoring Committee for dealing with the various issues related to the sale and transportation of existing stock of iron by the market. This court is of the opinion that the time has come to review the system that was put in place over a decade ago and halting the unchecked excavation of iron ore in the 3 districts in Karnataka, state of Karnataka. Ever since then, e-auction has been the only mode available for disposal of the excavated iron ore. The said arrangement has worked out satisfactorily so far. The situation that was prevalent in the region prior to the year 2000 has now changed for the better. Having regard to the course correction that has taken place, the regeneration post the ruinous damage caused to the environment and various steps taken by the government, we are of the opinion that the order date passed on 23rd September 2011 deserves to be relaxed. My lords, then so that order which I read, my lords, before has been relaxed. Additionally, it is a matter of record that consecutive e-auctions conducted by monitoring committee have been receiving poor response, and the sale of iron ore even at the reserve price is dismally low. Looking at the overall change in the outlook, the restrictions placed in the manner of conducting the sale of iron ore and fixation of sale price need to be removed. Keeping in mind all the aforesaid factors, we are inclined to favorably consider the prayer made by the applicants and grant them permission to sell an already excavated iron ore stockpile at various mines and stock yards located in the districts of Bellary, Tumkur, and Chitradurga without having to resort the process of e-auction. Permission is granted to the applicants to enter into direct contract. So this e-auction was closed, my lords. Thereafter, my lords, may see Alexa R5, my lords, page 68. This is a letter written by monitoring committee to me.
Yes.
Second paragraph, my lords. Pursuant to the honorable, he was working in, we had engaged his services, my lords. Para 3 takes his role, my lords. The petitioner's initial monthly payment paid by the respondent was 15,000 at the time of joining. The petitioner has been assigned the risk of handling day-to-day book keeping of accounts in tally software, which includes all the various heads concerning e-auction. Now e-auction has stopped, my lords. So we have told him that now, we did not want his services.
So he has challenged that particular letter, my lord.
Where is his appointment?
My lord, his appointment and all was all ad hoc, my lord, because this is ad hoc committee which was appointed. My lord.
Now, where is your appointment order?
Appointment order has not been placed. My lords, my lords may kindly see page number, my relieving letter. my
Now,
lord.
where is your appointment order? First basic, I want to know how you has been appointed.
Appointment letter has not been issued to us. my
What
lord.
is your right, mister?
My lord, so appointment
Even
letter itself-
appointment order is there, you are only for the term that work is there. After that, you have nowhere, where they will keep you.
My lords, my-
Committee itself is not there.
My lord, they themselves have issued me a
Show me
letter.
that appointment order, there will create your rights. If there is no appointment order, you are simply went there, you worked there, you going out.
My
That's
lords,
all.
may kindly see Annexure D, my lords. Annexure D of my writ petition.
Yes.
They themselves certify this, my lords.
What
This
is
is to certify that Mr. Late, as an senior accounts executive. And my lords, may kindly note few of the dates, my lords. I'll just point out few of the dates.
Worked, how you has been appointed, how you have entered their premises, mister, on what basis?
My lord,
Are they worked, how you has been appointed, how you have entered their premises, mister, on what basis?
My lord,
Are they
appointment
called you an
letter-
application? Are you, without giving an appointment order, how you will go there, mister? Where is your appointment order?
My lord, they don't issue an appointment letter to anyone. my
Then
lord.
what
That
is your right,
That is
mister?
my instructions, my lord.
Then what is your right? They ask you to do contract work for daily wages, like they have paid it and send it back.
My lord, the other employees, my lord, similarly placed employees, e-auction was closed. The person who was specifically handling e-auction, my lord, she's still in the post and she has been given increments. I'll specify the
first-
dates, my lord. if your
No,
lordship
I
can permit.
date is, I want to know how he has appointed, what is the condition in that appointment, then only we can decide.
I'll place the documents.
Without appointment order, how you have gone into there and joined the service? ಸುಮ್ಮನೆ ಹೋಗತ್ತಿದ್ದಾಗ ಬನ್ನಿ ಕೆಲಸಕ್ಕೆ ಅಂತ ಕರೆದ್ರು ಅಥವಾ ಏನಾರ ಒಂದು ಲೆಟರ್ ಕೊಡ್ಬೇಕಲ್ಲ. Public money they are paying, mister, how can they say?
And my lord, all
Monitoring
this
committee,
money is,
this is private.
they are all under the orders of the Honorable Supreme Court. my lord.
Honorable Apex
Temporary
Court.
it is.
And only
No.
thing is, they can approach the Supreme Court, my lord. They have any
My lord,
grievance.
No,
let them
that Supreme Court, it's, let us see that. First, let me show what is that appointment, how he has appointed and all.
Please.
We don't know that how it is appointed. Yes. At the request, leaves this matter of 3 weeks. Yes.
My lord,
Cell number 54, 55 adjourned. Cell number 56, Shivarudra for
Obliged.
petitioner. Yes, Sudarshan, Yogesh
Yes.
Nayak.
for the respondent,
Yes, Mr. Shivarudra. None is there.
respondent,
Cell number 56.
None appear for the petitioner. None appear for the petitioner.
Ravindra, RS Ravindra. I am for the petitioner.
ನೀವು ನನಗೆ ಆರ್ಗ್ಯೂ ಮಾಡೋದು.
That the consolidated pay employee was terminated without there being any notice after. So she's serving for the last 15 years of the.
Where is your appointment order?
Not they have not issued the appointment order. Not they, if your lordship kindly have a glance at this annexure
Paramedical board.
Annexure B, my lord.
Annexure?
Annexure B at page 14.
Annexure P.
At page 14. The date of joining is mentioned here. Second name, Bhagyalakshmi N.
Page 14, huh?
14 ಹೌದು.
Yes.
8/5/2010
Yes.
appointed.
Yes.
Not by an order dated.
What is your name?
Bhagyalakshmi.
Bhagyalakshmi.
Not the.
Yes.
With an order of simplicity, my lord, just Mandali Kalakanda Sibbandi ನಿರ್ವಹಿಸುತ್ತೆ. She was shifted to work in paramedical board by annexure G. ಅರೆ ವೈದ್ಯಕೀಯ ಮಂಡಳಿ ಮತ್ತು ಶುಶ್ರೂಷಾ ಪರೀಕ್ಷಾ ಮಂಡಳಿಯ ಈ ಕೆಳಕಂಡ ಸಿಬ್ಬಂದಿಗಳಿಗೆ ಅವರು ನಿರ್ವಹಿಸಿದ ಕರ್ತವ್ಯಗಳು ಉತ್ತಮಪಡಿಸಿಕೊಳ್ಳಲು ಸಾಕಷ್ಟು ಸಮಯ ಅವಕಾಶ ನೀಡಿದರು. ಅವಕಾಶವನ್ನು ಉತ್ಪನ್ನಪಡಿಸಿರುವುದರಿಂದ ತಕ್ಷಣಿಗೆ ಜಾರಿ ಬರುವಂತೆ ಮಂಡಳಿಯ ಸೇವೆಯಿಂದ ಬಿಡುಗಡೆ ಮಾಡಿದೆ. After having served for 15 years in different capacities, not from nursing board, after paramedical board, as of now, from director of medical education office to paramedical board, and she is continuing to work there. But without there being given any opportunity of being heard, but she is being removed from service, and this honorable court was pleased to state, not after having heard the matter, that she should not have been removed from the service without there being given an opportunity of being heard or any inquiry being conducted.
No, that they are not removing you on that allegation.
No allegations, Lord.
Therefore, the inquiry is not necessary. You are a contract employee. They are
Not even
they
a
don't-
contract employee or a consolidated pay employee, according to the Supreme Court, and according to this honorable courts also, my lord. The division bench of this honorable court, may will not seems pleased.
Yes.
Without having given an opportunity, you should not be removed ಅಂತ ಇದೆ. Enquiry conduct ಮಾಡಬಹುದಿತ್ತು ಅಂತಾನೂ ಇದೆ.
Where is that?
Even order of the single judge also is there, not without there being.
No, this is made out a ground for misconduct. If such a complaint is made, in the process of the court should examine if there is an allegation of misconduct and all. Notice is necessary. Is it settled? Now the Supreme Court said even contract employee. No, therefore that notice is not.
ಇಲ್ಲಿ misconduct ಇದ್ದಿದ್ರೆ my lords are right.
No, misconduct ಇದ್ರೆ ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕು ಅಂತ ಇರೋದು.
ಇಲ್ಲಿ
ಏನು ಇಲ್ಲದೆ ಇದ್ರೆ if they
discharge simpliciter ಇಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್.
yes.
Much okay.
Leave this matter on 19.
Cell number 57, Chaudappa DN for petitioner,
Yes, my lord, I
Renuka HR, PL Sanjeev.
Petitioner, my lord.
Yes.
In this case, my lord, the respondents have paid the earned leave encashment to these petitioners belatedly after a lapse of nearly one and a half year to ranging from 1.5 year to 3 years, my lord. My lord, all the petitioners are the retired employees of the respondent
Director
corporation.
responded to pay that interest at a rate of 12 per annum, delayed payment of leave encashment benefit. Petitioner by considering the representation. Yes.
After their retirement, my
What is
lord,
that judgment you are relying on this?
ಎರಡು judgments ಕೊಟ್ಟಿದ್ದೀವಿ. Our
have
own
the
high
submission
court,
also.
these judgments are passed by our own high
Respond, keeping
High
in
Court
mind of the
ruling.
principle I don't discount.
One is in requisition number 48.
Now, what is this, huh? ಇದೇನ್ರಿ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವ್ದೋ ಹಾಕಿದಿರಲ್ಲ ಏನದು?
It is a judgment pertaining to payment of interest for the late payment of earned leave encashment.
ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ ಸರ್, ಮುಂದೆ ಕೇಳ್ಕೊಳ್ಳಿ.
These judgments are pertaining to interest, payment of interest for the late payment of earned leave encashment, my lord.
ಜಡ್ಜ್ಮೆಂಟ್ ಅದು.
At page number 38, my lord,
Withholding the employee.
passed by Honorable Justice Ram Mohan Reddy in requisition number 485554 of 2014.
Yes, it is needless to state that.
And another judgment is also passed by this Honorable Court, my lord.
The case of the petitioner that they were all employee of the respondent. After attaining the age of superannuation, the petitioner retired from the service from various posts. The leave encashment benefit of the petitioner was paid by the respondent after a delay of how many years?
Nearly 1.5 year, more than 1.5 year, my lord.
Delay of 1.5 years to three years from the date of retirement. Therefore, petitioner has submitted a representation annexure.
A1 to A10, my lord.
At priorly representation idavella.
B1 to B10.
So and so. Annexure B1 to
B10, my lord.
B10.
Which are at
The respondent
page
to pay
number.
that interest at a 12% per annum for the delayed payment of the leave encashment. The learned counsel appearing to the petitioner submitted that writ petition could be disposed of, directing the respondent to consider that representation time bond, and also relied on judgment of this court in similar circumstances in WP number 48554 of 2014 and
Another judgment is
20799 of 2022 disposed of on so and so date. In view of the said submission, writ petition is disposed of, directing the respondent to consider that representation submitted by the petitioner dated so and so, with annexure B1.
Petitioner, government advocate.
Yes. What is this covered in favor of petitioner or? What is this?
I may permit to my lord.
Yeah, no, what is that issue?
My lord, all these petitioner, my lord, they are working under, my lord, the
Hmm. ಏನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಏನಿದೆ ಅದು ಕೊಡಿ. ಔಟ್ಸೋರ್ಸಸ್ ಎಂಪ್ಲಾಯಿ
Cannot be regularized. my lord.
ಅದು ನಿಮ್ದು ಇದು ಅದು ಜಸ್ಟಿಸ್ ಎಸ್
ಅಲ್ಲ ನನ್ ಗ್ರೌಂಡ್ ಅಂತಂದ್ರೆ ಈವನ್ ಮಲಾಡ್ ಐ ಕೆನಾಟ್
go through that whether it is covered or not.
ಅಲ್ಲ ಬೇರೆಯವ್ರು ಬಂದು another batch should not be
ಅದಿದೆ your appointment regular appointment has to
There
be
is no such threat to him, my
there
lord.
is a threat my lord, for remove these petitioners.
there. Not related to issue any manner
He
of
sought for regularization.
Representation came to be filed.
their case to be-
ಅಷ್ಟು ಕೊಟ್ರೆ ಸಾಕು at least another set of employees cannot be appointed through a appointment agency ಅಷ್ಟೇ. ನನ್ ಗ್ರೌಂಡ್ entire pleading is that.
You, Lord, may I
Though my
request,
lord, I
my
have not my lord sought in the
For-
writ petition.
In this writ petition, they cannot
The
seek
prayer.
such relief also, my lord.
what is
But-
that they have sought for?
My lord, though the my lord,
They
I
read-
pray my lord with respect to representation which has been made by my lord the petitioner. But Lena ಅಂತಂದ್ರೆ I have taken a ground in the itself my lord.
May I read, my lord, prayer, my
No,
lord?
you seek for
First,
regularization, that's all.
I may permit to read.
The agency,
Please,
ಅವ್ರನ್ನ
from last my lord, from last 15,
the agency,
please, from
ಅವ್ರನ್ನ
last my lord, from last 15 to 20 years, we are still my lord is working.
ಎಲ್ಲ ಅವ್ರ ಸೆಕ್ಯೂರಿಟಿ ಏಜೆನ್ಸಿ ಕೆಳಗಡೆ 25-30 ವರ್ಷ ಕೆಲಸ ಮಾಡ್ತಿರ್ತಾರೆ because they are an employer, you are an employee. Outsourcers, they will give an
Lord, we
employment.
call for tender notification, my lord. Who is the lowest bidder, we will consider his bid.
The payments will be made by the government only.
The
We are
payment,
receiving from my lord the payments which is made by the
show
government
me
itself.
outsourcers employees can be regularized. Show me that.
Though, my lord, Jaggu versus Union of India, the court has considered all these aspects. Clearly because an ad hoc appointment.
Not
or,
ad hoc.
my lord, on contract basis
No,
or
Mr.
any
Ad hoc.
other appointment made by my lord outsourcing employees itself.
Contract, ad hoc, it is appointed by
Government.
government itself. Here you have not been appointed by the government. They will give middleman agency.
My lord,
ಈ ಕೆಲ್ಸ
then
ಅವನು
My lord, then virtually my lord, Article 14 and 16 will be violated by.
This
my lord,
honorable
the
court has
government.
answered for that.
The Supreme Court though my lord has certainly my lord has directed all the government that no such appointment has to be made. Still my lord, the government is making these my lord the steps and they are going to appoint my lord by virtue of these.
You
through
could have-
out-
you could have
outsourcing agencies.
raised an
But I-
objection.
My lord, I may permit it. My lord, by virtue of those appointments only, my lord, these petitioners working from last, my lord, the 15 years.
Yes,
These petitioners working from last, my lord, the 15 years.
yes.
Now they cannot come before this court and saying that, my lord, they are appointed through outsourcing.
Yes, where is that? Read.
To so 10 to 15 years, it is because of the policy of the government to get appointment made through outsource agency. Since it is the realm the policy, this court would not pronounce upon the permissibility of the or otherwise, but what needs to be noticed with the concern that concern is that the fact of the appointment of the post of teachers are also being made through outsource agency by calling for tenders. It is a teacher from out of his monthly salary has been paid month on month. A portion of his salary to be the outsource agency. Under these head the service charges. There cannot be any better explanations of human labor by state by encouraging appointment of teachers through outsource agencies in the life of the students to play very important role. That is this thing is court is extracted, my lord, that is not necessary. My lord, even that the appointment order is also extracted, my lord, where they appointed, my lord. And the next, my lord, page 26, my lord, that is also says it is outsource agency, my lord.
Yes.
ಆಮೇಲೆ 27 may I read, my lord? 27. Insofar as issue of regularization petitioner is sought for, it is for the state to take a decision on exigency of the discretion with regard to the service of the petitioner in the event of our continuing to work till satisfy all the parameters stipulated in the judgment rendered in the case of Uma Devi and forthwith. This was what my lord. And my lord, this is the batch of matter where the 800 and odd my lord petitioners were challenged in this.
That there, my lord, the court has considered with respect to, my lord, the society, not, my lord, under any, my lord, the government department. It is registered under the Karnataka Registration Act itself.
No, no, no,
No,
no.
my lord, though the court considered that, my lord, since mandamus cannot be issued to the society. By considering all these facts, my lord, the courts rejected, my lord, the petitioner claim. Now, my lord, now this petitioner is working in a government department itself, my lord, by through outsourcing agency. But my pleadings before this court is, my lord, that, my lord, another batch of, my lord, the person should not be, my lord, appointed by terminating the petitioner itself.
Where is that?
Since,
Show me that they are appointing another persons.
my lord, there is no such, my lord, as on the date of filing of the
That is two
petition.
things.
Now there is a threat, my lord, only by oral threat has been made to sign in the, my lord, the termination order. Then only, my lord, these petitioners come before this court, and the court considered, my lord, the aspect of the
You
matter,
are
my lord.
ನಿಮ್ಮ ಟರ್ಮಿನೇಷನ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಲ್ಲ. ನಿಮ್ಮ ಏಜೆನ್ಸಿ ಇದೆಯಲ್ಲ ಅವನಿಗೆ ಹೇಳ್ತಾರೆ ಇವತ್ತಿಂದ ನೀನ್ ಬರ್ಬೇಡಪ್ಪ ಮುಗೀತು ಅಂತ ಅಷ್ಟೇ. ನಿಮಗೆ ನೀವ್ ಆರ್ ನೋವೇರ್ ಕನೆಕ್ಟೆಡ್ ಟು ದಮ್ ಮಿಸ್ಟರ್.
Obliged.
ಇದೆಲ್ಲ ನೀವು ಮಾಡ್ತೀರಾ ಅಂತ ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅವ್ರು ಔಟ್ಸೋರ್ಸಸ್ ಶುರು ಮಾಡಿದ್ದಾರೆ. ನಿಮ್ದಿರ್ಲಿ ನೀವು ವಾಟ್ ಇಸ್ ದಟ್ ವರ್ಕ್ ಯು ಆರ್ ಡೂಯಿಂಗ್.
But we are, my lord, the cook servant. 15-20 ವರ್ಷದ ಏನೋ ಒಂದು 14,000 10,000 ತಗೊಂಡು ಜೀವನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಟೀಚರ್ಸ್ ನ ಔಟ್ಸೋರ್ಸಸ್ ಮಾಡ್ತಾ ಇದ್ರು. ಅದಕ್ಕೆ ಕೋರ್ಟ್ ನವ್ರು ಸ್ವಲ್ಪ ಹೋಗಿದ್ಬಿಟ್ಟು ಟೀಚರ್ಸ್ ನ ಔಟ್ಸೋರ್ಸಸ್ ಮಾಡಬೇಡಿ, ಬಟ್ ಔಟ್ಸೋರ್ಸಸ್ ನ ನೀವು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ನೀವು
Lord, page 70 to 31, my
Go
lord.
through the entire decision of.
Lord, page 70 to 31, my
Go
lord.
through the entire decision of, my lord, what.
21.
Lord, tomorrow it may be taken.
Yes. Leave this matter on 14th.
1 week.
14th.
14 ಬೇಡ ಸ್ವಾಮಿ, 18 14 ಬಹಳ ಕೇಸ್ 18 ಆಗಿ
Yes, 18th. Yes. Leave this matter on 18th. First or not.
Bill number 59, Ramamurthy HS for petitioner, Prakash MK.
Other matter will give the date.
In the 59.
Past over matters tomorrow. Admission tomorrow. Nimdu, who has to come, Mr. Bhagwate? Yes. Yes, Mr. What you say? You have to complete within that 5 months.
Lord, may I request, my lord?
Draft
That is
rules.
a, my lord, policy decision, my lord, draft, the code is issued, my lord. That has to be done by the legislature, my lord, not by the principal secretary or anybody else, my lord. Once it is approved, my lord, the notification issued, then he can file a fresh writ petition. That is not an issue.
No,
But
how
now,
many-
my lord,
How much time it will take to approve? You say you have filed an affidavit saying that.
my lord,
we'll do it.
that affidavit explains, my lord, why it is not done. My lord, there is objection is called for that. The objection has to be received, my lord. That has to be looked into, and the cabinet has to be sit for that. They have to take a decision.
How much time it is? See,
Lord, that,
within,
It would be delayed. State government has produced a letter dated 3/2/25, preparing executive order for voluntary retirement.
no, if you see after receiving the objection,
Lord.
if you're satisfied, you can drop that rules.
No,
But don't show that.
My lord, may I request, my
But
lord?
it will not go to cabinet. my lord.
Lord, draft
My lord,
rules
it is
are not.
delegated legislation. 1 minute. It is delegated legislation, Lord. It will go to concerned minister and, my lord, rules will be prepared. It
Lord.
is not an enactment, Lord.
Lord,
Rules.
this,
rules.
the law is
Rules.
very well settled, my lord. The draft rules are not in enforceable rules, my lord.
No, they
The
are not.
petitioner
sitting-
herein has got a benefit of the policy decision, my lord. He was appointed at the got a grant in your code, my lord. Now he want to go by VRS, my lord. That is the provision does not show that.
No, 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 no. He is not now taking that benefit. He is saying that, you have prepared in a rules. You finalize that. If it is entitled, you will
No,
take a
that,
benefit.
my lord, he cannot take in mandamus from this court, my lord. There are n number of judgments where
No.
The-
No. See, earlier this court has directed, you filed an affidavit. Who has
my
asked?
lord, that is filed only in the extent of, my lord, what is the stage of that rule is there, my lord.
You said that
that-
will finalize.
Yes, my lord.
See that-
20,
You see that will finalize. Why you have not, why you have filed? You could have said that to the court on that day, saying that, no, you can't ask it to file because you have to take any
May I
decision.
read
But
that?
secretary, government department skill development,
ಇಲ್ಲ.
he has filed it.
ಹೌದು.
Para 7,
ಅವ್ರು
my lord.
ಮಾಡಕ್ಕಾಗಲ್ಲ, ಲೆಜಿಸ್ಲೇಚರ್ ಅವ್ರು ಮಾಡ್ಬೇಕು.
Para 7 and 8.
Go on changing your stand by
Lord,
changing
may I
that,
request, Lord, this is the facts, my lord, what is there in that file, my lord?
No, on that day, why the court has asked to you file an
I deeply
affidavit?
oblige, Lord. May I read that para 6 and 7, my lord?
Yes.
8 is the answer.
Both
It's
6 and 7 ಓದ್ತೀನಿ ಸ್ವಲ್ಪ
regarding the
ತಡಿ. In concurrence of the finance department and cabinet has to mandatory procedure as per the extent rules. Further, the concurrence of the Department of Parliamentary Affairs and Legislature has to be obtained in respect of the subordinate legislation, and thereafter the approval of the cabinet is mandatory in this matter. I state that all efforts will be made regarding finalization of the draft rules in accordance with the due procedure. ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಅಂತ ನಾ ಕೇಳ್ತೀನಿ. ಇಷ್ಟೇ ಹೇಳಿದ್ದು.
Due as expeditiously as possible.
ಎಲ್ಲಿದೆ?
As expeditiously as
Lord, may I request, my lord, may I request.
ಯಾವತ್ತಾರು ಮಾಡ್ತೀವಿ ಅಂತ.
May
ಎಷ್ಟ್ ದಿನ ಅಂತ.
Lord, may I request, my lord.
ನೀವು ಈ ತರ ಇದೆ ಸಿಚುಯೇಷನ್, ನಾವು ಮಾಡೋದಿಲ್ಲ ಅಂದ್ರೆ
ಇಲ್ಲ, ಅವ್ರು ನಾನು ಮಾಡ್ತೀನಿ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ, ಬಟ್ ದಿ ಅಥಾರಿಟಿ ಹೂ ಹ್ಯಾಸ್ ಸೈನ್ಡ್ ದಿಸ್ ಅಫಿಡವಿಟ್, ಲಾರ್ಡ್, ಹಿ ಇಸ್ ನಾಟ್ ದಿ ಲೆಜಿಸ್ಲೇಚರ್.
No, who has
Secretary.
authorized to you file?
Secretary of the department.
Has explained, this court has called for that, my lord.
Where is that
This affidavit was filed, my lord, that's it.
Where is that order of this?
Lord, may I read,
125.
may I read affidavit only, my lord, in that there, my lord.
16,
Para 2, my lord. Para 2 of that affidavit only. It is extracted.
1 minute.
No, you could have stated before
Para
the court saying that
Lord,
this is that domain of that legislators, they have to take, we can't file
I
it.
agree, my lord.
When there is in that other bench, you are saying that yes, we'll comply. ಏನೋ
agree.
ಹೇಳ್ತಾರಲ್ಲ ಬೀಸೋದೊಣ್ಣೆ ತಪ್ಸ್ಕೊಳೋದು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಇಲ್ಲ,
ಅಲ್ಲಿಂದ ಹೋದ್ರೆ
ಇಲ್ಲ, ಅವ್ರು ಕರೆಕ್ಟ್ ಆಗಿ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದಾರೆ ಇದ್ರಲ್ಲಿ, ಅವ್ರೇನ್ ತಪ್ಪೇನ್ ಹೇಳಿಲ್ಲ.
See, Mr. Law has to be placed before the court with authentication, whether it is in a
I
court.
agree, my lord.
There is no question of threat by the court saying that if the court said, if you have an authentication, you can say the court that I will
I
not
agree,
file
my
an
lord.
affidavit
Para-
because it is domain of that legislator,
Obliged,
will
my
not file. That has to be
That
done.
para 6 and 7 that
Saying
they've
that
explained.
everything you has to be accepted and saying that only
Obliged.
15 days time has to be given to file an objection
But
for the draft
31,
rules.
23, rules itself say 15 days.
Yes, that is what the rule is that.
October
15 days.
23.
Then after seeing that objection, if that objection is sustainable, drop the
I oblige,
rules.
my lord.
Or if you required for modification, modify the rules and issued another rules. But don't keep like that.
Lord, ಪ್ರಾಬ್ಲಮ್ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ,
My lord, he is unable to perform his work.
No, that we'll
Lecturer, my
see.
lord.
That we'll
He
see
is not
tomorrow.
going to, my lord, he is not now for the last 3 months, he is unable to
No.
stand even.
No, only thing is why you are keeping without taking.
Lord,
any
I will
decision.
take instruction and make submission, my lord, why
If it is difficult for the state to
Obliged.
drop that rules,
Obliged.
that's all.
That I
Then we
will,
will work out some other.
I will make
remedy.
submission, my lord, after getting instruction from the secretariat, my lord.
Yes.
My lord, a short date may be given, my lord. You would otherwise, my lord.
And when, mister? When will you take the
Lord,
instruction?
it may be taken next week, my lord.
Yes.
The problem is,
21st.
ಇಲ್ಲ, problem is that I will not be continued from Monday, my lord, because Vikas will be there, he will.
Yes, the 28th. Why you are there changing that? Who will come then?
ಅದು ನಮ್ದು ಟರ್ಮ್ ಮುಗ್ದೋಗ್ಬಿಡ್ತದೆ, ನಾವು ಮುಂದಿರೋ ಅದಕ್ಕೆ ನಾವು ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟು ಮತ್ತೆ ಹೇಳಾರ್ದಂಗ ಆಗ್ಬಾರ್ದು ಅಂತ.
No, that term is
2 years ಕಂಪ್ಲೀಟ್ ಆಗ.
complete. Other they will continue till that substitute is there. I don't think they will remove that. The process is that you ask Krishnappa, you will say.
1 year ಕಂಟಿನ್ಯೂ ಆಗ್ಬೋದು.
ಅದ್ ನೀವು ಆಮೇಲೆ retrospective effect ಅಲ್ಲಿ
ಆಮೇಲೆ
ಮಾಡ್ತಾರೆ.
ಮತ್ತೆ ನಾನು ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟೆ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ತಪ್ಪಾಗ್ಬಾರ್ದು.
Any other Vikas is also there. Yes.
Serial number 65.
59.
And you have to challenge, otherwise I have to follow. Whether you will challenge it, if you are not challenged, he is saying that it is covered. I can't do any other options.
They are not, so far they are not challenged.
Yes, we verify that he is not challenged. Then in that terms, we have to be disposed of.
Serial number 65.
Yes, leave this matter on 13th.
Serial
number 59,
So
my
far,
lord.
he has already been terminated, but tomorrow. Request for-
Tomorrow agala. 12th. Yes, 12th.
Alert, serial number 63, my lord.
65.
Short date,
Mallards, IPF for respondent Mallards. By next week, any date Mallards.
Next week, yes, 13th.
Serial number 59, my lord.
62 and 66.
Serial is correct. Serial, we'll call serial wise, yes.
Number 59, Ramamurthy.
Let's sign per petition. Anyway,
Number
What is that matter?
Mallards, with regarding to granted, Mallards, it's covered by judgment, Mallards.
Covered by decision.
Covered by judgment.
99, yes, 20th. Is it,
Ninth.
who is appearing? Notary covered by decision idava ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
19th May they have 20th.
19th.
Right.
20th. Yes.
20th minutes. 19th, sorry, I'm not in station 20th minutes. 19th.
21st. Yes, 21st. Yes. Correct.
Bill number 60, Ravindra VS.
60 is the consideration of representation, my lord.
None.
Society.
Yes, none appears.
My lords, for the respondent number 2 in this matter, my lords.
No, none is appearing for the petition. Is this matter? Next week, 2 weeks. Yes.
Bill number.
Consideration of representation made by the petitioner, madam.
For what?
Consequently, the amount, gratuity amount deducted by the respondent, madam.
Who has to answer? Who is? Huh? You are appearing for one. ಎಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಎಲ್ಲಿ ತೋರಿಸಿದ್ರು?
Dispense with ಆಗಿದೆ.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಕೊಡ್ರಿ?
Andhra Lord 5.
ಏನದು? ಅಂಡ್ರಾಲ್ ಅಂದ್ರೆ ಏನದು? ಏನಮ್ಮ? Yes, for R5. Who is R5? Executive Engineer, HLC, W. Tungabhadra, this thing. Yes, at the request of respondent number 5, week's time is granted to file objection. When do you want, Mr.? 23rd. Yes.
Bill number 65, Adjourn, 66, Muridhar.
I am for the petitioner.
Yado.
The promotions matter, 65.
65, somebody has taken time.
ಇಲ್ಲ, ಇವ್ರೇ.
Either 65.
The promotions matter, my lord.
Yes,
Candidature was not.
Yavati
Next week, Ali.
13th. Yes.
66, Muridhar KB.
66, my lord, it's a matter pertaining to regularization, my lord. But on the last occasion, I had made a submission document, 66. Matter pertaining to regularization, my lord. But on the last occasion, I had made a submission document, 66.
Number 3, my lord, CEO.
Respondent number 3.
Yes, my lord.
Devraj,
Please.
65.
Yes, my lord.
ಯಾವತ್ತು ಬೇಕು ನಿಮಗೆ?
14th or 15th, 14th, my lord.
14.
Or
67, my lord, so weeks of time may be.
I'm sorry, my lord, 66 when the date.
Yes, leave this matter on 21st. Yes. Will see, I have any meeting, otherwise I sit up to 5:30. Yes.
68, Adjourn, 69, Shilparani.
My lord, 69, my lord,
Yes.
for a week of time.
You are appearing for?
Respondent number 1 to
Yes. None
Yes.
appear for the petitioner.
R3, my lord.
Leave this matter on 3rd September.
70, yeah, KG Lakshmipati.
That matter. Yes. Yes, leave this matter on 13th. Yes.
71, Shivraj Patel.
This matter was already heard by the standard report. Physical and.
I'm appearing
Last time
for
one day.
I seek for 10 days, my lord.
Why?
10 days.
But additional document has to, additional statement objection has to file. Last occasion, my lord, is directed to file additional.
Hey, 2015, 10 years ಆದ್ಮೇಲೆ
10 days
additional.
ಅಷ್ಟೇ, 10 days, because I have to get the instruction from the
Monday, 18th
department.
Yes.
18th or 19th.
18th, yes.
Yes, much of.
Yes. All other hearing matters, date ಕೊಟ್ಬಿಡಿ first week.
My lord, serial number 73, my lord, final hearing matter.
39, my lord. I appear for the,
Given a date, huh?
I appear for the respondent, my lord. My lord, suspension matter, my lord.
Serial number 73, my lord, one request, my lord. Serial number 73 may be taken up with B group matters, my lord. It's 2017 matter.
Yes, 73, yes, we'll take it on 3rd, yes. Yes, we'll give the date.
74 ಯಾವತ್ತು ಬೇಕು ಸರ್ ಗೌರ್ಮೆಂಟ್?
73.
ಯಾವಾಗಾರ ಕೊಡಿ sir.
ಯಾವಾಗ
Serial number 73 B group ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಸಾಹೇಬ್ರೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್ 3rd ಸೆಪ್ಟೆಂಬರ್.
Sir, total, sir, 66 ಏನಾಯ್ತು sir date?
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ. 75 ಯಾರು? 3rd ಸೆಪ್ಟೆಂಬರ್ ನಂತರ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ತಗೊಳ್ಳಿ. 4th ಸೆಪ್ಟೆಂಬರ್ ಬಿಡಿ ಸರ್, ಬಿಡಿ.
73.
73 3rd September ಸಾಹೇಬ್ರೆ ಹೇಳಿದ್ರು. 8 ಸೆಪ್ಟೆಂಬರ್. ಆಯ್ತು 8 ಸೆಪ್ಟೆಂಬರ್.
Sir, 66, sir.
74 3rd September.
Sir, 63 date, Court of
60
63.
1st September.
Oh,
Sir, 66, sir.
66 28th August.
Much of it. Thank you, sir.
71 18th August. ಹೌದು ಸಾಹೇಬ್ರ ಡೈರೆಕ್ಷನ್ ಹಂಗೆ. ನಾಳೆಗೆ ಅಲ್ಲಿ ನೋಡ್ಬೇಕು ನಂಗೆ ಪಾಸ್ ಓವರ್ ಎಲ್ಲ ಕೇಳಿದೆ, ಆಮೇಲೆ ನೋಡಿ ನಾಳೆ ಕೊಡಿ ಅಂತ. ಈಗ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೆಲವೊಂದು ಕೊಟ್ಟಿಲ್ಲ, ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಒಂದ್ ನಿಮಿಷ ಇನ್ನೂ ಇದೆ ಬಿಡಿ ಸರ್. ಹೇಳಿದಾರೆ, ನೀವ್ ಯಾಕೆ ತಲೆ ಕೆಡ್ಸ, ನಾನು ಅವ್ರಿಗೆ ಹೇಳಲ್ಲ ನಿಮ್ಗೆ ಹೇಳಲ್ಲ, ನಿಮ್ ಲೀಸ್ಟ್ ಆಗತ್ತೆ. ಲೀಸ್ಟ್ ಆಗೋಗಿದ್ರೆ ಲೀಸ್ಟ್ ಅದು ಹೇಳಿ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಸಾಹೇಬ್ರಿಗೂ ಹೇಳಿದೆ, ನೋಡಿ ಟ್ರೈ ಮಾಡಿ. ಈಗ ಯಾಕಂದ್ರೆ ಇವ್ರು ಒಬ್ಬರು ಕೊಟ್ಟು ಪಾಪ ಅವ್ರು ಕೊಡ್ಬೇಕು, ಪಾಪ ಅವ್ರು ಹಂಗೆ ಮಾಡಿ.
Court officer, sir. Court officer, sir. Court officer, sir. ಸರ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 73 ಸಾಹೇಬ್ರು 3rd September ಅಂತ ಹೇಳಿದ್ರಲ್ಲ?
ಹೌದೌದು, 3rd September.
ಅದು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಿ ಗ್ರೂಪ್ ಅಂದ್ರ ಸರ್?
ಏನ್ ಸ್ಟೇಜ್ ಇದೆ ಆ ಸ್ಟೇಜ್ ಬರುತ್ತೆ.
ಓಕೆ ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಇದೆರಡು ನಂಬರ್ ನೋಟ್ ಲಿಸ್ಟ್ ಹೋದಾಗಿಲ್ಲ ತಾನೆ, ಇದೆರಡು ನಂಬರ್ ನೋಟ್ ಮಾಡ್ತಾರೆ. ಅದು ಕೇಳಕ್ ಆಗಿಲ್ಲ, ಮೀಟಿಂಗ್ ಕೊಟ್ಟೋದು ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಸರಿ. ಇದೆರಡು ನಂಬರ್ ನೋಟ್ ಮಾಡ್ತಾರೆ. ಹಾಕ್ಬೇಡ ಅರ್ಜೆಂಟಲ್ಲಿ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸಾಹೇಬ್ರು ಕೇಳಿ ಬರ್ಕೊ. ಈಗ 2 ನಂಬರ್ ಫಸ್ಟ್ 23822 25. ಇದು ಆಫೀಸ್ 3822 25. ಇದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಪೋಸ್ಟ್ ಮಾಡ್ತಾರೆ.
ಸರ್ 67 ರೀಚ್ ಆಯ್ತಾ? ಸರ್ ಏನೋ ಡೇಟ್ ಕೇಳಿದ್ರಲ್ಲ, ಯಾವ ಡೇಟ್ ಹೇಳಿ ಸರ್? ನಮ್ದು 21 ಸ್ವಲ್ಪ ಟೈಟ್ ಇದೆ, 22 ಆಗ್ತದೆ. ಇನ್ನೊಂದು
ಅದೆರಡು ಬೇಡ, ಏನ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಟ್ಟು ಅದು ಬೇಡ. ನಾನೇನ್ ಹೇಳಿದ್ರು ಎಷ್ಟಾಗ್ತದೆ ಅಡಿಷನಲ್ ಏನಾದ್ರು ಸೇರಿಸಿದ್ಯಾ ಅಥವಾ ಇಲ್ವಾ? ಅಲ್ಲಪ್ಪ, ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಎಷ್ಟು ಹೇಳ್ಬೇಕು. ಯಾವ್ದು ಸೇರಿಸಿಲ್ಲ ಅಂತ ಬೆಳಿಗ್ಗೆ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ವಿತೌಟ್ ನಮ್ಮ ಸೇರಿಸಿದ್ಯಾ, ಬೇರೆ ಯಾವ ಸ್ಟೇಜನ್ನು ಸೇರಿಸಿಲ್ಲ. ಸರಿ ಗಿರೀಶ್,